We have a full house this morning. I'd like to welcome you to the second day of our spring 2026 oral argument session here in Philadelphia. As you may know, because I say it all the time, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and the Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In May of 2022, we celebrated our 300th anniversary with a special session in Old City Hall here in Philadelphia. We on this bench are very proud of our rich history. In 1996, 274 years after the establishment of our Supreme Court, Madam Justice Sandra Schultz Newman became the first woman ever elected to our Supreme Court. On September 9th, 2025, we gathered in this courtroom to bestow a very special and well-deserved honor upon Madam Justice Newman by renaming this historic courtroom the Madam Justice Sandra Schultz Newman Supreme Court Courtroom. Justice Newman passed away on February 2nd, last month, at the age of 87. Justice Newman was an inspiration to me and to countless other women in the judiciary and in the legal profession. May her memory be a blessing. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with the cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases in which there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel because we only want to hear them once. Please do not interrupt the justices when they are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we wish to explore further. I remind you that we do not allow rebuttal. Finally, while we have no set time limit for argument in our court, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case. This is a direct appeal arising out of a suit filed by the District Attorney of Philadelphia County and the District Attorney of Allegheny County under Pennsylvania's Unfair Trade Practices and Consumer Protection Law against pharmaceutical companies who sold opioid painkillers to Pennsylvanians and spawned a public health crisis. Yet, after reaching a separate statewide agreement with these pharmaceutical companies, the Attorney General of Pennsylvania sought to enforce that settlement agreement by discontinuing the district attorney's cases. The district attorneys objected, but the Commonwealth Court granted the Attorney General's request. The question for our court is whether the Attorney General, as the Chief Law Enforcement Officer of the Commonwealth, had the constitutional and statutory authority to settle the consumer protection lawsuits brought by the district attorneys. Good morning.
Good morning. Honorable Justices of the Pennsylvania Supreme Court, I am Larry McMichael, I represent District Attorney of Allegheny County, Stephen Zappala. Chief Justice Todd, you've explained the issue precisely. I will not repeat what you said. That is exactly the issue. And the answer to the question is no. I will demonstrate why the answer is no under the Constitution and under the Commonwealth Attorneys Act. My colleague, Catherine Dorsey, who represents District Attorney Larry Krasner, Philadelphia County, will discuss the issue under the Unfair Trade Practices Law and Consumer Protection Law. And also we'll reference the Commonwealth Court's decision below. The beginning of your analysis has to be the statute that grants co-equal authority to the Attorney General on the one hand and to the elected district attorneys on the other hand to bring civil cases to recover civil penalties for violations of that law, the law being the Consumer Protection Law. So this is a case where the district attorneys have sought to recover civil penalties on behalf of their electorates. The Pennsylvania Attorney General purported to supersede them. The question of supersession has been addressed both in a statute and by this court on multiple occasions. So let's start with the statute. In 1978, a couple of things happened. One is Pennsylvania adopted a new constitution. Constitution provided in Article 4 that the now elected Attorney General, prior to 1978, the Attorney General was an appointed position, but 1978, we are now an elected Attorney General. The Constitution says that the Attorney General shall have such powers, quote, as may be imposed by law, as may be imposed by law. That's the Constitution. What does that mean? Well, in order to understand what the Constitution means, we have to take a step back to a little bit earlier in 1978. It was an important year, also the year I graduated from law school, but that has little to do with this case. In 1978, in January, this court decided a case about the power of the Attorney General to supersede a district attorney. Cases, Commonwealth versus Schaub. Schaub was a case where a Philadelphia police officer shot a patron of a restaurant. There was an investigation. The district attorney decided not to prosecute. The Attorney General superseded and decided to prosecute, relying on a line of cases that gave the Attorney General that power as a matter of common law. This court dissected that issue in the Schaub opinion. It's important to understand what the court did and why it did it. The court said, first of all, there is no common law with respect to the relationship between the Attorney General and the district attorneys. There is no common law. Why is there no common law? Because elected district attorneys were not known to the common law. They didn't exist in common law. The Attorney General had deputies, and of course he could supersede his deputies because his deputies worked for him. But he couldn't supersede an independent elected official. So the Constitution is adopted right after that, after this court has decided that there is no common law right of the Attorney General to supersede a district attorney. The legislature responded to the enactment of the Constitution 18 months later by passing the Commonwealth Attorneys Act. Okay, the Commonwealth Attorneys Act lays out who has what power. And it addressed the Schaub issue. The Commonwealth Attorneys Act changed Schaub. Section 205A4 of the Commonwealth Attorneys Act gives the Attorney General the power to supersede an elected district attorney in a criminal case on petition to the court. In other words, there's judicial supervision. There's no unilateral power to supersede. There's judicial supervision under the statute in criminal cases. But what about civil cases? Well, there's a separate section of the Commonwealth Attorneys Act that deals with the Attorney General's power in civil cases. That's Section 204. And if you look at 204C, what you see is there is a power to intervene in a case affecting the Commonwealth, but there is no power to supersede. So the statute is 100% clear. The Attorney General has a power to supersede in criminal cases. He does not have a power to supersede in civil cases. It's nowhere there.
Counsel, can I explore over here. This way.
I'm sorry.
That's okay.
Sorry, Chief Justice Rouse.
I'm over in the corner. I want to talk about this concept of supersession because that's how this case is being presented as a question of supersession. But the supersession cases that I've seen and that you're referencing deal with a situation where the Attorney General is stepping in for the prosecutor in their case. So it's a criminal prosecution, and the Attorney General says, "Move aside, District Attorney, I'm going to prosecute the case." That's not what we're dealing with here. We're dealing with separate lawsuits. The lawsuit that's happening by the Philadelphia and Allegheny County District Attorneys and the Common Pleas Court, and a separate action that was commenced by the Attorney General. Why is that supersession in the sense that we have historically understood it?
It is supersession because the Attorney General is exercising the power to replace the judgment of an elected district attorney who is responsible for
They're not replacing the district attorney. Like, for example, what is the status of the civil suit brought by the Allegheny County District Attorney and the Philadelphia District Attorney?
Well, if I were up to the Attorney General, the civil suits will be over.
No, but what's the status of them now? They're not over, are they?
They're still pending.
Right. So the Attorney General has not stepped in and superseded you can still proceed with those lawsuits.
No, that's not the position of the Attorney General.
I'm not asking the position of Attorney General. What is stopping you right now from proceeding with those lawsuits?
The Commonwealth Court has ruled that we cannot.
They've said that you cannot move forward?
Correct. Because the Attorney General superseded the elected district attorney.
Well, but see, this is why I'm struggling with the supersession thing. And maybe, again, maybe I should look at it in the prism that you all are looking at it, but this is the way I look at it. You would agree that the Attorney General has the authority to bring an action under the Unfair Trade Practices and Consumer Protection Law, correct?
Correct.
And they have the authority to sue defendants on behalf of the entire Commonwealth of Pennsylvania, including Philadelphia and Allegheny County.
The Attorney General has that power, yes, sir.
And if they do bring that suit, they have the authority to settle that suit, right?
They do.
Okay. So with all that authority, it seems to me that the question simply is that settlement enforceable in your Common Pleas Court actions?
Well, that is a question that my colleague, Ms. Dorsey, will address.
Right, I understand, but that's not supersession. That's a matter of contract law. That's a matter of, is a settlement enforceable? And what I would have expected to see instead of an original jurisdiction Commonwealth Court declaratory judgment action would have been the pharmaceutical companies coming into, is it Delaware County? Is that where the coordination is happening?
Yes, Your Honor.
Come into Delaware County and say, motion to dismiss, we want to enforce this settlement agreement, and then you would litigate in Delaware County the contractual enforceability of the settlement agreement.
One could have done it that way. That's not what happened here, but...
What avoids the issue of supersession. Then it becomes a simple matter of, is the settlement agreement enforceable?
No, it's a little bit more than that. It's a little bit more than that. It's whether the district attorney's lawsuit can be settled by the Attorney General.
No, well, that's where I'm trying to press you on, and I understand that that's the rubric in which you want to present the case. I'm just wondering, whether this supersession thing is just the wrong path to go down, and the question really is not whether the Attorney General can settle your case, but whether the Attorney General's settlement can be enforced in your case as a matter of contract law.
I understand the point you're making, and I think that in the light of the Commonwealth Court's decision, that's not what we're here to decide, though. I mean, that's not what happened, and maybe that's what should have happened, but it isn't. And when one party settles a case, generally speaking, it does not, in fact, affect the rights of another party pursuing the same or similar case. There may be issues of double recovery. The lower courts sort that out all the time in tort cases where there are multiple plaintiffs.
I'm just wondering whether all of it should have been sorted out in Delaware County and not in the Commonwealth Court.
Your Honor, that may have been a better course of action, but it's not what happened. And that's why we're here. I mean, fundamentally what happened is the Attorney General attempted to settle cases brought by district attorneys. That is supersession. He is superseding the district attorney's rights to prosecute those same cases. And if I can get back to the point I want to make, that this court has actually addressed this issue, and it's addressed it in broad terms. And I think if you just stick with the basic law that has been well established in this Commonwealth, you get to the right answer here. So after the enactment of the Commonwealth Attorneys Act. After the enactment of that act, this court was presented with a case called Garcia. Garcia was a case where a lawyer was trying to bribe a cop for, changing his testimony or something, and the lawyer was indicted. And the Attorney General attempted to prosecute that case because the local district attorney wasn't doing it. And this court said, and this is very important, this court said in Garcia that the Attorney General does not possess any inherent additional powers not set forth in the Commonwealth Attorneys Act.
Counsel, can I interrupt? I hate to get you off the path that you're intent on going down, but I want to follow up on Justice Robson's line of questioning. It's clear the Commonwealth Court looked at this as the Attorney General's right to supersede.
Yes.
It's clear in the briefing in this case that the AG is taking the position that they have a right, somewhat, of supersession. Am I correct?
Yes, Your Honor.
Okay, so the AG never attempted to supersede in this case. The AG decided to ignore the actions that were pending in Delaware County, file lawsuits solely for the purpose of effectuating a settlement in the Commonwealth Court. Correct?
Right.
Okay. Now, when the AG took that route, did the district attorneys have an opportunity in any way to participate in that action that was pending in the Commonwealth Court?
I'm not sure I understand what you mean by an opportunity. We were not parties to it. We were not served with any.
Attempt to intervene?
The district attorneys did not attempt to intervene.
Okay, so I tend to, there was no attempted supersession here. If there were an attempted supersession, it would have had to have taken place in Delaware County. That just didn't happen. And so, the way this case has gone on has, I don't know, maybe flows from the fact that the Attorney General in the release and the other papers that were filed in this case took the position that they had the right to control and settle any other actions that were pending.
Your Honor, that's exactly correct.
Now, that sounds like supersession.
It is supersession.
Without taking any steps to supersede other than saying, I have the right to supersede, or I have the right to take over and settle these cases. Am I on the right track here, how we got to the notion that there was supersession here?
Which is why I'm arguing supersession, because in fact, that's what happened. Okay, I mean, maybe as Justice Robson pointed out, maybe that shouldn't have happened. Maybe there should have been a different procedure. But what happened was the Attorney General said, I'm settling your case. And we challenged that. And we lost it.
And if I understand your position, is if they don't have a right to supersede, they certainly don't have a right to settle.
That is correct. That is correct.
Isn't the right to settle really vested in the client? So my question is, because I see this a little differently than Justice Donovan and Justice Robson, but in my view, it seems to me that if the Allegheny County decided that they wanted to settle the case, they're the master of the ship. And so why do the VAs have a right to proceed when the County of Allegheny has agreed to settle?
Okay, so that is a question that will be addressed by my colleague, but I will answer your question because under the law, the Unfair Trade Practices and Consumer Protection Law, there are co-equal rights to bring civil actions to collect civil penalties. Okay, both the Attorney General and the districts have those rights. The counties do not have those rights. That is not a right invested in the county. The county can bring a private claim, but that's different. This is a civil penalty claim. Counties can't bring that claim. And what happened was the Attorney General superseded us and said, I can do this and I'm going to settle it, you're done. And that's why we're here. So let me just get back to Garcia for a minute, because there's some important language that I think the court needs to understand. It's language that comes right from this court. Garcia said, when talking about Article 4 of the Pennsylvania Constitution, Garcia said, the use of the language, quote, as may be imposed, clearly shows an extension of power to the legislature to statutorily define and regulate the powers of the Attorney General. There is no more bed of common law precepts The Attorney General's powers, and this is important, this is what this court said, the Attorney General's powers are strictly a matter of legislative designation and enumeration. Strictly a matter of legislative designation and enumeration. So if this court looks at your precedent and looks at the Commonwealth Attorneys Act, you simply look at the act and say, okay, where in this act did it give the Attorney General the right to do what he did in this case? It's not there. It isn't there. So there's one more case that you should consider here, and I'll wrap up. And that is a decision by Madam Chief Justice Todd in 2011. This is the latest pronouncement of this court on the subject of the Attorney General's powers. Okay, this is about power and about what power the Attorney General has under the Constitution and under the statute that grants powers to him. In Briggs, Commonwealth versus Briggs, this court said, it is now firmly established in this Commonwealth that the powers of the Attorney General are strictly limited and solely a matter of legislative designation and enumeration. Solely a matter of legislative designation and enumeration. So Briggs reemphasized Garcia, and it stands for the proposition that has been the law in this Commonwealth for 20 plus years now, that the power of the elected Attorney General emanates from the legislature, and if it's not in a statute, he doesn't have the power to do what he's trying to do. If you look at the statute, there's only one statute to look at, Section 204C. That tells you what the powers of the Attorney General are in civil cases. There is nothing in there that says anything about supersession. It doesn't say anything about settling cases that are brought by the district attorneys. It's simply not there. And therefore, the power doesn't exist. And the case should end there. So for that reason, and for the reasons that my colleague will now explain, the decision of the Commonwealth Court should be reversed.
Are there questions for Mr. McMichael? It's highly unusual. Thank you.
I take it as a compliment. Thank you, Your Honors.
Let's hear from Ms. Dorsey.
Good morning, Your Honors. May it please the Court. Catherine Dorsey from Barron & Budd, PC, on behalf of District Attorney Krasner. I first want to address the questions that have been posed by the Court about whether the framing of this case is right in terms of a power of supersession or a power to settle the case. And I think it's a distinction without a difference, Your Honors. I mean, it was briefed to the courts below in terms of a supersession power, but that was in terms of encompassing the power to settle or release the district attorney's case. And at the time after the settlement agreements were reached, the district attorneys brought a declaratory judgment action in the Commonwealth Court to make sure, to clarify that the Attorney General could not settle their claims that were brought in the Court of Common Pleas. And the Commonwealth Court originally held that that challenge was not ripe, and then we waited until the consent decrees were entered after the settlement agreements, and then the district attorneys again brought suit and challenged the Attorney General's power to release or settle their actions.
So did just the matter of the settlement agreements, these are not Pennsylvania-specific settlement agreements. These are national settlement agreements, right?
That is correct, Your Honor. All the consent decrees were entered in Pennsylvania.
Right. Do any of the documents specifically reference the Delaware County litigation by Philadelphia District Attorney Krasner and Allegheny County District Attorney Aplt?
No, although there are side agreements that were entered into by the Attorney General and the district attorneys, which I believe were attached to those consent.
But you don't have any side agreements with your client did not have a side agreement, right?
Our clients had no agreements with the Attorney General.
Right.
No, they had their cases and they intended to proceed with them.
Right, but the reason why I was raising the question, and maybe the simple answer is there's two ways to skin the cat, but my concern about supersession is you get into a power dynamic and you get into a constitutional issue, and we try to avoid constitutional questions if we can. Why isn't this just a question of capacity and contract interpretation, because it seems to me that everybody agrees that the Attorney General can bring a claim under the Unfair Trade Practices and Consumer Protection Law. I don't see anybody arguing that the Attorney General and the District Attorney can't both bring claims at the same time. You're not arguing that.
We are not arguing that, Your Honor.
So we know the Attorney General can bring a claim. We know the Attorney General can settle a claim on behalf of the Commonwealth. So I guess the question simply is that settlement enforceable in the Delaware County litigation?
I'd like to take issue with one thing Your Honor just said, that Attorney General can bring a claim and he can settle his claim. The District Attorney can also bring a claim and the District Attorney can settle his own claim.
Well, but that goes to capacity, and that goes to the framing of your question, because you talk about them as if they own the claims. The claims belong to the Commonwealth. The claims don't belong to the law firms.
They don't belong to the law firms, but I think and this might be a good time to transition into the discussion of the statute.
I want to do that, but I just want you to understand why I'm thinking about this capacity thing, is because if the statute gives the authority to sue on behalf of the same defendants to two different law firms, and then it really becomes a question of the enforceability of the settlement agreement, and that's a matter of contract.
I think the issue here, Your Honor, is that two plaintiffs are given the authority to bring a suit.
The DA is not named. The DA is not a plaintiff. The Commonwealth is a plaintiff.
I disagree, Your Honor. The statute gives both a district attorney and the attorney general standing to bring a claim as a plaintiff in the name of the Commonwealth.
Well, in the name of the Commonwealth, that's the plaintiff. In the name of the Commonwealth means the Commonwealth is the plaintiff.
I don't think that's correct, Your Honor. There are numerous statutes in this state which provide that in the name of the Commonwealth is different from a suit by the Commonwealth or when the Commonwealth is a party.
Okay, let's talk about that then. I'm interested in that.
We cite these statutes, I believe, at page 28 of our brief, but for one example, 16 Pennsylvania statutes, section 14302, that distinguishes between in the name of the Commonwealth or if the Commonwealth is a party. And there's another statute, 63 Pennsylvania statute 1604C, which authorizes an insured to bring suit in the name of the Commonwealth if no suit should be brought by the Commonwealth of Pennsylvania. There are numerous statutes.
Well, that's different. That's because like the Attorney General, those are basically allowing private parties to step into the shoes in the name of the Commonwealth.
Correct, which is similar to the district attorney.
They're not private, though. The district attorney is a law firm. The DA's office is an elected law firm. The Attorney General is an elected law firm.
And similar,
representing the Commonwealth.
And no, the district attorney is not permitted under Commonwealth law to represent the Commonwealth. That is under the Commonwealth Attorneys Act. Only the Attorney General shall represent the Commonwealth in all civil cases. The district attorneys are not authorized to represent the Commonwealth. When they bring a CPL action, it is in their name as the plaintiff, in the name of the Commonwealth.
Counsel, can I follow up on this? When I look at the Unfair Trade Practices Act language, I read it to say that the district attorney can bring an action in the name of the Commonwealth, but so can the Attorney General. Obviously, the jurisdictional limitations on the district attorneys in every county would limit their ability to state a claim only for those claims that arise in their jurisdiction.
That's correct.
And that's what they did in Philadelphia County. I'm going to refer to Delaware County, but that was just the consolidation point. That's what happened. Each of the district attorneys who brought claims under the Unfair Trade Practices Act brought it in the name of the Commonwealth on behalf of those individuals that it could represent within its jurisdiction. Am I correct?
Yes, you are correct.
I mean, I don't actually see the statute doing anything other than that. Along those same lines, the Attorney General can certainly settle any claims. What they can't do under your theory is settle and discontinue actual lawsuits that have been brought. I mean, there are many counties, district attorneys who didn't bring lawsuits. And so they had claims. They had claims, and it may be that the counties also had claims. We're not interested in that now, but to the extent that there was no legal action filed, the Attorney General had the right, you would agree, to settle those claims that had not been filed by district attorneys.
Our position, Your Honor, is if there were no filed claims by district attorneys, then the issue of releasing those claims is not before this court.
Right, but isn't that why I wouldn't have gone down the path that the Commonwealth Court went in this case, but I think I understand how they fell onto this supersession paradigm that they were arguing. It's not a question if claims can be settled. Any claims could be settled. The question becomes, can they be settled when there have actually been lawsuits filed? That would require supersession, I think, was the Commonwealth Court's analysis of this.
I think that's a fair analysis, or summary, Your Honor. If I could turn to specifically the CPL statute here to address that and why we think it's unambiguous here that the Attorney General did not have authority to release the district attorney's public enforcement actions. There are two relevant provisions in the CPL. Section 4, which gives concurrent and equal authority to the Attorney General and the district attorneys to serve as plaintiffs in public enforcement actions. And then Section 8, which provides that if the court finds a violation of the statute, the Attorney General or the appropriate district attorney acting in the name of the Commonwealth of Pennsylvania may recover on behalf of the Commonwealth of Pennsylvania a civil penalty. Section 8, therefore, of the statute plainly contemplates that either plaintiff, either the Attorney General or the district attorney, has authority to prosecute to completion a public enforcement action he has brought and recover civil penalties. And just to be clear, the public action we're talking about that the district attorneys brought is completely separate from the private actions for damages that can be brought under Section 9.2 of the statute, which is what Philadelphia and Allegheny counties had claims that they brought here under that private section.
Repeat that. Pardon me. Could you say that last part again?
So Allegheny and Philadelphia, Allegheny County and Philadelphia both brought private claims for damages under Section 9.2 of the CPL, which they opted into the settlement agreement and released those claims. But those are different than the claims brought here by the district attorneys, which are public enforcement actions. And the Philadelphia and Allegheny County do not have such claims because only the Attorney General or district attorney can bring public enforcement claims under Section 4.
So, counsel, what's the principle then? Let's say the facts were different, and the Attorney General brought an action only on behalf of the Commonwealth for the people of Philadelphia, and then the district attorney says, "Whoa, I'm not going to let that happen. I'm going to bring my own action on behalf of the people of Philadelphia." Is that allowed?
So the statute seems to allow him to bring that suit,
Okay.
but of course there would be principles of, double recovery, that you couldn't recover twice against the same defendant for the same conduct.
But they could both go down the road at the exact same time and reach. How would they be resolved?
Again, that issue is not before this court because that's a different question, and there are questions the statute says, the Attorney General or a district attorney. We've certainly never taken the position that means you can only have one action because, for instance, there could
It's not the issue here, but we look at cases, not just because of the issue here, we look at cases, if we're going to adopt your principle, then we have to look at how that might impact other cases. And if your principle relies on the idea that, oh no, you can have separate independent actions, independent recoveries, and by the way, if there are two actions, then the only way the case gets settled is if both the Attorney General and the District Attorney happen to agree that the settlement is appropriate. What if they don't?
Well, for instance, when a district attorney brings an action first and the Attorney General is interested, he has a right to statutorily intervene in that
I gave you a
action.
different fact pattern.
Yes.
I said if the Attorney General brings an action first and the District Attorney says,
Yes.
I don't like the Attorney General. I don't believe that they're going to do what I want them to do. I'm now going to bring a duplicative action, and I'm going to be more aggressive or less aggressive. How do we deal with that?
That is an issue, again, I don't think the court needs to decide, but
How does your theory, if we rule the way you want us to rule, impact that scenario?
I don't think it does, because that situation does not involve where the Attorney General is releasing the district attorney's claims. And I think in most of the...
But it's the same claim. It's an identical claim for the same thing, for the same Commonwealth. You have to accept the facts I'm giving you. How does your view in this case impact that possible future scenario?
I think in that future scenario, the likelihood would be that the Court of Common Pleas would need to sort that out like any multi-plaintiff case. But in general, double recoveries would probably prevent the district attorney's case in that suit. But again...
So they couldn't settle?
Sure they could. They could settle.
As long as the DA and the Attorney General agreed on the settlement.
I think that's right, but the point is that the Attorney General can't come in and decide, as in this case, after the DAs have been litigating the case for a long time, without any process, that he's just going to settle their claims. And that's a different case than the hypothetical, Your Honors.
No, well, you're saying their claims is based on the exact same claims on behalf of the exact same Commonwealth, but what makes them different is who the law firm is.
Well, but Your Honor, you can't get, again, in that case, it's the principles of double recovery. I think that would prevent a double recovery again.
I'm not talking about double recovery. I understand. They could go to trial, both. I mean, you could have two different trials, but they'd probably get consolidated. The Attorney General will argue for $100 million in damages, and the district attorney may argue for $200 million in damages. The jury is going to reach whatever the jury is going to reach. But I'm talking about settling. That your factual scenario would essentially preclude the settlement of those claims because unless the DA and the Attorney General would agree.
Well, if they're joined together, they will, if those two cases are joined together, which would be a natural thing to do, then they can work out settlement together, as would be an appropriate thing for the court in that case to work out. But again, I think these are downstream issues that would be resolved by the trial court, resolving that when you have everybody together resolving it, instead of here, as the Attorney General kind of went around those procedures, even though he could have intervened in the district attorney's action and just declared that their actions were settled.
Counsel, if I could just follow up on Justice Brobson's question. In his hypothetical, you wouldn't have the issue that is sort of embedded in the problem that we're addressing here. In that case where both the AG and the DA bring an action, each brings an action in the same county, in the same courtroom, and the cases are consolidated and the cases are tried, there wouldn't be a question as to how damages would have to be allocated. There would be one determination in that context based upon a jury verdict or agreed upon settlement after discovery, et cetera, as to what the damages are in that case brought in that county.
Yes, I agree.
That's not what we have here.
That's
what the problem is.
Yes, Your Honor, I agree. There is no language in the text of the CPL governing public enforcement actions that could be read to mean the Attorney General here has any power to supersede a district attorney's public enforcement action, including a power to release the DA's action. Again, the Section 8 language says that the appropriate DA may recover civil penalties, That language is not qualified or limited in any way and does not make the district attorney's authority to prosecute or recover penalties dependent on the Attorney General. In other words, there are two potential plaintiffs here, the Attorney General or the district attorney, who can bring a public enforcement action for civil penalties. Because the statute does not confer authority on either plaintiff over the other plaintiff, each plaintiff can control only his own action consistent with the general rules of litigation. The statute cannot reasonably be read another way and is therefore unambiguous. Aplts, in fact, do not offer an alternative reading of the statute. Instead, they suggest that because the statute is silent as to what happens when both the Attorney General and a district attorney bring actions, that makes the statute ambiguous. But that is a gap, not an ambiguity, and it is well established that this court does not fill statutory gaps.
Counsel, earlier we had a discussion about whether or not this is truly the AG superseding, whether supersession is the correct concept. Isn't it possible that that analysis really doesn't matter at all? It's a de facto supersession if it's not an actual supersession, and does that really influence our analysis at all?
I don't think it does, Your Honor. I think it's the same analysis whether you call it a supersession or a power to release someone else's claim. Again, it's a power that's not in the statute, that is not given to the district attorney here, and I think you can frame it as narrowly or as broadly as you like, and it would still get to the same result.
Thank you.
And so because the CPL unambiguously does not authorize the Attorney General to release a district attorney's claim, the Attorney General lacked authority to do so here unless he can point to other authority outside the statute. As Mr. McMichael has already explained, there is no other authority in the Commonwealth that gives the Attorney General that authority. I'd like to focus on how the Commonwealth Court also got its analysis wrong in determining that the statute was ambiguous. And I'd like to focus on 4 critical legal errors. First is the one we've kind of touched on already, which is that the Commonwealth implicitly held that because every public CPL action must be brought in the name of the Commonwealth, that is an action by the Commonwealth, even if it is brought by a district attorney. That is wrong. As we've discussed, in the name of the Commonwealth is not the same as by the Commonwealth or on behalf of the Commonwealth. Those are distinct terms used differently in the CPL and other Commonwealth statutes, and the courts are required to give them distinct meanings. They are not interchangeable. Indeed, if the Commonwealth were the party plaintiff in every public CPL action, as the Commonwealth Court held, then the Attorney General would be required to take over the action pursuant to his duty in the Commonwealth Attorneys Act, that he represents the Commonwealth in all actions brought by or against the Commonwealth.
Well, the Unfair Trade Practices Consumer Protection Law is a specific statute, so the specific would override the general.
I'm sorry, I missed the last.
The Unfair Trade Practices and Consumer Protection Law is a specific statute.
Yes.
The Commonwealth Attorneys Act is a general statute. The specific would override the general.
I agree, Your Honor.
Okay.
Just to be clear, let me ask what you're agreeing with. Because Justice Brobson is...
I can't win.
Wait, Your Honor.
I was on my toes. What exactly are you agreeing with? Because he's suggesting that the Unfair Trade Practices Act specifically gives the Attorney General to bring this action.
I'm agreeing that the specific controls the general, and the CPL action here gives both the Attorney General and the district attorney a right to bring an action in the name of the Commonwealth.
Period.
That's what I'm agreeing to.
Okay.
If it was held that every action brought in the name of the Commonwealth is in fact brought by the Commonwealth, is an action for the Commonwealth, that would effectively eviscerate the district attorney's authority to bring these actions. Either the they'd only have a right to bring the action, and then they'd essentially have to turn the prosecution or the litigation of the action over to the Attorney General. And here, in fact, the Attorney General never sought to take over the district attorney's actions, suggesting that even he does not believe that a suit in the name of the Commonwealth means that it is brought by the Commonwealth. Instead, the Attorney General recognized that the district attorneys have a right to, under the statute, to bring a public enforcement claim for penalties, which is why he tried to persuade all 67 district attorneys to join the settlement agreement and release their claims. There would have been no need to do so if the district attorney's claims were, in fact, the Commonwealth's claims and could be released by the Attorney General. The second error in the Commonwealth Court's opinion was that it understood every public action, CPL action, to be a suit by the Commonwealth. And because of that, it found there was a conflict in representation whenever both a district attorney and the Attorney General bring public enforcement actions. But such a conflict in representation is statutorily precluded. As we've discussed, the Commonwealth Attorneys Act, Section 204C, requires the Attorney General to represent the Commonwealth in any civil action brought by or against the Commonwealth. The district attorneys do not have authority to represent the Commonwealth. So the Commonwealth Court's contrary interpretation actually creates a conflict with the Commonwealth Attorneys Act. Third, the Commonwealth Court also erred in determining the legislative intent behind the statute. Even if the statute were ambiguous such that it was appropriate to look to legislative intent, the court made two errors. First, it held that the Commonwealth Court held that the General Assembly must have intended to incorporate the Attorney General's common law powers, which at the time the CPL was enacted were understood to include a power to supersede a district attorney. But this court in Schaub overruled those cases and explained that the Attorney General never had a common law power to supersede a DA. And because the Attorney General never had such a power, it is not reasonable to assume that the General Assembly would have intended to incorporate such a non-existent power. But even if that were right, as the court has to interpret the CPL in pari materia with the Commonwealth's Constitution and the Commonwealth Attorneys Act, which Aplts agree on that. And the Constitution and the Commonwealth Attorneys Act and this court's cases interpreting them, Garcia and Briggs, make clear that after 1978, the Attorney General has no common law powers unless codified by statute. Going forward, therefore, those provisions prohibit courts from inferring powers for the Attorney General that are not statutorily enumerated. And in other words, because the CPL has been interpreted in the context of other authorities, it has to be interpreted in the context of other authorities, including later enacted authorities. It was error for the Commonwealth Court to turn solely on what the General Assembly may have intended in 1968, rather than making sense of all the law. Finally, I'd like to focus on the Commonwealth Court's decision, its misunderstanding that there was no reason to let the DA's actions proceed because there was nothing left for the district attorneys to recover. That is wrong on several fronts. The court found because Philadelphia and Allegheny County signed on to the settlement agreements and released their claims, that the district attorney's claims were also released. But Philadelphia and Allegheny County released their private claims under Section 9.2 of the CPL. They cannot bring public enforcement actions under Section 4 and therefore could not release such claims.
So who is the money for? What's the DA's doing? What's the purpose?
If the DA's actions seek civil penalties, that would then be used for their electorates. And for those their constituents who, yes, the people in those counties. But again, what the Philadelphia and Allegheny County, their claims that they released were claims for damages. And these are civil penalties claims.
What if Allegheny County said to the district attorney in Pittsburgh,
we don't want you to file this civil penalty claim. We have no interest in it. We don't want you to do it. Would they be bound by that?
I don't think so, Your Honor, because the CPL gives the district attorneys a right to bring those civil penalty claims.
Okay, and I
So-
guess then likewise, if Allegheny County said, we want you to settle this claim along the lines with the Attorney General, they wouldn't be bound by what the County of Allegheny wanted
That's
how
correct,
the
Your Honor.
litigation to be handled.
And in fact, that's illustrated by what happened here. The Attorney General himself recognized that the counties and the district attorneys are distinct entities with distinct claims because he separately negotiated with both the counties to sign on to the agreement and the district attorneys separately. And for those counties and district attorneys who opted into the settlement agreements, they received separate payments, one to the district attorney and one to the respective county. And those were separate amounts of money under the settlement agreement.
There's a number of different public interest laws across the Commonwealth where an attorney may bring an action on behalf of a client, and if the attorney is successful, they themselves receive maybe payment of fines or payment of costs and fees. But I'm just having a hard time wrapping my mind around the concept that the client doesn't control the litigation, that the attorney gets to make the decisions in the litigation.
I think here, Your Honor, it's a little different because the client and the attorney and the plaintiff are all wrapped up in the same individual. And the district attorneys are suing in their official capacity on behalf of their electorate for the best interests of them. And so I don't think it's, yes, settlement is usually, sure, has to be approved by the client, but there's no way to really do that when it's a claim on behalf of the electorate or your jurisdiction. And I think the CPL in authorizing district attorneys to recover civil penalties envisions that, Your Honor. So this is in line with exactly what the statute envisions. About Section 8 of the statute, yes. Secondly, on the Commonwealth Court's rationale that there was nothing left here for the district attorneys to recover, that was also wrong because the settlement agreements here are not a bar to the district attorney's recovery of civil penalties if their actions proceed. The settlement agreements expressly disclaimed that any of the settlement money was for the payment of fines or penalties. And so defendants have not paid any civil penalties or funds in settlement of civil penalties. So if the district attorney's actions were to proceed, there is no risk of double recovery against defendants for civil penalties. And finally, on the point of the nothing left to recover, the district attorneys also believe that the money recovered under the district attorney's actions will directly benefit their electorates because of the 2021 Fiscal Code Amendment, which provides that the money recovered by the district attorneys goes to the district attorneys, not to the Commonwealth's opioid restricted account.
Could you clarify something for me? In the settlement agreements that the AG entered into, were civil fines and penalties expressly excluded and regarded as resolved?
No. The releases were to the maximum extent of the Attorney General's authority, but the settlement agreement explicitly excludes any recovery for fines and penalties and says no portion of the compensatory restitution amount constitutes disgorgement or is properly characterized as the payment of statutory or other fines, penalties, punitive damages, or other punitive assessments.
So in your analysis, that issue was still wide open even after the settlement?
That's correct, because they explicitly excluded that no money was paid for fines and penalties. So that leaves that open for that money to be recovered in a CPL action.
Counsel, the AG, in filing their complaint in pursuit of a settlement order being signed by the court, their complaint includes, two complaints, include counts for nuisance. They have civil nuisance claims in which they claim very broad damages. Did the district attorneys bring nuisance claims?
No, they only brought, it was a single count complaint for both of them under the
That's
CPL.
why I just wonder, it's very difficult to know what the settlement amounts were paid for. The nuisance claims have extremely broad claims for damages involved with them. And, so it's really sort of unclear. I mean, obviously both of those complaints and each of those counts had to be settled in the context of this agreement. So how do we know what damages were allocated to the nuisance claims?
Well, I think here, Your Honor, I'm not sure that's clear, but I don't think the court has to reach that for here because, again...
But it raises the issue of, what claims actually, what monies were paid for, in keeping with your, pointing out that there are specific exclusions of certain types of damages that weren't included.
Well, and just to be clear, Your Honor, we don't think this court needs to reach that issue
I
now.
agree with you.
That's an issue downstream
I
for
couldn't agree with you more.
if the district attorney's actions proceed, then that would obviously have to be sorted out. But we think here it's crystal clear from the exclusion that the language did not include fines or civil penalties such that a CPL action could proceed.
All right, any other questions for Ms. Dorsey? Have you concluded?
If I could go on for more the practical, but I'm happy to take a seat and ask the court to urge this court to apply the Commonwealth, the CPL as written, hold the Attorney General to his enumerated powers, and reverse the judgment below.
Thank you very much.
Your Honor.
Let's hear from Mr. Scarinci on behalf of the AG.
Good morning, Your Honors. Madam Chief Justice, and may it please the Court, my name is Michael Scarinci. I am a Senior Deputy Attorney General with the Pennsylvania Office of Attorney General. I'm here representing Appellee David W. Sunday, public CPL action over the objection of a local DA. Mr. John Hare here will be addressing alternative arguments for affirmance. Although the Consumer Protection Law, the CPL, authorizes both the Attorney General and a local district attorney to bring an enforcement action in the name of the Commonwealth, when there is a conflict between them, the Attorney General prevails over the local district attorney.
Why is that? Don't you have to add a provision to the statute that the General Assembly did not insert that would give you the supersession authority? That's entirely missing in Section 4. The two district attorneys brought these actions before the Attorney General. And you maintain that absent language for supersession, you can come in later and supersede without even intervening under this Commonwealth Attorneys Act. Can you explain that to us?
Yes, Your Honor. I think the mistake that my friends on the other side, and I heard counsel repeat it here at the outset of his argument, is that let's start with the statute. But we have to go a little bit back and start with the Pennsylvania Constitution. As this court has said, most recently in Synthes, the constitutional language that the Attorney General is the chief law officer empowers the Attorney General. And so we start there.
Can we stop there? He's empowered as provided by law. He's not a roving law enforcement officer.
I agree, Your Honor. There's some tension between the language and the Constitution because it both empowers him as the chief law officer, but it also allows the General Assembly to legislate on his duties and on his powers.
There's no tension at all, counsel. You want to draw the general flavor or gestalt of the thing from the chief law officer when it's clear under the Constitution that you only have such power as you get by statute. Here, you have the statutory authority to intervene, and you did not do it. And number two, you share the opportunity to bring an action under the CPL, and they did it first, and then you came along and did it. And you don't have a power to supersede them in any statute that I've seen that applies in this case. Do you?
Your Honor, we're relying on the Constitution, but also it's not explicit in the CPL, but it's ambiguous because between the district attorney and the attorney general, when it comes to a public CPL action, one party must prevail over the other. And so we have to apply the typical rules of statutory interpretation when a statute is ambiguous.
Why does one party have to prevail over the other when the specific statutes gives both of these parties the ability to file lawsuits?
It gives them the authority to bring a lawsuit, but it does not resolve explicitly what happens when there's a conflict between the two of them. And we can see some of the conflicting results that might happen if they're both bringing an action in two different courts. We would see potentially conflicting litigation strategies, conflicting interpretations of statute, and potentially conflicting results because the Attorney General is going to bring an action in the Commonwealth Court, and we have the DAs bringing their action in the Court of Common Pleas. And I think this gets into some of the consequences of either party's interpretation, which is one of the factors you can consider under Section 1921 of the Statutory Construction Act. So I agree with you.
It sounds like an argument for the General Assembly. It sounds like a simple fix. You go to the General Assembly, and if you have such a great argument, just get them to amend the statute that gives you your authority and also the CPL. But it seems to me that what you're doing is coming to us and asking us to do that work for you. We're not authorized to change the language of the statute. There's nothing in this statute, either the CPL or the Commonwealth Attorneys Act, that authorizes you to supplant them. And this concern about double recoveries or downstream effects is not the issue before us in any event.
No.
If there's some issue about there's no money left in the till, or there's some enforcement issue, that's something a trial court can handle down the line. Can you react to that?
Yes, sure.
Am I
Yes, Your
missing something?
Yes, Justice Wecht. Again, I agree with you. It's not explicit in the statute, but I think, as the unanimous Commonwealth Court concluded, the statute is ambiguous, and then we look to the typical rules of statutory interpretation, including what was the state of the law when the CPL was enacted. That's the black letter.
Before you go to statutory construction, can you explain the ambiguity?
Yeah. Thank you.
The ambiguity, I think, flows from two different sources, Your Honor. First, because the Constitution.
No, don't talk about the Constitution.
Well, Your Honor,
there's the ambiguity in the statute, the statutory language. I mean, you're chuckling, but we look to the statutory language to discern ambiguity. We don't look to external sources to discern ambiguity.
I disagree, Your Honor. I think we have to start with the constitutional language. That's a requirement.
Is the Constitution ambiguous?
No, I'm not saying. I'm saying the Constitution, when read as when the statute, when the CPL, Commonwealth Attorneys Act, is read in light of the Constitution, there's an ambiguity because it sets forth that the Attorney General is the chief law officer.
As provided by law.
You want to take an unambiguous statute and try to make it ambiguous by importing some spirit of the law from the Constitution. Is that what you're trying to do?
Not at all, Your Honor. We have to read the Constitution. We have to read a statute in light of the Constitution.
I don't understand where you're getting that principle from. I mean, I've been doing statutory construction for a while. I've never heard that.
Well, that was my understanding of the black letter law, Your Honor, and the Constitution sets forth the framework of our government, so it establishes...
You could argue that the statute is unconstitutional.
Right, there, you can do
based
that.
on some provision of the Constitution, but I don't recall ever seeing an analysis of a statute on ambiguity based on the Constitution.
Well, maybe I should take it from a different angle, Your Honor. The Constitution limits what the General Assembly can do, so we have to read it in light of that. So with the...
I see what you're saying. But you have to presume the statute is constitutional.
Of
You have
course,
to-
and I'm presuming
so,
that, Your Honor.
So let's presume it's constitutional.
I'm-
And just
if I-
tell me
if I was
what...
confusing. I'm
Please,
not challenging
sir,
the constitutionality.
Mr. Scorinci,
Yeah.
let
I'm
Justice-
sorry.
Let him
Yeah.
finish his
I'm,
question. Thank you.
I apologize.
I understand. Let's just agree that for a moment we disagree that you
I
should
do
start with the Constitution. Let's start with the statute. Is there any ambiguity in the statute?
Yes, that was my next point, Your Honor.
Start with that one.
After the Constitution. I wouldn't want to forget the Constitution. The ambiguity is, as I think I mentioned, and I apologize if I've repeated myself, that the inherent ambiguity is because they both can bring an action.
That's not ambiguous. That just says that the legislature wanted both of them to have that power. What part of "or" don't you understand? There's nothing ambiguous about the word "or." It just means in the alternative, either the AG or the DA can do it.
And if they both do it, then what happens when they have a conflict? Because we wouldn't expect the General Assembly to require absurd results. And as I think I mentioned...
What is the absurd result? The absurd result we have here is because the AG decided to ignore the fact that there were pending lawsuits brought by district attorneys in courts of common pleas. I mean, that is where the action was. I mean, that's why it's so odd to refer to this as supersession, because supersession would imply that you go to where the lawsuits are filed and say, Your Honor, we are superseding. Here, this was just totally ignoring the fact that district attorneys exercise their rights under the Unfair Trade Practices Act. That's why this confusion resulted.
I think Madam Chief Justice put it best. There's a de facto supersession here because there's nothing left for the constituents to...
There's no supersession.
No
Because
supersession.
you had the power, under the Commonwealth Attorneys Act, you had the power to intervene at any time. If you were concerned about these so-called absurd results, all you had to do is intervene under the Commonwealth Attorneys Act instead of trying to invent a supersession power that you don't have.
Well, I think there's two responses to that, Justice Weck. One is we went to the Commonwealth Court to get a Commonwealth-wide ruling. We weren't required to intervene in those actions in the Court of Common Pleas. We have the discretion to, and we didn't want to go into one court and have to go into more than one court.
Can I
It's
just
as if
probe
you're
it?
pretending that the common pleas actions
don't.
didn't exist.
I'm sorry, Your Honor.
I'm sorry. It's as if you're pretending that the common pleas actions did not exist.
Well, I think you also may see us go into after this court rules, go into the Court of Common Pleas if we have a favorable ruling and saying you can no longer proceed. And I think you'll see the drug companies do that as well on alternative reasons. So the fact that we haven't done it now.
You need the power to supersede to do that.
And we believe we have the power.
And it comes from what ambiguity in either the Commonwealth Attorneys Act or the Unfair Trade Practices Act. We'll start with the Commonwealth Attorneys Act.
Well, the Commonwealth Attorneys Act gives the Attorney General broad primary authority in a civil action. It also requires the Attorney General to appoint a director of consumer protection, gives him the authority to make rules and regulations. So I think that that are some indicators, again, not explicit indicators, that the General Assembly expected him to have.
Yeah, but then they, I agree with you. If all you had was the Commonwealth Attorneys Act, we wouldn't be here. But then they pass a specific statute which overrides the general, carving out an additional area for district attorneys to essentially exercise the power of suing in the name of the Commonwealth in this particular area. So the two can exist, coexist, right?
Excuse me. To be clear, Justice Brobson, I think the CPL was passed before the Commonwealth Attorneys Act. CPL was passed in 1960.
It doesn't matter. The specific overrides the... In the event of assuming there's a conflict, and I don't think there is, but assuming there's a conflict, the specific would override the general, right?
Correct, and that's in the CPL.
Right. So is there a conflict between the Attorney General, the Commonwealth Attorneys Act, and the Unfair Trade Practices and Consumer Protection Law?
We haven't argued that there's a conflict. We've argued that they should be read in pari materia. So we don't see them as
But
conflicted.
that reading, counsel, in pari materia in your construction, would rewrite Section 4 to delete the words "or a district attorney," would it not?
No, they of course have the authority to bring an action. We're here on limited grounds about what happens when there's a conflict between them. So it's not asking this court to rewrite the statute.
So in other words, under that reading, a DA would bring an action, as happened here. The DAs brought actions prior to the AG. They could litigate their cases, and then whenever by fiat an attorney general decided to swoop in and knock them out and just take over the case, you could do that even though there's absolutely no statutory language that gives you that authority.
Well, Your Honor, I disagree about the statutory language, but in terms of limits, but in terms of...
What's the language?
Again, it's not explicit, Your Honor. It's implicit. That's our argument. It's based on reading several different materials, the Constitution, Commonwealth Attorneys Act, and the CPL. But there are limits on this. We're not, if the district attorney had brought an action, litigated it to final judgment, exhausted all appeals, and the attorney general had not stepped in at that point, that of course would be final. So
you're telling this court, under that scenario you just talked about, that the DAs on the strength...
I don't think it's a question of who files first. It's our position is that it's the fact that the Attorney General is the chief law officer and represents all Pennsylvanians. He's the chief law officer for all Pennsylvanians. It doesn't end at Allegheny County.
I guess I'm asking you the result, though. I'm not asking you the basis of it. But in your view, if the Attorney General brought an action just relating to damages to the Commonwealth in the city and county of Philadelphia, that initiation of that action would preclude the district attorney of Philadelphia from exercising his authority under that section.
Correct.
But do you agree that there's nothing in that section that says that?
I agree it's not explicit. We were relying on an ambiguity, as I said, and we believe that applying...
And the ambiguity is that the statute doesn't address the circumstance.
Right, it doesn't address that circumstance because at the time the CPL was enacted in 1968 and 1976, the common law provided that the Attorney General could supersede. So there would have been no reason for the legislature to address that issue. And of course you can, I'm not asking the court to incorporate the common law powers, but what I am asking the court to do is to apply the ordinary rules of statutory interpretation to look at the state of the law when the legislature enacted that legislation, just as you've done in the past.
The CPL's been amended since then, right? The General Assembly is well aware we're not in the common law of crimes anymore, right? We're not in the common law era.
Correct.
This year, right? So that why does your canon apply given that there's been legislative revision?
I think because we read it in pari material with the Commonwealth Attorneys Act also, that when the legislature enacted the Commonwealth Attorneys Act, the Attorney General was giving broad primary authority over civil cases. There was no mention of the district attorney with respect to civil cases in the Commonwealth Attorneys Act. And of course, the legislature knew how to give the DA supersession power as it did on the criminal side.
Where's the broad primary authority over civil cases?
That the Attorney General prosecutes and defends actions for the Commonwealth in Section 204. And it's up to the Attorney General to decide when there's a conflict with other attorneys who represent the Commonwealth, specifically the Office of General Counsel, that it's the Attorney General who controls.
So you're saying that the Attorneys Act, which came after the CPL, now cabins the express authority of the district attorney in the CPL to only being able to bring actions in the name of the Commonwealth if the Attorney General gives them permission to do it.
We don't have to give them permission, but if the Attorney General were to come in, then...
Where's the come in part in the Commonwealth Attorneys Act?
Your Honor, again, I think it's implicit in the statute that they have well, not in the Commonwealth Attorneys Act.
I think the only one where the come in part is where they intervene, right?
Yes, they have the discretion to intervene.
Where's the other come in part?
Well, they could, as we did here, we could go to the Commonwealth Court and get a Commonwealth-wide ruling.
Where does that appear in the Commonwealth Attorneys Act?
Well, because the Attorney General represents the Commonwealth, he's required to bring an original jurisdiction action.
Then why would the General Assembly permit you to intervene under 204C?
We're permitted to, I'm sorry, I'm not sure I understand the question.
The question is if you, I'm sorry, Justice, the question is, if the General Assembly said you can intervene and that's your remedy, why do you need this implicit authority to also bring your own action?
Well,
Isn't that the will of the General Assembly that
could've-
says your remedy is intervention?
Well, they said we may intervene, we have the discretion to intervene.
Right. You may or may not, but they didn't
Right.
say, and if you don't, you can also do this.
But by going to the Commonwealth Court, we get a Commonwealth-wide ruling that's effective, that controls, is binding on all the Court of Common Pleas. So that's what happened in this case, why we didn't go into the Court of Common Pleas. It was because we wanted a Commonwealth-wide ruling.
But that required you to ignore the fact that there were actions pending in the Court of Common Pleas brought by district attorneys. I mean, just as a matter of just comedy, I mean, it's sort of what struck me about this case. There's this bulldozer aspect to what happened here. I mean, this notion of not accepting the fact, I'm sure you're aware that these actions were brought in these other counties, just deciding not to deal with them.
Strategy.
And claiming in a settlement agreement that you had the authority to settle all these claims. I mean, that's, you know, something to discuss with the counsel for the settling defendants, but it's, you know, I think we're here in large part because there was a bulldozer instead of attempting to pry the door open.
I don't think there was a bulldozer, Your Honor. This started back in June of 2017 with Attorney General Shapiro, who started a nationwide investigation and then worked towards a settlement. It wasn't until a year later that the DAs brought their action. Not the DAs, excuse me, DA Krasner.
It was later than that you brought your action. So
Well, we obtained a settlement first.
They sued first, and then you tried to bulldoze later without having a statutory bulldozer. Isn't that what happened?
Your Honor, let me just clarify. I mean, yes, they did bring their action in November. DA Krasner, to be specific, brought his action in November of 2018. But Attorney General Shapiro then had been participating in a nationwide investigation back in June of 2017. Then in October of 2019, our office announced support for a framework for settlement, and then in February of 2021, DA Zappala brought his claim.
Wasn't that his right to bring the claim?
No.
Really, I mean, even everything that you've explained, it appears that the legislature with the consumer protection law seemed to recognize that there may be, in certain circumstances, local interests that had to be protected by the district attorney. So
Right.
I don't understand why that's a negative.
Well, Your Honor, I think this gets into one of the issues that we've raised, the consequences of a particular interpretation. This particular case is not a question of local concern. The opioid crisis affected all of Pennsylvania, all of the nation. So we're not seeing the kind of different effects in terms of who suffered. The effects were the same. And Philadelphia.
That's interesting that you mentioned that, because when you look at the manner in which the settlement proceeds were distributed through the trust, it was done on a county-by-county basis, implicit in which is the fact that there were claims extant for damages in each of those counties. The Commonwealth of Pennsylvania got a minute portion of the settlement. The vast bulk of the settlement proceeds went to each of the individual counties, some through their district attorneys, some through the county commissioners or their other governing body. So, I mean, even the settlement in this case recognizes the fact that there are distinct local interests at play here. Does it not?
Well, Your Honor, I would say it this way. Of course, Philadelphia is a major city. It had more people suffer, so it did receive a disproportionate amount.
I'm not looking at Philadelphia. I'm looking at every county.
Yes.
Fayette County, Union County, Tioga County, Lycoming County, each county was allocated funds based upon the local impact, I'm assuming, recognizing the
Correct.
local impact, the local interest attendant to the opioid scourge.
And the Attorney General is the person who's in the best position to represent the Commonwealth wide, not a local
is he
district
in the-
attorney who's only concerned about his local
Why is
jurisdiction.
he in the best position to decide what the best interest is in Allegheny County?
Because he's looking at it from a Commonwealth-wide perspective. He's not looking at it just a parochial interest. He's looking at what's going to benefit all the people the best, because he is, of course, elected by all the people in Pennsylvania.
Exactly. I agree with you entirely, and that's why the Unfair Trade Practices Act allows DAs to bring an action based upon their perspective of what a local impact is.
Yes, but as I've said throughout this, the Attorney General has the right to supersede him based on an ambiguity in the statute and based on the Pennsylvania Constitution.
Do you agree, counsel, that we only get to wade into this this calculus about who serves the best interest and who's better qualified to pursue the Commonwealth's interest or the public welfare, et cetera, if there's an ambiguity? If we read the CPL to say what it says, the Attorney General or a district attorney, and we read that and say it doesn't strike us as ambiguous, you don't get to make this argument at all, do you?
Yes, Your Honor, I agree with you. We're relying on an ambiguity in the statute. And as I said, I don't want to repeat myself, so we're relying on ambiguity that begins with reading the Constitution as a backdrop when reading these other statutes, and the statutes that I've mentioned already that I think resolve that ambiguity when you apply the ordinary rules of statutory interpretation. I think I've advanced all my points, Your Honors, and if there's any other questions, otherwise I think I just want to mention one thing that I remember. I'm sorry, Your Honor, that my friends on the other side, I think either Justice Mundy or Justice Doherty asked this question, if the DAs were to recover penalties, civil penalties, those would be, this has never happened before because they haven't exercised this authority ever in 40 years, but if they were, those would be payable to the Commonwealth under the CPL, which would go to the general fund. And so unless there's any other questions, I'll turn it over to Mr. Hare.
Isn't that in conflict with 72 PS 1792A1, B1, in which it says money received by the county, municipal, or local government and agencies, including the district attorney, arising from claims concerning marketing, manufacturing, sale, promotion, distribution, shall not be deemed funds of the Commonwealth and shall be deposited and shall not be deposited in that account? Doesn't that go directly in conflict with what you just said?
Yeah, I don't think it does, Your Honor, because under the Consumer Protection Law, the only remedies that in a public CPL action that a local district attorney could recover are injunctive relief, which is non-monetary, restitution, which goes to the victim, and then civil penalties, which are, again, as I said, payable to the Commonwealth.
Does the fact that this statute became effective after your settlement empower them? If
No, I think that's referring to either monies that had already been received or money that would come from a private CPL action.
I'm a little confused, and I apologize, but if the DA's action results in funds, in damages, civil penalties, he has sued on behalf of the county, and you're saying even though it's Allegheny County or Philadelphia County that's the client, those penalties go to the entire Commonwealth through the general fund?
Yes, in the CPL, under the CPL.
That's just based on the language?
That's on the
of
language in
CPL?
section 201.8, I believe, Your Honor. I'm not sure of that, but it does say that they're payable to the Commonwealth. Thank you, Your Honors.
Any other questions for Mr. Scorinci? Thank you so much. Now, Mr. Hare will bring it on home with the perspective of the pharmaceutical companies.
No pressure. Good morning, Madam Chief Justice.
Well, normally you're arguing against Mr. Becker, and Mr. Becker is here but not participating.
He'll tell me
You
what-
caught us off guard.
You'll tell me what I messed up later, Your Honor. May it please the Court, John Hare, and with me is William Petrogallo and Lane Golan for the pharmaceutical manufacturers and distributors referenced in the briefs as the settling defendants that we've talked about. Your Honors, we obviously agree with the unanimous en banc Commonwealth Court decision that the Attorney General does have the authority, and ultimately I think this is an issue of respective authority, supersession, de facto, de jure, it really is, to settle all public CPL claims for the entire Commonwealth, including the subset of the Commonwealth represented by the DAs in this case. And if Your Honors ultimately agree with that, then the alternative arguments we've raised, release, res judicata, and the one satisfaction rule, ultimately are moot. And that happened in the Commonwealth Court, and if that obviously happens, that's fine. So I'll be brief.
Can I just, is this the
Of course,
nomenclature thing?
of course, Your Honor.
You used the word subset. Do you think a DA is a subset of the OAG?
I do not think the DA is, Your Honor, but I think the party represented by the DA, and this is a crucial point that I think we're overlooking here, they're representing the same party. These are representative claims. So literally, the public of Philadelphia and Allegheny County, which are the parties in a CPL claim, are a subset of the Commonwealth public. These are public claims. These are not private actions.
Do you think that the DA of Allegheny County works for the county executive, and do you think the DA of Philadelphia works for the mayor?
I do not, Your Honor. But I think you're getting to the participation, the subdivision agreements that made the releasors. And it wasn't the mayor or the county executive only that joined the AG's settlement of these public claims. The participation agreements incorporate the settlement agreements, which define releasors not only as the elected officials, but the people who can bring claims by and through them. Not public claims, not private claims, all claims.
Isn't this an issue that, because brass tacks, what I think you're talking about are the implications for the settlement kitty downstream. Aren't these issues to be sorted out by a trial court and not with the broad, sweeping supersession invention that the Commonwealth Court did here on the front end?
I don't think so, Your Honor, because this is a pure question of law. With respect to the ambiguity that the court has asked so much about, it's true the UTP says an AG or a DA can bring a claim, but it doesn't address what happens when they disagree on the resolution of the claim. You can't proceed and settle a claim. Only one can happen, and that's the dispute in this case. Who gets to decide that?
Well, that's a capacity. So that's a capacity to settle, and isn't that more appropriately addressed when the settlement is attempted to be enforced in the Delaware County action?
No, Your Honor. The Delaware County actions have been stayed. We were sued in the Commonwealth Court. The Commonwealth Court decided.
No, I understand,
Yeah.
but okay, I get that. But I'm not saying that the Commonwealth Court was a wrong place to get a declaratory judgment, which is essentially what you got. I'm just saying if we put aside the supersession paradigm, this is just a case about whether a settlement agreement is enforceable or not.
If you get past, correct, Your Honor, if you get past supersession, there are, in our view, respectfully, very strong reasons that release, res judicata, and the one satisfaction will clearly apply here based on the settlements. But we don't get to Delaware County. This was properly litigated in the Commonwealth Court. The private actions filed by Philadelphia and Allegheny County were dismissed in Delaware County. These were only stayed because the issue was teed up and decided in the Commonwealth Court. And the district attorneys had a part of this. They've acted as though they didn't have any say in the Attorney General settlement. They were invited to participate as participating subdivisions, which every other DA did.
Right, they didn't want the deal.
Exactly.
They didn't like the deal. But can I ask you, go to the statute for a second?
Sure.
In the name of the Commonwealth is pretty ancient language. There are a lot of cases going back to the 1800s that talk about actions in the name of the Commonwealth. And the ones that I have seen refer to saying that the legal plaintiff is not the Commonwealth. The legal plaintiff is the person who brings the action in the name of the Commonwealth. Why shouldn't that principle be brought forward for this act to recognize that although bringing it in the name of the Commonwealth, the legal plaintiff is in fact the district attorney?
Yeah. Your Honor, it depends. There are cases, certainly, like the False Claim Act cases, which authorize a private claim by a person, a quote-unquote person. Section 4 of the CPL is quintessentially a public claim. To remove any doubt, the legislature said these claims are brought in the public interest. They're not brought by district attorney, they're brought by AGs or DAs, but they're not in the name of, as this court said in the Shapiro versus Golden Gate case a handful of years ago. The Commonwealth is the person in interest in a public CPL claim, because the other half of the statute, Section 9, is about private claims. So in the name of, combined with, and we respectfully keep forgetting about the other part of that sentence, it's brought in the public interest and in the name of the Commonwealth.
So you would distinguish the ancient cases because those cases involve purely private interest cases brought in the name of the Commonwealth, where the legal plaintiff is trying to recover for him or herself in the name of the Commonwealth.
That is correct, Your Honor, but we also have to remember this. The CPL is an unusual statute. It also talks about, and we've heard about civil penalties, on behalf of the Commonwealth, as if we needed sort of reinforcement about who the party is. The DAs say, well, you know, there's this amendment to the fiscal code that says the DAs get to keep what they recover. They can't recover civil penalties. Those go only to the Commonwealth. So while we can argue about the difference in the name of and on behalf of, the only damage they're talking about, a civil penalty, they cannot recover. So under the fiscal code, it cannot go to them. Even though the fiscal code says they keep what they recover, it can't go to them because they cannot recover civil penalties.
If you were correct, Mr. Hare, if you were correct that somehow we must construe the interplay of these statutes to give the Attorney General the power to displace without intervening, as he does have the power to do, doesn't that mean that in every other statute in pardons, wherever it says in the name of the Commonwealth, whether it's one of these factory inspector statutes or whatever's under Title 16 or the any person language and other statutes, universally in all those statutes, the Attorney General could at will swoop in, displace whoever's litigating that, and take over the case?
No, Your Honor, I'm not saying that. We are talking about consumer protection. And the Commonwealth Court was absolutely right when it said, look, there is an ambiguity. We keep fighting about whether there's an ambiguity. It is undisputed that the UTP does not say who gets to resolve the claim that they both can file. That's what this case is about, who gets to resolve it. So if these other statutes that you're referring to said these are brought in the public interest, then that has to mean the Commonwealth, or at least the public.
Can I just follow up
Sure.
on this resolve? I'm not sure I see the maybe I'm just failing to understand this this huge impasse you see. So this is a downstream thing. The DAs bring their actions, the OAG brings its action, and then whatever happens, in the counties where the two DAs brought their actions, there's a disagreement on resolving a case, and it can't be fixed. So the pharmaceutical companies can make a judgment whether they want to settle with whoever's willing to settle, and then on the civil penalty issue that the DAs don't want to settle, they litigate that. What's the problem?
The problem is, Your Honor, we want to settle cases on behalf of the citizens of Allegheny County and Philadelphia, and the DAs don't. We have to agree that it's the same citizens at play in both the Attorney General's lawsuits and settlements, and the releases are extremely broad.
I thought we established, though, that the county executive's action is under paragraph 9 whereas the DAs are under this Section 4.
No, the Delaware County cases filed by Philadelphia and Allegheny County are the private actions.
They're different actions than the district attorney's actions. We're talking about two different things.
Two completely different.
And they're settled. They're
That's what I'm
settled.
saying.
Yeah.
That's what I'm saying.
Yeah.
So the county executive piece is out. You're
Right.
saying we're talking about OAG versus DAs, right?
Your Honor, apologies, but they're not out. The citizens of Philadelphia and Allegheny County joined the Attorney General's settlement. The documents couldn't be more clear about that. They joined the settlements, and we all agree the Attorney General has a right to bring that claim on behalf of, I'm sorry.
But counsel, you would agree that the AG can settle, and you could only settle with someone the claim that they own, correct?
Correct.
The citizens of Allegheny County or Philadelphia do not own the claim that was brought by the DA.
They do, Your Honor.
I
They're the
see.
release.
That's where I differ with you. I mean, the Unfair Trade Practices Act makes clear the legislative recognition that local interests may differ in some circumstances from the Commonwealth's interests. That's why the district attorney or the Commonwealth can bring a claim. I don't see anything in that statute that suggests that the Commonwealth can decide that they have the ability to settle those claims that are brought by the district attorney advancing the local interest, that they are recognized to be able to pursue under the Unfair Trade Practices Act.
They're authorized to bring them, Your Honor. Page 2 of the plaintiffs of the district attorney's brief says, we are bringing these claims on behalf of our citizens, the citizens of the counties. Those are the exact citizens who joined the AG settlements of their public claims.
To settle their public claims. Their public claims, not the DA's claims. The executive of Allegheny County cannot settle the district attorney's case.
But the citizens can, Your Honor.
The county executive is acting on behalf of those same citizens. I mean, there is a divide that is recognized in the Unfair Trade Practices Act, and the divide gives authority to two different entities. And I'll just say it again. The reason we are here is because of the bulldozer that was used here, which brings me just my question to the settling defendants in general. Why would the settling defendants ever agree to a settlement without the discontinuance with prejudice of the pending common pleas court actions? Because they're still pending.
You're correct. They were stayed, Your Honor, but part of the settlement agreement, and this is a national settlement. Obviously, you can tell by the hundreds of pages in our record. Very, very complicated settlement.
I tried working through about 50 of those pages
Yes.
and decided it was above my pay grade, so.
Yes, and it was dependent, Your Honor, on the buy-in of different subdivisions.
I get it, but if they didn't buy in, they didn't buy in. I mean, see, that's the problem with a lot of settlement agreements when there are multiple defendants. That's why you have joint tortfeasor releases. That's why, you know, the law has developed along those lines. But what we have here is a situation where you leave cases pending and yet pretend to have settled all of those cases. I mean, it's just so contrary to the manner in which any kind of civil litigation proceeds, that it's the bulldozer approach. We're going to see what we could get and keep our fingers crossed that this actually takes care of those cases that we left pending out there.
Yeah, Your Honor, a couple of points. First of all, in a joint tortfeasor situation, the resolving parties are different. They're different clients. The same parties who the DAs represent settled their public and, by the way, private. That's why the private claims were dismissed in Delaware County. They settled their claims.
See, that's where you and I will continue to disagree, because the district attorneys have a distinct ability to bring a distinct cause of action under Section 4. This Allegheny County, the county executive, whoever it is else out there, they had their own lawsuits that they could bring. They're settled. They're discontinued, correct?
They are stayed. In Delaware County, they're stayed. Your Honor, the best analogy maybe in our appellate case law, including this court's jurisprudence, is a wrongful death claim. We know by rule that a wrongful death claim has to be brought by the personal representative on behalf of the beneficiary, but it's the beneficiary who's the real party in interest. So if the beneficiary settles that claim before the personal representative files suit or outside the lawsuit that the personal representative files, the personal representative's claim is released because the party for whom the claim is brought released it. That is exactly equivalent to what we have here, because the litigants, the citizens, the electorate, they use all those words to describe them, settled the claims that they're bringing. And they settled under the broadest possible general releases that released all claims by elected officials, including district attorneys.
Except that I understand the general public interest argument and the citizenry, et cetera, but you still have the inconvenient fact that the General Assembly said Attorney General or a district attorney, and that created it's like a chosen action. I mean, it boosted the DA into this ownership status here, and I'm not sure I see how you can displace that, do away with that, on the strength of an invocation of the generalized public interest. It seems like a risk that your clients and the Attorney General were bearing as they move forward here. And I think an assumption was made, validated by the Commonwealth Court here, that the AG could just override the DA, which again faces this inconvenient statutory language.
Your Honor, with respect, I don't think it's inconvenient. We're fine with the statutory language because it says they can bring a claim. That's agreed to. It's stipulated. The issue is what happens when they disagree in the disposition. It's like two competing personal representatives bring a wrongful death claim. It's the same idea. There's only one beneficiary. It's the citizens of Allegheny and Philadelphia, so a court has to decide. Somebody's got to control. You can't just say, well, they can both bring the claim. Somebody's got to decide who controls its disposition. And that's the issue. If you look at and I won't mention the Constitution, it does say chief law officer. That's not surplusage. But look at the Commonwealth Attorneys Act that we've heard about. It vests far more authority in an attorney general with respect to consumer affairs. They get to appoint the consumer advocate. They get to run all the consumer programs in the Commonwealth. So look at the CPL. It's the same way. They can do a lot of things a DA can't do. They accept assurances of voluntary compliance. They write the regulations for the CPL. So clearly what the Commonwealth had to do is not decide who gets to bring the action. We agree with that. It's who gets to decide how it's resolved.
I don't know how you split the baby that way. You bring an action in order to recover. I mean, you're saying you bring an action for the heck of it? I mean, the reason the actions are brought is to result in a recovery of funds. I mean, if someone other than the person who brings the claim has the ability to decide what to take at the end of the game, that's a hollow right to bring the action in the first place. I mean, as I look at this, I mean, the question keeps being asked, who gets to decide? I would say these suits that were brought by the district attorneys, they have the right to weigh in on what the public interest being served is and what is necessary in terms of compensation to accommodate those claims, because that's what the General Assembly allowed them to do.
Mr.
Your Honor,
Harris, can I interrupt?
Apology.
I think we're getting lost here. I want to go back to essentially what, at the outset of this whole conversation, Justice Mundy asked the question, who controls the settlement? In other words, who settles the case? Because if you have two different law firms, two plaintiffs' firms, for instance, who represent the same victim, who controls it? You have one big firm saying, we can get you a lot more money, and one firm saying, this is a great settlement. Who decides to settle the case?
That's this case. You're right, Your Honor.
That's
It's
why
the
I keep
victim.
asking, because we keep
It's-
going back and forth with regard to who can bring it, which I understand the statute says DA or Attorney General. But if they're representative capacity, we've already established this is a public interest. The CPL is a public interest statute. You file on behalf of the public. It becomes who settles the claim. So if you're representing the same public, whether it's the citizens of Philadelphia, which is a subset of the Commonwealth of Pennsylvania, that's where I keep getting lost in this particular issue.
Yeah,
The claim is settled by somebody. Somebody's got to control it. If two law firms represent the same party, who says I'm either settling or not settling? Is it the law firm or is it the client?
In the personal injury scenario, Your Honor, it's the victim. The victim gets to decide whether to settle. And here the victim is the citizens of Philadelphia and Allegheny County. They joined the...
It settled the case on behalf of the victims of the Commonwealth of Pennsylvania, the citizens of the Commonwealth of Pennsylvania, which include the citizens of Allegheny and Philadelphia.
And those citizens decided to join the Attorney General's settlement. This is the point. You could have 10 law firms representing the same person, but if that person, like a beneficiary in a wrongful death claim, releases their claims, that claim is gone for all 10 law firms.
Justice Mundy was asking that question at the outset, and I don't think I got an answer, which is why I wanted to...
Apologies.
Mr. Hare, though, who agreed to the settlement for the citizens of Philadelphia and Allegheny County?
They're elected representatives, as the releases say, Your Honor.
Isn't the district attorney the elected representative of the people?
He is an elected representative, and had he joined the settlements on behalf of them, and the settlement said anybody by or through the district attorney joins the settlement, then it would be the same result.
But my point is, there are many elected officials in Allegheny County. I mean, can the sheriff agree to settle? Can they give you the authority to settle?
I wouldn't think so, Your Honor. I mean, we have to remember, only DAs and AGs can bring a public interest.
I'm getting to a finer point of the settlement, because I believe this case is about settlement authority. I don't think it's a case about who, it's really, to me, it's a case about settlement authority. You say that the citizens of Allegheny County and Philadelphia County agreed to the settlement. They're the victim and the plaintiff's injury person. I'm asking you, did you do a poll? I mean, was there a referendum? I mean, how do we know this?
The mayor, their top executive official, and the Allegheny County executive joined the settlements.
And you're saying that that elected official has the express grant of authority to settle civil actions brought by the district attorney, a separate elected official, on behalf of the people. That when the DA brings a CPL claim, the way they determine the client's wishes is to talk to the mayor?
The county executive.
Or the county executive?
Yeah, that is an executive level decision.
I know you're saying, you're arguing that. I'm asking you for the basis of your argument for that. Is there a statute that gives the authority to the mayor to direct the elected official's lawyer, the district attorney, on how to proceed with litigation and to settle or not?
Yeah, I don't know.
The answer is clearly no. Isn't the answer clearly no? In other words, you're saying that even though the statute says the district attorney, you're saying we can ignore that and just sub in the Allegheny County executive and the mayor of Philadelphia?
No, Your
On the settlement authority front.
No, Your Honor. The statute, again, we have to just be careful about what it says. It said they can bring the action. That's what it says. The Attorney General brought the action. The question is who it's on behalf of. And it's on behalf of the very citizens who then separately, through their executives, the Attorney General didn't have to involve.
Well, did you involve the governor in the Attorney General's sign-off on the settlement?
No, the governor doesn't.
Well, that's the executive for all the people of the Commonwealth of Pennsylvania, so the executive would represent the public interest, and they would have the settlement authority for the AG's action, right?
No, Your Honor. The governor can't bring a UTP claim as
well. Neither can the mayor.
Correct, and he didn't. And
but
it's a question of whose citizens. I'm sorry.
Yeah, no, I'm not sure. I think we're speaking past each other.
Yep.
You've created the paradigm that the DA, although the statute authorizes the DA to bring the action in the name of the Commonwealth and the public interest, can do that, but they don't speak for the client they represent. Some other elected official speaks for the client, the victim, the beneficiary. And that's the person that's vested with the authority to enter into the settlement. I understand that's your argument, correct?
The argument, Your Honor, is the claims were brought by the correct people.
Right.
The question is who joined the settlements and how. And
No, the question is who has the authority to settle? And I think in responding to the questions, you're saying the mayor had the authority to settle for the citizens of Pennsylvania that the district attorney was representing.
No, Your Honor, I apologize. I want to distinguish between the authority question. The Attorney General has the authority to settle for the whole Commonwealth, and it did that. It doesn't need the buy-in of anyone to do that.
Does the district attorney have the authority to settle a CPL? Let's say the Attorney General didn't bring this action. Let's say that did the district attorney possess the authority to settle their individual common pleas court actions without involving the mayor or the county executive?
Yes, assuming that they're public interests, they're not individual actions. Yes, you're correct. If the DAs just brought claims for Philadelphia and Allegheny, they could settle those. Yes, they could, because it's their claim on behalf of their citizens.
They're not aspiring. The DAs here are not aspiring to bring claims outside, on behalf of citizens outside of their two counties. The bridge that you're trying to construct that I submit doesn't exist is the bridge that allows you to remove the district attorney from the statute. So that you have the inconvenient mess created by the fact that your clients settled with the OAG in a situation where the OAG lacked the authority to get rid of the DA. So at your peril, you settle that, and the DAs have their actions, and whatever happens in those actions happens. So the world doesn't end. You know, you might have the view that you pay twice if you pay again, but you know, that's a risk of settling when the defense, you know, the OAG thinks he has authority that he doesn't have. I mean, that's not an end of the world risk, but it's a bit of a mess. But there's the mess, and I don't see the legal construct whereby we can do what the Commonwealth Court did here and sort of clean up that mess for you.
Your Honor, the suggestion that you cannot reach a Commonwealth-wide settlement until everyone signs on, as you've said, that where there are claims outstanding, would mean you would never reach a settlement like this. To this day, there are 20 other municipalities in Pennsylvania that didn't join this settlement. This was a Commonwealth-wide settlement that had certain thresholds because you're never going to get everyone join a settlement like this. So it can't be the answer to say, well, you have to wait till everyone signs on before you join, or the hundreds of Commonwealth-wide settlements. And this one, Pennsylvania gets $1 billion, and that's being jeopardized by the continuation of these claims.
No, it's not.
I totally, just to finish up on that, I totally understand the jeopardizing argument, and I see what the Commonwealth Court was doing here. But sometimes the law jeopardizes things. Sometimes the law creates a mess, and the legislature gave the DA this power, and they can, you know, they can upset this thing, this apple cart for you. That's just too bad. But you know, this jeopardizing argument is akin to sort of a public policy argument, and the General Assembly makes the policy. They wrote district attorney, and that's the basis upon which these folks get to sue and get to have a seat at the table.
And Your Honor, that's a good way to sort of get back to where we started. There is a mess, I agree with you, but it's an ambiguity. It's something courts, and especially this court, deal with all the time. The statutes say, and we do take them together, the statutes say the AG or DA can bring the claim, but the simple ambiguity is, and it's not, I'd submit, Your Honor, that it can be easily reconciled when we look at the authority of the Attorney General versus the DA across all of these provisions. Yes, the Constitution, but the CAA and the CPL too. So this is a simple matter of statutory interpretation. The statute doesn't address who gets to settle claims for the same people.
See, counsel, I understand your argument, and you know, you've repeated it, it's been repeated, but it doesn't make any sense in the context of how litigation works. This notion that you could take your chances and ignore pending lawsuits on the theory that the ability to settle is somehow different than the ability to take over that lawsuit is one that just doesn't fly. I mean, if there were a supersession authority, which is why that's been argued. I mean, this case has been argued as the AG has the right to supersede. Without that right, you can't take over a lawsuit. I mean, you know, if this goes back to Delaware County, and I'm assuming that's where everything is still pending. I have a unclear understanding of what's still out there, but I'm assuming it's in Delaware County. This goes back to Delaware County. Somebody's going to make the argument you're making here. And the district attorney is going to take the position, it didn't settle our claims. That was not in the best interest, the public interest of the electorate that we represent here. That argument's going to be made, but they still have lawsuits.
But then it sounds like, Your Honor, somebody's going to have to decide this issue, which is a mess, as Justice Weck says, but somebody's going to have to decide who controls the ultimate disposition of that district attorney's lawsuit. They could decide to try their cases. I mean, each of their individual cases is based upon facts and circumstances existing within their jurisdictions. I mean, I'm assuming, I don't know how this settlement came to pass, but I can look at the distribution through the fund, and it's obviously done on some assessment of a county-by-county impact of the opioid scourge. I mean, so the district attorneys who still have cases pending may say, here's our case. Here's what the impact is in our jurisdiction and this is where our lawsuit generated. I don't know what would be wrong by that. It would be inconvenient. There's no question about that. But yet, without the ability to supersede those lawsuits, I don't know how the AG can settle them. You can't try a case, Your Honor, if as a matter of law there's no relief that you can recover. Under the CPL, there are only three forms of relief. There's an injunction, which the AG got. There's restitution, which you need an injunction. Did they get a permanent injunction? Sorry? Did they get a permanent injunction? It is an injunction for 10 years, Your Honor.
But it's not a permanent injunction. With a permanent injunction, disgorgement is a possibility, correct? And that was not part of the settlement, correct?
It was, Your Honor. See, this is...
I thought it was expressly exempted.
Yeah, disgorgement and civil penalties. First of all, disgorgement's not in the CPL at all, but it was excluded only as compensatory compensation, restitution, and that's because of tax reasons. These settlements foreclose any and all relief for any opioid-related harm of any kind. So the district attorneys, when they go back, they can't get an injunction because the AG got that. They can't get restitution because you need an injunction first. And they can't get civil penalties because, however we define the difference in the name of and on behalf of, they have to go to the Commonwealth. So there's nothing for them to recover because it's all been released. So if I pivot away from the respective authorities, the fact is, under res judicata, for instance, these consent judgments acquired res judicata effect, and that's obviously for a court ultimately to determine whether they do. But the parties to this, which again included the citizens, said these are preclusive of all other opioid-related claims. So if you go back to Delaware County, first of all, those are claims by counties. The Attorney General doesn't have to intervene at all, but why would it intervene in a claim for a county when it's settling on behalf of the Commonwealth as a whole?
You keep confusing me. The district attorneys have actions pending. District attorneys' claims against the settling defendants.
For people who have settled for whom they can recover no relief.
Well,
yes.
They have claims pending, and you say that. Some court may have to decide that. Are there other claims brought by the county of Allegheny? Forget about the district attorney's claims.
Those have been dismissed as a result of the settlements.
Okay, see, that's what happens when you settle claims on behalf of the county of Allegheny. They get dismissed. The lawsuits get dismissed.
Those were private claims.
I get it. I get it. They were claims for different damages.
Unlike the DA's claims, which are claims against the same people for the same relief. Appreciating, Your Honors, that you might not be buying what I'm selling. If I could just quickly pivot to the consequence, because in statutory interpretation, of course, the consequences matter. If not only is the continuation of these claims going to cost the remainder of the Commonwealth millions and millions of dollars, and appreciating, Your Honor, that that's a consequence of allowing claims to remain open, I also think you're going to invite chaos, I don't think is too strong, into the settlement of CPL claims, because the statements we've heard today are the DAs were first here. That's just not true. Attorney General Shapiro first spent years investigating.
Well, people investigate things all over the place for years. We're not talking about, maybe the DAs would say, we were investigating this from the day we were born. I mean, it's meaningless. We look at the filing of a lawsuit. To the extent primacy matters, and I'm not saying it does, that sort of competition is meaningless, but they did bring their actions first. And this consequentialism, to me, is an argument to make to the General Assembly if you want them to take the DAs out of the statute because, hey, senators and representatives, here's Exhibit A. Look how much money you blew for the Commonwealth because you've got this DA language in Section 4. But coming to us and arguing, gosh, you have to affirm the Commonwealth Court because otherwise the heavens will fall. Let justice be done though the heavens fall. And justice here is whatever the statute says.
And, Your Honor, I agree. I won't return to the interpretation part because I don't think now there's a doubt that there is an ambiguity. But what I'm pointing out is the suggestion earlier seemed to be that this AG was sort of late to the party and sort of glommed on. And we're going to allow one or two DAs, and yes, these are big county DAs, but they could be small county DAs, to wait until the Attorney General spends years, and only the Attorney General can negotiate with the hundreds of subdivisions in a state to reach a Commonwealth-wide settlement. And this was done 5 years ago. It was a hallmark, obviously, of now Governor Shapiro's tenure. But since then, it's been Attorney Generals Henry and Sunday who have defended this for 5 years after this settlement was supposed to be completed. So in terms of policy and looking to the next case, it is a strong disincentive, I'd submit, to say that you work at your peril if you try to settle on a Commonwealth-wide claim, if there's any claim still out there, because the legislature hasn't said the AG supersedes, when all of the relevant imperamateria say the AG is superior with respect to consumer claims.
It would have been so easy for the Commonwealth, for the General Assembly to say, and the Commonwealth supersedes any cases brought by the DA. Or there could be something in the Commonwealth Attorneys Act that ever gives the Commonwealth to supersede under any circumstances. It would have been easy for them to do that. They didn't. And maybe you're right. Maybe they should have.
Well, the question becomes, why did the General Assembly use the word intervene as opposed to supersede?
Because it's another indication of the power of the Attorney General versus the DA. The DA can't intervene in an AG suit, but the AG can intervene in a DA suit.
You didn't.
No, why would we?
You did not intervene. That's the ironic thing. You specifically, number one, you did not intervene, and number two, under your interpretation, the language giving you the power to intervene is meaningless because you can supersede anyway, anytime.
No, Your Honor, we could. It says may intervene, but why would, and I'm not asking the court a question, obviously, but why would we intervene in a county action? It's a Commonwealth-wide settlement. We don't need to intervene. When you look at the respective authority through all of those documents, the power, especially in the consumer realm, of the AG outstrips the DA. So why would we intervene in Philadelphia and Allegheny County? Well, it wouldn't, because then a court would still decide, Your Honor. What if the court said, well, the DAs get to control this case against all the authorities saying the AG can make a Commonwealth-wide settlement?
It does seem to me, though, that there's a lot of off-ramps to the parade of horribles. If we were to say that what the Commonwealth, this superstition stuff doesn't exist, we don't have that. An off-ramp would be your pharmaceutical companies would go in to the two actions where there was no settlement. The Attorney General would intervene, and you'd argue in front of the Common Pleas Court all of the issues. One, you have to dismiss the case because any remedy that they are seeking is foreclosed by the settlement that the Attorney General entered into. Money would go to the Commonwealth. There's nothing for them to recover. You've made that already. You could argue res judicata. You could argue all kinds of things and get the same result, the enforcement of a statewide settlement.
But the Commonwealth's a party, Your Honor, so the Commonwealth Court all these issues were before the Commonwealth. I'm not saying that you did. I'm not saying the Commonwealth Court didn't have jurisdiction and everything like that. I'm just saying we're here struggling, or I'm struggling, I'm not going to speak for my colleagues, with this whole supersession concept. And your response, which I completely understand why you're raising, if we don't make this grand principle that the Attorney General has supersession authority in all consumer protection matters, notwithstanding the ability of a DA to bring an action, the world is going to crumble, statewide settlements are never going to exist, all of that stuff. I'm just saying that I see off-ramps that would prevent us from getting there. Do you see them? I do, Your Honor, and okay. I think they're before this court, but totally appreciating if Your Honors don't reach them and the Commonwealth Court said they're moot, then we raise them elsewhere.
Mr. Hare, I appreciate your public policy argument. I think it's very strong. My problem is I can't get there because I don't find an ambiguity in the statutory authority, and I wondered if you could just address that.
Sure. Your Honor, I submit respectfully, there is an ambiguity because the statute only talks about who can bring the claim. The problem is now having both...
That's a gap, though, isn't that? How is that an ambiguity?
Because it doesn't address what happens later. It says you can both bring them, but it doesn't address conflict. Just like my personal representative in a wrongful death scenario. No statute, of course, and Your Honors know this, can address every possible scenario. In the 40-plus years the CPL's been on the books, this has never arisen.
We don't call those ambiguities. I mean, the reason courts are busy is there are all kinds of permutations that happen downstream. They're all, I mean, that's why you folks make a good living, better living than us. I mean, this is why there are, these cases. So there are all kinds of things that, why we enjoy our profession, right? There are all kinds of idiosyncrasies, off-ramps, things that can happen downstream. But that doesn't make the language of Section 4 ambiguous. Just because you have messy consequences down the line as far as trying a case or settling a case, that doesn't make it anything ambiguous about the language that the DA can bring the suit. There's nothing ambiguous about that.
And counsel, if I could just add one other thing to that. I mean, there's no downstream mess as far as I see it, because there are often times that cases can't settle. You try cases. That's why we have trial lawyers who go to court and try a case. I mean, if the DA and the AG were both involved in the action in Delaware County because there was an intervention or they otherwise filed there, and then the consolidated cases, what would happen. They'd say, we can't settle. The trial court would say, go to trial. And there'd be a verdict. There'd be a verdict. There would be, sometimes cases don't settle. I mean, I understand the complexities involved with companies like your clients who have statewide issues and they want to take care of it in one fell swoop, but our law is just not geared toward accommodating that desire.
Mr. Hare, if we could just go back to my question as supplemented by Justice Wecht and Justice Donoghue. The fundamental problem is reaching your public policy concerns when we don't see an ambiguity in the statute. If you could just address that and then supplement it however you wish.
Understood, Your Honor. Yes, I respectfully submit that there is an ambiguity in the statute. There has to be. It's like the rule that says, to get back to the wrongful death example, because it's the only one I can think of that's even close, the personal representative has to bring a wrongful death claim. But it doesn't say what happens if there are two personal representatives. No statute or rule can address everything. So you wouldn't come back to this court and say, you didn't add in there what happens later. We wouldn't come back here. We would have a court decide what that means. And you look at the relevant, statutes regarding who the proper person.
But that didn't, but that, Mr. Hare, that's right, but that didn't make the wrongful death statute ambiguous,
Well, Your Honor,
right? I mean, you have a messy case. The court's going to have to decide who the personal representative is or whatever. But that didn't make the statute ambiguous. I mean, I don't think we've ever seen that, have we?
in the personal representative scenario, no, just like we've never seen this scenario. But if it doesn't answer the question before the court, because it doesn't, Section 4 does not answer the question before this court. Who controls the disposition? It doesn't answer, saying who brings the claim doesn't resolve it. It's about who resolves it. And that's the issue here. That's the issue before this court. So I just submit, Your Honor, to answer your question, I do believe there's an ambiguity. And if we then have to look, as the Commonwealth Court did, to the impaired material stuff, and I won't be redundant, it's got to be the Attorney General because it's a Commonwealth-wide settlement.
All right, any other questions for Mr. Hare?
Thank you, Your Honor.
Thank you very much, Mr. Hare, Mr. McMichael, Ms. Dorsey, Mr. Scarinci. Tremendous arguments. Your clients should all be assured that the very best job was done by their counsel. Thank you. Mr. Minner, we're going to take a recess until 12:30.
Thank you, Counsel.
Good afternoon. Mr. Minner, would you call the next case? In this case, Apelt was a suspect in a shooting of two individuals in North Philadelphia. Detectives met with Apelt and read him his Miranda warnings, which he waived. The detectives first questioned him regarding an incident in which he was the victim, and they asked him to identify the individual who shot him. Apelt immediately asked, "You all going to use this in court on me?" And one of the detectives assured him, "Nobody's using anything in court." Apelt then explained that he was fearful about identifying the person who shot him, but ultimately he identified his assailant. The detectives subsequently began questioning Apelt about his involvement in the shooting of the two victims in the instant case. Although he denied shooting anyone, Apelt eventually implicated himself in the shooting. Apelt sought to suppress his inculpatory statements at trial on the ground that they were given in violation of Miranda, because the detectives assured him that his statements would not be used in court. The suppression court denied the motion, finding that the detectives' assurance pertained only to Apelt's identification of the person who shot him. The Superior Court reversed, holding the evidence did not support a finding that the assurance was limited in this manner, and concluding that the detectives' broad assurance violated the protections of Miranda. The Office of the Attorney General appealed, and this court granted review to consider whether the effect of a suspect's otherwise valid waiver of his Miranda rights continues after the suspect is told by police that his subsequent statements will not be used against him. Good afternoon, Mr. Burns.
Good afternoon, Your Honors. May it please the Court, Hugh Burns of the Commonwealth. Saying nobody's using anything in court was not a Miranda violation. Once Miranda warnings had been...
I'm sorry, sir. Could you pull the microphone down a little bit? There we go. Thank you.
Is that better?
Yes, thank you.
Once Miranda warnings have been given and waived, the waiver process is done. In the words of the U.S. Supreme Court, the analysis is complete and the waiver is valid as a matter of law. It can't be retroactively made invalid by later police conduct, even if that conduct is questionable. The value of Miranda is clarity, and the warning and waiver process is either clearly done or it is clearly not. Once the warnings have been properly given and waived, the process is complete. The error of the Superior Court in this case was to rule that the warning and waiver process of Miranda was retroactively made invalid by what subsequently happened later in the interview, and that's not what the rule allows. Now, we're not talking here about a post-waiver reassertion of rights, which is something that the rule does provide. The Superior Court did not find that the defendant waived his rights and reasserted them, but that the warning and waiver process was retroactively invalidated by something that happened later. We rely on two cases. First is Moran v. Burbine, and the second is this Court's decision in Comm v. Templin. In Moran, the suspect was warned and waived under Miranda, and his lawyer later called the station and was told that he wouldn't be interrogated. Well, he was interrogated, and the Court of Appeals decided that that was a Miranda violation. The U.S. Supreme Court reversed the Court of Appeals, holding that what happened later had no effect on the completed Miranda waiver. The Court said that as long as the warnings are properly given and the decision to waive is uncoerced, the analysis under Miranda is complete and the waiver is valid. More on point, though, is this Court's decision, and a unanimous decision, in Collins v. Templin. In that case, after the warnings were given and waived, the officer gave the suspect an inducement to confess. And the issue in that case was whether that situation was the same as that in Collins v. Gibbs. In Gibbs, though, the officer gave the suspect an inducement to waive under Miranda. And in Templin, this Court said that the two situations are different. Where the Miranda waiver is obtained with an inducement, that's governed by Miranda. But whereas here, something happens later, an inducement is given to confess or some other impropriety after the Miranda waiver is complete, that's not governed by Miranda. That's governed by the question of whether or not the statement that was given involuntarily. So Templin is directly on point. It controls the Superior Court's published Miranda decision, and under it, the Superior Court erred and should be reversed.
Mr. Burns, is it your position that nothing that the police officer said or would have said, could have said after the Miranda warnings can impact the duration of the waiver at all?
It can't impact the waiver under Miranda. It can influence the question of whether or not the statement was given voluntarily.
How should we consider the fact that the defendant asked the question, are you going to use that against me? Or doesn't that indicate his lack of understanding his rights for which he allegedly waived?
No. Well, 2 pages before this happened, they went through the whole Miranda process, and they repeatedly assured the defendant that if he wanted to stop talking, for example, that would be fine. He acknowledged the warnings. He signed a waiver. So there's no question that he was given the Miranda warnings. He understood.
He apparently didn't understand them, right?
Well, that's the question I'm having.
Well, there was no claim that he didn't understand the warnings. That was not what the Superior Court decided, and that's not something that he claimed. And as a matter of fact, 2 pages after the disputed exchange here, he said, nobody's forcing me to say anything, or nobody's forcing me to say nothing. If I didn't want to talk, I wouldn't talk. As the trial court additionally found, and this goes to the voluntariness question, the trial court did find, as the Chief Justice mentioned, that the defendant understood that this statement had to do with the question of what's the identity of the person who shot him. And that was in a separate incident, not this murder case. Before the conversation turned, it was about a half hour later, to the instant murder case, in fact, the officer told the defendant, I'm accusing you of murder, which is something that a reasonable person in the defendant's position would understand to mean that we're not talking anymore about me being a crime victim. Now we're talking about me committing a murder, and that is a significantly different situation.
And shortly after that, the interrogation ended, right?
Yes, it did.
Can I ask you, Mr. Burns, what's the point of Miranda's prophylactic rule if the police can just contradict the warnings at will? Is there any point to the prophylactic rule? Because I think what you're saying is once he's Mirandized, there can be no Sixth Amendment violation. There can only be a Fifth Amendment violation on an involuntariness analysis. Is that right?
That's right.
And given that SCOTUS has said deception alone is not enough to render a confession involuntary, doesn't that mean Miranda is essentially reduced to something meaningless, isn't it then?
Well, not at all. And in passing, I want to note that, again, I don't think it's quite accurate to say that they were contradicting the warnings. The trial court explains in its opinion that when you're talking about a crime in which the defendant is the victim, that's not even something that Miranda contemplates. But the purpose of Miranda is a kind of a Faustian bargain where we get assurance once the process of warning and waiver is done that Miranda's been complied with, and we have that assurance going into the questioning. On the other hand, if Miranda is violated, even a completely voluntary confession will be excluded. So, that's the balance. The confession can still be excluded if the court finds that the interrogation was so manipulative, so coercive, that it deprived the defendant of his ability to make a free and unconstrained decision. But that's not what happened here.
Mr. Burns,
Here the police officer said, let me quote it, nobody's using anything in court. That was his reassurance.
Those are the words he said. And if that were taken completely out of context, that there might be a better case for the idea that his faculties were overwhelmed and he couldn't make an informed decision. But as the trial court found, the record supports the idea that he understood that that was restricted to who shot you. He had had the Miranda warnings and understood them. He was told before we started talking about this case, I'm accusing you of murder. And again, as he himself said, he stated, if I didn't want to talk, I wouldn't talk. So the record has substantial support for the trial court's finding that the confession was voluntary.
Yeah, but
That goes
Mr.
to
Burns, if I can
coercion,
kind of
correct?
interrupt.
That goes to coercion.
Yes.
Okay, not to whether or not he understood the rights that he was giving up. Two different
Correct.
prongs, correct?
Correct, but the record also supports the conclusion that he understood his rights because of just the manner in which the warnings were given. It was transcribed, it was filmed, he read them as well as having them explained to him, he signed a waiver, and again, later in the conversation, he said, if I didn't want to talk, I wouldn't talk.
That goes,
He understood it.
that goes to coercion. What the police officer stated goes to knowing the rights that he was giving up. I mean, the police officer said, nobody's going to use it in court, which is a direct contradiction of the Miranda warning that he got.
Well,
That's not a coercion. That's just not understanding or confusing the right that's being given up.
Well, the Superior Court didn't decide on the basis of him not understanding, but I think it's true to say,
right?
I think it's true to say that when he said, if I didn't want to talk, I wouldn't talk, I think that's reflecting back the Miranda warnings. I think it's an indication that he did understand the warnings.
But that was before that was before the police officer took back the Miranda warning aspect that says anything that you say can be used in court.
No, that was actually later. It was actually 2 pages later.
Well,
and it said, if I didn't want to talk, I wouldn't talk.
Mr. Burns,
Justice McCaffrey had
if
a
I can just
question.
ask a quick question, Mr. Burns?
Yes, Your Honor. I'm sorry.
My understanding of the whole Miranda rule is that you're advising somebody of their rights, and more importantly, you're advising them of the consequence of waiving their rights. We have the whole line of cases that talks about police kind of subterfuge and what's allowable, what's not allowable, but in this particular case, I think the Superior Court, Judge Beck, when she wrote the opinion, she was basically saying that the police officer's statement really abrogated the second prong of that analysis, which was, in fact, the consequence of waiving your right to Miranda, which is nobody's using anything in court. How do you respond to that?
Well, under Miranda and under Templin, once the warning and waiver process is done, later events
But
don't
again,
undo it.
we're talking about the initial waiver. You have the right to remain silent, and anything you say can and will be used against you in court. So they're advising of your rights and the consequences. If, in response to the police officer's questioning, he says something along the lines of, are you going to use me in court? He's talking about the consequences of this statement. And the police officer's response is in direct contradiction to the Miranda warnings, which is, we're not using anything in court. So doesn't that go to the voluntariness, and more importantly, doesn't it go to the consequences of waiving the Miranda rights?
It goes to the question of whether or not the statement was given voluntarily. It does not go to the validity of the warning and waiver process,
I'm
which
sorry, I didn't catch the first half of what you said. It goes to the
it
what?
goes to the voluntariness question. It doesn't go to the question of the validity of the waiver under Miranda v. Burbine and Commonwealth versus Templin. Later events don't affect the validity of the Miranda waiver once it's done correctly. It is
Let me ask you a
completed.
question then. What if at the outset the police officer says, Mr. Burns, you have the right to remain silent, and anything you say will not be used against you in a court of law?
Right, but that's not what happened. He was actually told.
Well, that's exactly what happened. Later on down the road, you're saying there was an initial valid waiver of Miranda rights. Later on in the conversation, the police officer abrogated the second half of it, which is, I'm taking the consequences of you waiving it off the board.
I think Your Honor is actually addressing the factual question. What the trial court found was that he understood that when the officer said those words, it was directed to one specific thing, that is, the identity of the person who had shot him. And with that factual finding, it undermines the idea that the defendant didn't understand the Miranda warnings, which he, in writing, said that he did.
So you're saying it was a promise within the context of the interview with regard to a specific item of information, not extending beyond that particular item of information?
Yeah, it indicated an intent not to use the identity of the
Well,
person who shot him.
I think we're supposed to stay away from intent. Are we supposed to view these from like an objective perspective? Do we really engage in the subjective intent of the police officer? Or
Sure.
Okay.
Sure.
But you're saying that the exchange, you all going to use this in court on me, that this is specifically how he responds to the question posed.
The question being, who shot you?
Right, okay. It doesn't extend beyond that question.
That was the trial court's finding, yes.
So when the police officer responded and said, nobody's using anything in court, you're saying that should be interpreted objectively to mean only anything you say in response to this specific question.
Given the context and the circumstances, a reasonable person in the defendant's position would have so understood what was said, and that, again, was the trial court's finding, and it's supported by the record. Thank you, Your Honors.
Thank you.
Thank you, Mr. Burns. We'll hear from Mr. Chisholm.
Good afternoon, Madam Chief Justice, Justices. My name is Walter Chisholm. I represent the appellee in this matter, Keith Phillips. May it please the court. So, the fundamental assurance of Miranda is the right to choose between silence and speech, and that remains unfettered throughout the interrogation process. So I'd like to kind of give an example. Mr. Burns is saying it's a one and done thing. You give him Miranda warnings, and after that, if you waive, you have no remedy if there's a violation of regarding police conduct. Okay, let's say you have a person that's given Miranda warnings. 10 minutes after that, the officer asks, okay, I want to know, did you shoot the decedent? And defendant says, you know what, wait a minute. I think I want a lawyer before I answer that question. Am I allowed to not answer the question? And am I allowed to have counsel? And the officer says, no. You got to keep talking. You can't remain silent. And I'm not giving you a lawyer. That is a Miranda violation.
See, I'm glad you made that example, counsel, because it reminds me of something I was thinking about when I was thinking about this case. Isn't there a distinction between a scenario like you're talking about where presumably in fairly short order after he's Mirandized, a suspect asks questions or makes statements which indicate that he did not understand Miranda. He did not understand the Miranda warning. On the one hand, versus a scenario like this, where the suspect hasn't indicated a failure to understand the Miranda warnings, and there's no suggestion as to confusion about that warning. It's rather a misconduct type analysis akin to the Fifth Amendment cases, isn't it?
Well, I think that the law is saying that it's the words themselves. We can't, I think once we start going into the subjective mental processes of what the detective meant, what the defendant thought he heard or interpreted, then we get into an area that Miranda teaches that we are not to go into. Miranda teaches that we are to rely on the words themselves. And the words in this case are that nobody is using anything in court. And that's what Miranda says we rely on. Once we start getting into subjective intents, and there's a lot of case law out there that says that you're not to look at this from the perspective of the officer. You're to rely on the words and how the defendant responded. And So basically, in this particular case, since we have Miranda that says that the right remains unfettered throughout the entire process, that is that, this isn't, and I think that even the words in Miranda cut against the Commonwealth's one and done theory, right? Because Miranda says it's not one and done, it remains.
Counsel, if I may.
Yes, I'm sorry.
What's your argument, that your client did not know the Miranda warnings, that he was coerced in making a statement? What are you trying to tell us?
I'm trying to tell you, Your Honor, is that the statement by the detective that nobody is using anything in court directly vitiated the prior warning, and that when the detective told Mr. Phillips, the suspect in this case, that nobody's using anything in court, that violated Miranda, and that therefore anything said after that is suppressible.
So share with me, from that moment until the time he evokes his Fifth Amendment and says, hey, I want a lawyer, what in that temporal space shows or proves to us that he was well aware of the Miranda warnings to the point where he exercised them, such that anything he said up until that point is admissible based upon his waiver of Miranda?
So when Mr. Phillips asked whether or not this is going to be used in court, and the detective responds, nobody is using anything in court, at that particular point in time, Mr. Phillips is trying to determine just what the effect of his statement is going to be within the context of Miranda. And I think that that's a reasonable action for a person who, isn't familiar with reading the rights as they are within the context of interrogation.
Under the totality of the circumstances analysis, how should we consider the fact that your client asked that question with regard to identifying the person who shot him, such that he didn't want to be a snitch, had nothing, and that's the series of questions for which he invoked, are you all going to use that?
So I think that what happened is that the Superior Court found that the trial court opinion was unsupported by the record. What happened was that discussion about not being a snitch happened after Mr. Phillips asked, are you going to use this in court on me? And it's in the trial court opinion. The Superior Court opinion made clear the sequence of events, and I think I also made clear in my brief the sequence of events, because the Commonwealth's brief, to the extent, adopts what the trial court said. But if you follow the transcript, and I appended the transcript to the brief, the discussion about gang retaliation and everything like that occurred after Mr. Phillips asked, are you going to use this on court on me? And the detective said, nobody's using anything in court.
With regard to the identity of the individual who shot him. However, when the focus of the investigation or the interrogation was on him as a doer, that's when he invoked his right to counsel.
That's when he invoked his right to counsel, but I'm saying that the Miranda right was vitiated when the detective made his statement. As regard to Mr. Phillips being a shooting victim and that sort of thing, I think that question goes to what I placed in my brief as Rhode Island v. Ennis. The detective's question was phrased in a way that could have elicited an incriminating response.
Well, I'm glad you said that in response to Justice Stocker's question, because that, I think, even if we buy your argument, let's say hypothetically we disagree with Mr. Burns' position and say, okay, something the detective did later could invalidate a Miranda waiver, just for the sake of argument. Would you agree that there would at least need to have to be a causation requirement? In other words, would you agree in that circumstance that the detective's statement would have to cause the suspect to incriminate himself?
I think that Miranda says that those rights are clear, and anything contrary to what is laid out in the Miranda warnings is the violation in and of itself. I don't think that I'm not aware of, the detective's statement having been the cause of anything after. It's the words themselves that violated the warnings, and at that particular point in time, Miranda was vitiated.
Counsel, you're asking for a very straightforward, clear rule, and I commend you for that. But if I understand you, what you're saying is, after a suspect or a person under custodial interrogation waives Miranda, knowingly, voluntarily, all that stuff, if at any point in time during the examination, the interrogators make a statement that is directly contradictory of the Miranda warnings, all bets are off, Miranda reattaches, and they have to be given the warnings again.
Right. I think
so. It doesn't matter, just to complete my thought, it doesn't matter, in your view of the law, what he said that prompted the police officer to make that statement. That police officer could make the statement, going back to Justice Weck's hypothetical, we give you Miranda, you waive, and the police officer says, you know, I know we just did this Miranda thing, and you signed the document, but I promise you I'm not going to use anything against you. In your view of the world, that would vitiate the waiver.
Yes, and I apologize for speaking before you were finished. Yes, I think what Mr. Burns and the Commonwealth appear to be relying on is Commonwealth v. Templin. Right? Templin is not a Miranda case. Templin is a case where a detective, in the course of the interrogation, promised ROR to have a suspect continue with the interrogation. In my mind, there's a big bridge between Miranda and ROR. Templin is a involuntary confession case.
That's a coercion to continue to get them to speak versus under your theory of the case, a statement directly at odds of somebody's constitutional right.
That's correct, Your Honor.
Okay. And it doesn't matter, again, in your view, the contextual analysis the trial court did, the statement that prompted the investigator to say what the investigator said, none of that matters. We look at the words of the investigator in the middle of an interrogation following waiver, and if anything in that statement contradicts the waiver itself, all over, done.
I would, and I would also just kind of briefly provide the sequence of events regarding this interrogation.
But just so I understand, you agree that that's the principle that you're advocating for?
Sure. I would think that Miranda is bright line, right? I think that as soon as the detective's words vitiate what he said earlier, as soon as those words are contrary to what he said earlier, then that's a bright line. And that bright line is that anything that contradicts Miranda vitiates the warning, and that everything after that is suppressible. Yes.
The United States Supreme Court indicated that, ploys to mislead a suspect or lull him into a false sense of security are okay. AKA, cops can lie.
Cops can lie, and cops do lie.
During this Miranda investigation. That's what we have here.
I think that
despite the fact that the question, his response was, are you going to use, I give you the name, are you going to tell the world I'm a snitch? And he said, no, not at all, because technically the Commonwealth could introduce other witnesses, I guess. We're not planning the strategy of the Commonwealth's case. But I'm looking at that. You're trying to get a clear line rule that said once an officer lulls an individual into a false sense of security or is employed to mislead him, that right then and there, we're not allowed to accept it. It's a violation. And that's in direct conflict with the United States Supreme Court.
Not, though, if it is in direct violation, direct contradiction to the Miranda warning. I think that seems to be the difference.
I don't know. We have cases out there. What was the case when the United States Supreme Court said that he would not contact his lawyer was not a violation? You have a right to an attorney. That's in the words of Miranda. The United States Supreme Court said, a police failed to inform a suspect of an attorney's effort to reach him. That is not a violation. And that's a direct violation, if you follow your theory, as to what the language of Miranda said. That's what I'm saying. Police are allowed to mislead, AKA from our SCOTUS. Tell me why we should change it. You would have to do an Edmonds analysis that before we can distinguish our Constitution rights compared to the United States.
So as Justice Todd made clear, I think that a lot of the cases, and I'm not aware of the case that you just cited, but much of the case law says that the officer is not allowed to lie about the dimensions of the Miranda warnings themselves. Certainly he can lie about other things and bring in evidence that doesn't exist, but when you go to lying about what your rights are, especially after you were just given those rights, then that's a bridge too far. In the case that you cited, unfortunately, Justice Doherty, and I certainly didn't mean to jump in before you were finished. I don't have that case in front of me. Your knowledge is a lot higher than mine. But I think,
been around a lot longer, sir.
I think I'm going to be on the ship with the Chief Justice here, and that you can't lie about those warnings, because otherwise the warnings, in my mind, are meaningless.
But the issue, with all due respect, sir, is not your mind, it's your client's. And your client invoked his Fifth Amendment right to an attorney subsequent to that comment. How are we not to take that and glean from that invocation of his rights the fact that he was well aware of his rights and he freely spoke up until the point he felt he didn't want to?
Well, I would think that when he was told that nothing would be used in court, that certainly would have lulled him into a sense of security that he was.
So why would he have invoked his Fifth Amendment if he's lulled?
Well,
2 pages later in the notes of testimony, what's that equal? Maybe 5 minutes?
no, I think that when he was invoked his right to an attorney, that was much further down.
It's about 4 o'clock, I think.
Yeah, and so there was a lot going on, and there were videos and all that sort of thing had been played by then. But when he was told,
It was like 2:30 when that thing about we're not going to use it against you happened.
right?
It's really a fairly straightforward question, and I think the court understands it. We're going to take a close look at it. Do you have anything to say in conclusion?
Yes, and thank you for allowing me to say something in conclusion. I would think that with the hypothetical that I provided, that if a detective gives the warning, and if a defendant 10 minutes after the warning asks the detective, after a question is posed to the defendant, can I have a lawyer? And the detective decides to lie and says, no, you're not entitled to a lawyer and you have to keep talking. I think that is conduct that many courts would find reprehensible. I think that would be a direct violation of Miranda, especially with the language that right to choose between silence and speech remains unfettered. And with that, I think that the answer to the question that this court posed would have been answered in the hypothetical that once a valid a waiver is provided, that conduct by the police can certainly vitiate that waiver.
All right, thank you, Mr.
Thank you so
Chisholm.
much.
And,
Pleasure.
Mr. Burns, it's nice to see you back in our courtroom. I trust you're feeling well? Good, welcome back, welcome back. Would you call the next case, Mr. Minner? If I can find Mr. Minner, there he is. Thank you. Good afternoon.
Good afternoon, Your Honor.
This is a medical malpractice case brought by the estate of a 41-year-old woman who succumbed to cancer against the oncologist who treated her initially for breast cancer after a pathologist concluded a biopsy of an enlarged lymph node in her shoulder area revealed the presence of that disease. However, that diagnosis proved to be inaccurate, and the woman was actually suffering from a rare form of cancer known as ALK-positive large B-cell lymphoma. In its malpractice suit, her estate alleged that the oncologist negligently failed to properly consult with the pathologist who misdiagnosed her type of cancer, thereby delaying her receiving the appropriate treatment and causing her direct injury because the misdiagnosis and delay led to the cancer growing and spreading throughout her abdomen, which decreased her chance for a better outcome, and substantially decreased her chance for a longer life. At the end of the estate's case in chief, the trial court granted the oncologist's motion for a non-suit, agreeing that the estate's expert testimony failed to produce sufficient evidence to show that the oncologist's conduct was a substantial factor in bringing about harm to the plaintiffs. The Superior Court reversed. The question for our court is whether the Superior Court, in reversing, properly applied the standard articulated in our decision in Hamill v. Bashline, which requires a medical malpractice plaintiff to present expert testimony which establishes to a reasonable degree of medical certainty that the medical professional's conduct created an increased risk of harm to the plaintiff, and that the plaintiff, in fact, sustained such harm. Please proceed.
Thank you, Your Honor. That was a very nice summary. Good afternoon, Your Honors. My name is Michael Badowski. It's been my privilege over these many years to represent Dr. Annie Kannarkatt. I think it's important at the outset that we have a clear understanding of the undisputed facts of this case. In 2016, Tanya Smith developed pain in her shoulder. She went to an orthopedist. The orthopedist ends up doing some cervical spine surgery. Ultimately, Mrs. Smith has an MRI which reveals suspicions of metastatic lesions. She goes to an oncologic surgeon who biopsies it. Biopsies the lesion that was seen on that MRI. This is months before she ever comes to Dr. Kannarkatt. The specimen was sent to a well-established pathology lab at WellSpan in York. It was interpreted by Dr. Wright, who was originally a defendant in the suit, as well as the other healthcare providers involved in her care. He diagnosed it as adenocarcinoma, most consistent with breast cancer. There was not a doubt in his experienced, educated mind that this was a carcinoma, not a lymphoma. He made that perfectly clear in the two trials that he participated in. Dr. Wright himself indicated that in terms of cancer diagnosis, the buck stops with pathology. There's a phrase in medical oncology, usually used only by medical oncologists, I think, and the phrase is, without meat, don't treat, which in essence means medical oncologists necessarily have to rely upon what the pathologist says the cancer is, identifying it under the microscope, identifying it histologically. In this case, it was not only Dr. Wright who looked at these pathology specimens, but two other board-certified pathologists looked at the tissue themselves. They too came to the exact same conclusion. And one of the pathologists was in fact a hematopathologist, a person who is specifically trained in looking for lymphomas. He called it carcinoma, not lymphoma. So this is all before Dr. Kannarkatt ever became involved. Then the case was submitted to the WellSpan Tumor Board, which is, you may be familiar with it. There's a multidisciplinary group of healthcare providers, specialties. They look at various cases. It was concluded there, through the Tumor Board, that we're dealing with adenocarcinoma, most likely of breast origin. And keep in mind, Your Honors, that as of February of 2017, Tanya Smith had metastatic stage 4 cancer.
So, counsel, if I may interrupt you, I'm trying to follow your logic. Are you sharing with me, the way I understand this, was the pathologist's diagnosis was endocarcinoma, glands around the breast of the heart. That was in 2017. The oncologist performed chemo and radiation. The chemo showed no improvement, radiation slight. Then in 2018, the cancer moves to the stomach or the abdomen. And then 2018, the gallbladder is removed. A new pathologist declares that it's the ALK positive diagnosis.
That's correct, Your Honor.
With those facts, if the oncologist is introducing chemicals to the patient based upon the pathological diagnosis with no positive response, isn't it incumbent upon the oncologist to communicate with the pathologist to discuss this? And the fact that that didn't happen, did that not increase the risk of harm?
Well, I'm not so sure. I don't have that extent of medical oncology knowledge, Your Honor.
But it's a simple question.
Well, it is a simple question, but it's for the oncologist to come to that conclusion, given that she's presented with the diagnosis of stage 4 adenocarcinoma. Your Honor's question is assuming that everybody receives or appreciates the same reactions to chemotherapy and radiation. And no two patients are alike.
That's absolutely not part of the question. The question is, or the comment, or the concern that I have is that the oncologist introduced the chemicals based upon the pathological diagnosis. Therefore, the oncologist should be aware of the presence or the results based upon his or her experience as to what is treatable for that type of carcinoma. It was, in fact, not treatable, slight. And in fact, when you find out it's the ALK positive, it's a completely different type of diagnosis.
I could only answer that based upon my experience, and that is, no. Medical oncologists, when they come up with cancers that they're intransient, they're having difficulty achieving remissions, they tweak the chemotherapy. They instill different modes of therapy to treat the cancer that they were told existed. You don't pick up the phone and say, oh, Dr. So-and-so, are you sure this is carcinoma? In my experience, I've never seen any medical oncologist do such a thing. What they do is they try to manipulate or change the chemotherapy in order of hopes of achieving a favorable result. It doesn't always happen. And frequently it doesn't happen. Stage 4 breast cancer is a killer.
Counsel, may I, right up in the middle, Justice Donahue, let me add a couple of facts from the record to add to Justice Doherty's question.
Yes, ma'am.
What your client had that the pathologist did not have was a CT of the chest, a diagnostic mammogram, a diagnostic ultrasound, and a PET scan, none of which were consistent with the diagnosis of breast cancer.
No, Your Honor. What you're saying is true in the record, but what that means is that those studies were performed to assess the extent of the disease.
Okay, well, let me go on, because there was a standard of care expert in this case that contradicted just about everything you just said. The plaintiffs had an expert on the standard of care for an oncologist, and that expert on the standard of care testified that it was in fact the duty of this oncologist under these circumstances to consult with a pathologist on the chosen course of treatment.
Yes, ma'am.
Okay, well, that gets him to the jury on that question, does it not?
Well, on the standard of care.
Okay, well, that's all you've been talking about. I mean, that oncologists don't do that, and oncologists only follow what the pathologist said. I mean, you may have had an expert who said exactly that, but there was an expert in this case that said something entirely different. And actually, we have the increased risk issue, and I'm interested in your view of that.
Let me try to focus a little bit more. Okay, and your analysis is correct. Okay, but in this case, what we're talking about is their theory, the estate's theory, was against Dr. Kannarkatt, was that she should have picked up the phone and communicated.
Yeah, but counsel, let me interrupt you here, because we have been letting you kind of go on this duty and breach thing and standard of care. We only took the issue of causation, at least as I understand it. We took Hamill and Bashline. We're not here to talk about whether your client had a duty, whether your client breached the duty. We're simply here to talk about whether the expert report that was used to say that the alleged breach of the duty increased the risk of harm.
I'm trying to get there, Your Honor.
Well, but that's where you should have started, because that's the only issue we took. So if you could get to that really quickly, I'd appreciate it.
Because I think they're linked, but I will do that, okay? Their standard of care expert, and if you go back to Hamill, you know, the Hamill court, and it was the Venerable Cyril Wick who gave the testimony, used the words considerable chance of survival. The case law speaks in terms of substantial possibility of survival. In this case, there was no pathology expert called by the estate. There is an evidentiary nexus on causation that's missing here. And that nexus is, what was the standard of care of the pathologist?
I think let me push back a little bit. I think their claim is simply, you know, breaking it down into its most simple form, is had your client discerned the proper diagnosis, or had any medical professional, whoever the defendants were, discerned the proper diagnosis within appropriate period of time, there was a increased risk, or there was that your failure to do that increased the risk that she would not live longer, increased the risk that her death would occur sooner, and that for a family, that's precious days with their loved ones that they had no hope of having. No hope of having. Now, would they have had it? That doesn't seem to be what Hamill requires. Hamill only requires, was there an increased risk that prevented them from that hope, from that happening?
Well, let's talk about ALK positive large B-cell lymphoma then. Current to the time these cases were tried, Your Honor, there were only 150 reported cases worldwide of this disease. By the time it's diagnosed, statistically, there is a 8 to 22-month period, and then you die.
Counsel, I know where you're going. Let me interrupt you just for a second.
Sure.
Well, your problem is there's an expert report. Your problem is there's an expert report on the other side. I mean, and you may disagree with the expert.
No. Dr. Sofer is the expert you're referring to. And if you read his testimony, you will see that it's total equivocation. He admits that there is no recognized standard of care treatment for this disease. He recognizes that statistically, Tanya Smith was going to die. She, in fact, outlived the norm for this disease.
Isn't your argument go to the damages and not to the causation? I mean, as I understand Hamill versus Bashline, the plaintiffs have to show that the physician failed to exercise reasonable care, and they had an expert that said that. And then 2, such failure increased the risk of physical harm to the plaintiff. So what you're arguing before us here, and they had 2 experts that said that Dr. Kannarkatt's care substantially deprived Miss Smith of an opportunity for a longer life. So what you're arguing to us is just merely what you could argue to the jury about the damages.
I disagree, Your Honor. And I'll quote. This is from SOFR, their causation expert. Question. So you can't say with any degree of certainty that had ALK positive B-cell lymphoma treatment been provided at the outset, her course would have been any different. You can't say that with any certainty, can you? His response was, I don't know what her survival would have been.
Well, that's why Hamill exists, because no one can say that with any level of reasonable, let alone medical certainty. But Hamill allows, in these situations, an expert to opine that maybe death was the ultimate outcome regardless of the diagnosis, but what was deprived was the opportunity to potentially live longer or have not have your death hastened.
Yes, Your Honor, you're right. And the plaintiffs in these settings are required to give the jury at least some indication as to the likelihood of that happening, the likelihood that this woman would have been, the one out of the 150.
No, I think didn't the expert here say something to the effect of, if the diagnosis would have happened earlier, she could have gotten into some form of a treatment that may have, to a reasonable degree of medical certainty, extended her life beyond what it was.
And, Your Honor, I don't think that's enough under Hamill.
He said a substantially better opportunity for a longer life beyond when she died. That's testimony.
And if you continue to read his testimony, he qualifies all that. He recognizes that there is no standard treatment for the disease, and that, at best, there's a hope that the person might be the one who will have favorable...
Well, favorable just means one more day.
Pardon?
Favorable for a family dealing with a cancer diagnosis means just one more day.
But there has to be some evidence of that, Your Honor. You just can't have...
How would an expert prove that?
If the Superior Court is right, all plaintiffs need is to have the magic word said by an expert. It increased the risk of harm and prevented he or she from having a more prolonged life. That's all they need to say. And I don't think that's what Hamill stands for.
What do you think, a percentage is needed?
I think it has to be equated to what the law demands of reasonable medical certainty. The law says this is not 50-50.
Well, Soifer did say all of his answers were given to a reasonable degree of medical certainty.
Yes, he did.
So
again, magic words without substance is meaningless.
Well, isn't substance for the jury?
I submit, Your Honor, that the jury cannot be presented with the case, and this is what Judge Mangus wrestled with. He heard this testimony. He felt compelled to exercise his gatekeeping responsibilities and say, this is pure conjecture. I really can't let this go to the jury. He was doing his job. There is no evidence to give to the jury, okay, well, he's saying there was an increased risk, but how much was it increased by? How was the jury supposed to make that determination? Would she have lived a day longer? How much is that worth?
Well, only God knows that,
Your Honor,
only God knows that.
The point being is you can't just simply say these magic words without giving the jury some idea of what you're talking about. Some percentage has to be. And again, I equate it to the reasonable degree of medical certainty that the law demands. It's not 50-50. Okay.
Again, I didn't see in Soifer's testimony him saying it's 50-50.
Oh, he didn't. I'm just answering your question. regarding he said
What I'm not clear on is whether you're saying Hamel was violated, or you're saying you want Hamel to be amended by us.
I want further clarification of Hamel.
Well, I'll re-put my question. Are you standing here today to tell us that the Superior Court's decision runs afoul of Hamel versus Bashline, or are you standing here to ask us to change the rule of Hamel versus Bashline?
Both. The reason why I say the Superior Court misapplied Hamel, because my interpretation of Hamel is that it requires significantly more than simply an expert saying it increased the risk of harm.
Counsel, can I follow up on that right here in the middle again?
I don't know. We were classmates at Duquesne, you know.
Oh, is that right?
Yeah.
Oh, there you go.
Yeah, we're senior members.
Dukes.
We're senior members of the bar now.
If we had time, you could tell us all the stories.
Go Dukes. So let me just sort of clarify, I mean, for the sake of our discussion here. The plaintiff's expert did a whole lot more than say, oh, just increase the risk. I mean, the plaintiff's expert was very clear in saying any chance that this patient had was taken away by the defendant's conduct for two reasons. It was the delay in using the appropriate treatment for the type of cancer that she had, and secondly, by using the chemotherapy that was inappropriate for such a long period of time, it debilitated her to the point that even using the new drugs would not have been effective. So, I mean, that's a whole lot more than saying, oh, it increased the risk.
Your Honor,
I mean, he went into a lot of detail on these the consequences of the failure of the defendant in this case.
if you continue to read Seufer, he uses the word in the hopes that the treatment for ALK-positive lymphoma would work.
Campbell says when a defendant's negligent action or inaction has effectively terminated a person's chance of survival, which is exactly what happened here, according to the plaintiff's expert.
See, I disagree with that.
It's from Hamel.
Well, no, I don't. That's what Hamel says, and I agree with that. Okay, but what I disagree with is your position that Seufer gave that evidence to the jury.
Well, because you equate Hamel with survival.
Correct.
You are saying that Hamel only applies in cases where the person would have lived and eventually succumbed to a natural death.
No, that's not what I'm saying.
Well, it sounded like that's what you were saying.
No.
Because so do you believe Hamel can apply where the negligence eliminated the chance to live longer than they did?
Yes.
Okay. Isn't that what this case is about, the chance to live longer than she did?
Well, it is, and it goes to the evidence required under the law to allow the jury to make that decision. That's what I'm talking about
Do
here.
you agree with the proposition, counsel, that in increased risk of, I mean, this has been a recognized theory since at least Hamel. So, do you agree that in increased risk of harm cases, causation is proven in a way different from conventional professional negligence cases? Necessarily because, you're proving a negative, so to speak.
I do agree with that. I agree with what you said.
Okay, so given that you subscribe to you subscribe to Hamel, I take it then. Why isn't this just a battle of the experts and the jury's going to have to make a decision? Because
it's the quality of the evidence that the expert provided that's deficient here. My understanding of Hamel is that an expert needs to provide the jury with at least some basis for them to conclude what that chance was, what that risk was. None of that happened here. Seufer spoke in terms of hoping that treatment that has never worked for anyone else will work this time.
It is true that in Hamill, an expert who happened to share my last name, or whose last name I happen to share, did give a number. But the post-Hamill cases have never held, have they, that you need a percentage?
No, they've never said that.
But
Okay.
is that what you're saying?
I'm suggesting that again, I'm coming back to what Your Honor started with. I'm coming back to the legal requirement that is viewed upon in the law as what it takes, what reasonable medical certainty means. It's not 50-50. It has to be greater. It's not probable. It's not possible. It's not maybe. It has to be more than a simple chance. I'm saying that Hamill equates the rule of increased risk to the degree the law demands in the reasonable medical certainty definition. You understand?
Thank you.
A final question from me. I'm not sure, hearing your argument, that we're actually as focused on what did Hamill mean or how is Hamill interpreted today as we are on the error review that you seem to be asking us to conduct on what happened below. To me, this is sounding more like error review.
Well, again, Your Honor, I think it's both. I would like this court to provide a clear definition of increased risk of harm, to equate it to what the law demands with respect to what the definition of reasonable medical certainty is.
And you'd like that to be a percentage?
Well, I'd like it to be just like reasonable medical certainty. It has to be more than 50%. It has to be more than just mere possibility.
Counsel, can I just, we did look at this entire issue of the statistical uncertainty of survival in 1990. Former Justice Cappy wrote the opinion in Mitzelfeld. I mean, and looked at the issue and held that a defendant can escape liability because of statistical possibility that harm would have resulted without the negligence.
Well,
I mean, we've addressed the issue that you're raising. She would have died anyway. I mean, that's your defense. I mean, in this.
Well, there's no question about that.
I'm not being sharp, but see, we looked at that, and so you can't rely on that. If any chance of further survival in this case was taken away because of the defendant's negligence, that's what Hamill v. Bashline is. It goes to the chance.
Yeah, but if you look at Hamill talking in terms of considerable chance, the language of Professor Licht, okay, it's intended to demand evidence on a prima facie basis to permit the jury to make an assessment as to what that increase was. Is it now, if the law is going to be, if it increases it one more day, if it prolongs life one more day, then so be it. Then say that.
All right, we understand what you're asking us, and if there are no other questions by the justices, we'll hear from Ms. Leidecker.
Thank you, Your Honor.
Thank you.
You folks have an interesting potpourri of issues.
We do. Thank you, Mr. Badowski.
Thank you, classmate. Yeah, got it. See you there.
You want to pull that mic down? Pull it down a lot. Yeah. Thank you.
Good afternoon, Chief Justice Dodd and honorable justices of the Supreme Court. May it please the court, my name is Andra Leidecker, and here on behalf of the estate of Ms. Tanya Smith. At counsel's table are Mr. Thomas Hall from the Adley Hall Law Firm in Lancaster, Pennsylvania, who represented the family at trial, and Mr. Charles Becker.
Who needs no further introduction.
He has received his introduction from you earlier today. Let me pick up with Hamel and Mitzelfeld. In Mitzelfeld, the court discussed two separate concepts with respect to medical certainty. And I'm going to start from there because the first portion of what Mitzelfeld called Test 1 and Test 2, Part 1 and Part 2 of the test, the first portion of it truly addressed the causation issue. And what Mitzelfeld said was that an expert testifying to causation is required to testify to a reasonable degree of medical certainty that the negligence that is at issue in the case increased the risk of harm and ultimately led to the injury complained of at trial. So taking that framework and applying it to the facts of this case, what we have is Dr. Soifer testifying that the delay in the diagnosis of lymphoma increased the risk of Ms. Smith succumbing to lymphoma. And as your honors have discussed at some length, that opinion had a lot of texture.
Counsel, can I just interrupt to clarify? Are you saying increase the risk that she would succumb to lymphoma, or increase the risk that she would succumb to lymphoma sooner than she would have had?
Thank you for that clarification. The injury complained of was death. So the testimony was that she died.
Right, but are you proffering an expert to say she would not have died if there hadn't been the negligence?
Absolutely. I mean, so
I don't think that's what the doctor testified to.
So that's the second part of the Mitzelfeld conversation, right? Because Dr. Soifer was asked, would she have lived? And what he responds is sort of to go back to actually what he responds is, he's not capable of predicting this alternate future, right? So he testifies to that portion of his testimony. He testifies that he could not have predicted the future. But what he does testify, and he prefaces that with, I do know, is that she would have had the chance to live longer.
Right, exactly. Which seems, I mean, I'm just trying to get to what your expert actually testified to. I mean, it would be a very straightforward case if there was a misdiagnosis, and the misdiagnosis was they treated her for one cancer that was extremely aggressive versus another cancer that had a 95% success rate if treated properly, and she succumbed unnecessarily to an aggressive treatment that if she would have gotten the right treatment, she would have lived. That's not this case.
And I'll grant that would be the stronger case. But as Justice Mundy actually pointed out, that testimony about the percentages really go to the question of what would have been the extent, how much longer would her life have been extended? What are the damages?
Right, but do you have any expert to say that? I mean, do you have any, I mean, I know we're not taking this as a damages kind of a case, but I was completely understanding the causation side before you started talking. I'm sorry. But is your theory of the case that she would have lived? Or is your theory of the case is that she had a chance of living longer? Because the latter, I think, is probably pretty good under Hamel. The former, you probably have a problem with the fact that this was a very aggressive form of cancer, and your expert did not testify to a reasonable degree of medical certainty that she would have survived that particular cancer if she was treated in time.
So the expert testified actually to both, because those are the facts of the case. So there was a portion of the testimony that discussed the idea that if treated with appropriate lymphoma medication, 8 to 20% of the folks with her stage of lymphoma that get treated with general lymphoma therapy, and in that sense, what the testimony trial was is that there is not a specific lymphoma treatment for this particular lymphoma, but that doctors treat non-Hodgkin's lymphomas like this one in very similar ways, and therefore there are a lot of options for treatment, and of course Dr. Soifer goes through those particular treatments. And
but he could not testify to a reasonable degree of medical certainty that they would have been successful.
what he said was that he couldn't, that what we do know, and the law does, and in Judge Sircone's words in Hamill, the law does not require knowing the unknowable. So I think that that's very apt here, right? Because what he was asked on cross-examination to testify to was what would have happened in this hypothetical future. So what he testified to a reasonable degree of medical certainty was that the delay in the diagnosis caused her injury. Then he was asked further, how much longer would she have lived? And to that point, he says, effectively, what you said, only God could know. So the two portions of his testimony meet exactly what Mitzelfeld actually said. Because you might recall that in both Hamill and Mitzelfeld, a lot of these, the arguments that were being made was for Pennsylvania law to require a certainty about survival. In fact, that was the basis on which the trial court dismissed the case in the first place, the Hamill case in the first place, because Dr. Weck testified that yes, if the patient had been given the appropriate medications for his heart attack, he would have had, that the failure to give the medication increased his risk. And when further asked, so that was his causation opinion, and he gave that to a reasonable degree of medical certainty. And when further asked, what is the percentage that you believe in your experience for him, how long would he have survived? He says, in about 75% of cases, this works, but some percentage, and he says approximately. And what the Superior Court said in the initial Hamill 1 opinion was that Dr. Weck's testimony was sufficient to meet the causation, to meet the requirement to submit his causation opinion for the jury's deliberation. And the second part of it was this discussion of, do we require 100% certainty that this would have been a successful treatment, and therefore he would have survived 100%. And the Superior Court responded no, and then 2 cases later, the Supreme Court in Hamill 3 agreed with that analysis. So in that, so going back to the idea that the argument is proposed, the argument about percentages are being proposed as undermining causation, but they should be recognized for what they truly are. They are measures of damages, just like Justice Mundy talked about. Because, and let me give you sort of a foil to this example of medical causation. Let's say that there is a very clear intersectional collision between a red car and a blue car, and the plaintiff is severely injured, and there is testimony at trial about the standard tables of life expectancy. And this also goes back to the idea of outliving your life expectancy. In those cases, there are going to potentially be experts who testify that this person might have lived longer or less time. But all of that testimony gets placed into the lane of damages. And even thinking about it, just stepping back and looking at it, that doesn't actually undermine any of the actual causation testimony of what happened in terms of red car, blue car. So in these cases where we have a pre-existing cancer and we have a doctor treating a cancer, Hamill, Mitzelfeld, they all recognize that these are concurring causes that end up resulting in one injury, and perhaps one might have led to the injury on its own. But in these types of cases where the physician has the ability to treat the patient with appropriate treatment, the negligence is capable of increasing the risk, and the negligence is also gives rise to an injury. And the extent of that injury is simply a measure of damages, how long they may or may not have lived. in that respect, the testimony in this case was entirely appropriate.
You don't, but and I'll just prod one point further, make sure I understand your point, is to the extent the cancer that she had was not survivable, period, a matter of general medical knowledge, that in your view would be a battle of the experts kind of thing. They would have, where your expert on causation said, I have no idea, or I don't know what would happen, they could bring in an expert to say, in my expert opinion, based on my years as an oncologist and treating patients with this disease, there is no effective treatment, death is certain. How would that have impacted your case?
Well, if you don't have expert-supported trial, then you probably would not actually get into a courtroom. Your hypothetical was...
I'm saying you don't, in your view of Hamill,
right.
You don't have to establish a chance that she would survive at all. It's sort of presumed in the Hamill construct. You would then have the defendant, if they want to cut you off, come forward with an expert that says, no, death was certain. Reasonably, and it would go to a jury, obviously. A jury would have to decide whether to find the expert credible or what have you. But you think that's enough to get to a jury, let the jury decide, I believe the defense, if they want to, I believe the defense expert, this cancer was not survivable, death was going to happen. We're now only looking at whether the negligence robbed her of the chance of more days with her family.
So let me, again, sort of respond to your question this way. Hamill requires expert testimony that a doctor offers to a reasonable degree of medical certainty that the negligence increased the risk of the injury, and then the injury actually occurred. And the expert is obliged to connect the dots from the very beginning of the negligence to the ultimate injury. The question of how long one actually would have, so the expert, in the course of that explanation, just as in this case, and I'm going to speak to this case in the sense that Dr. Seufer actually did testify that there was a treatment for Ms. Smith's cancer, and in fact, even at the time, at the delayed time that she actually took this treatment, she may not have responded to the frontline epoch treatment, but she did respond and was almost in complete remission using the ice salvage treatment. And that treatment allowed her to go a step further and actually have the bone marrow transplant. And the bone marrow transplant, and let me also explain that the percentages of 8 to 20% really discuss the survival at 5 years with chemotherapy only. What Dr. Seufer also explained was that the chemotherapy is the pathway through which you get to a complete or a partial remission, and that increases, and that permits the bone marrow transplant that then actually can provide even a complete cure, could have provided a complete cure for Ms. Smith. So there was actually a pathway for Ms. Smith to get from her, that was documented in the literature and also from Dr. Seufer's experience. And of course, he is a physician, a lymphoma expert at the Dana-Farber Institute at Harvard University. So he has a substantial amount of experience with lymphomas. He provided that pathway for how, for the chances of more time, but also even a potential cure for Ms. Smith.
All right, do we have other questions? All right, do you want to wrap up, Ms. Lydecker?
Thank you, Chief Justice.
Okay, thank you.
Thank you very much,
Thank you.
counsel.
Thank you all. Would you call the next case, Mr. Minner?
4D in the case of Soland versus the zoning hearing board of Bradford Twp in Bradford Twp, fire jurisdiction on March
over.
Representing East Bradford Township, Mr. Max, representing Soland, Mr. Mezzanotte Jr., representing Marshall, Mr. Andy Reed.
Appellees own property in East Bradford Township consisting of nearly 11 acres upon which they wish to operate a bed and breakfast. The property contains several structures, including a residential home called the Paxson House, which is zoned as a Class 1 historic resource, and an unoccupied structure known as the Tenant House, which is zoned as a Class 2 historic resource. Because the township maintains a zoning ordinance that restricts bed and breakfast estates to owner-occupied Class 1 historic structures, appellees sought a use variance to permit them to place the guest rooms for the bed and breakfast in the unoccupied tenant house and not in the owner-occupied Paxson House. The East Bradford Township Zoning Hearing Board granted appellees use variance, implicitly finding that the requested variance was de minimis. Neighboring property owners, the Solands, and the East Bradford Township Board of Supervisors each separately appealed. The trial court reversed the zoning hearing board's decision, concluding that the de minimis doctrine was reserved exclusively for dimensional variances and not use variances. The Commonwealth Court reversed, holding that the de minimis doctrine could apply to a use variance and that the variance requested in the present case represented the rare circumstance where application of the doctrine was appropriate. In these consolidated appeals, we are asked to address whether the Commonwealth Court erred in holding that the de minimis doctrine can be applied to a use variance. If a use variance can be de minimis, we are asked then to address whether the Commonwealth Court erred by affirming the board's decision to grant a use variance under the circumstances of this case. Good afternoon.
Good afternoon. May it please the court, Chief Justice Todd, members of the court. My name is Andrew Rao. I'm here today representing East Bradford Township as appellant. An additional appellant are the Soland parties. They're represented by John Mezzanotte, who is also here. In order to avoid duplication of the appellant arguments, we find in this case the township and Soland's positions are very similar and complementary, and so as a result, my task, if the court sees fit, is to address the first question, which really looks at the court's precedent and the Commonwealth Court's own precedent, not only yours, that a de minimis variance can only apply to a dimensional case. And then Mr. Mezzanotte will deal with question 2 in more detail, which is more the factual and case detail of if the court sees past the idea that there is no such thing as a de minimis use variance, would the application of the marshals itself be de minimis?
All right.
So with that, so as the question 1 and the de minimis doctrine for practitioners across the Commonwealth in the MPC era, and when you look at this court's cases going back sometimes in the 40s through the 70s, we've always understood, and we believe the courts have always understood, there are really 3 hierarchies in a variance case. The first being use variances, which have the highest standards, the compliance with the 5 MPC, the statutory provisions in 910.2. Then we have the dimensional realm, which since Hertzberg in 1998, this court advised practitioners that dimensional relief is of somewhat lesser moment compared to the traditional variance standards. The idea being in Hertzberg that a use variance overrides the legislative judgment of the local government as to what uses are permitted, whereas a dimensional variance is sort of tinkering around the edges, usually setbacks, height, A lot of the reported and unreported cases at the Commonwealth Court level sometimes deal with mere inches or a foot or two in terms of a setback.
Well, and that's what makes dimensional variances so subject to a de minimis analysis, is because they're objective, they're measurable. You can say, well, it's only 6 inches, it's de minimis. A use variance, that's not so objective, and that's not so obviously susceptible to a de minimis or triviality kind of analysis.
Correct, and we would agree with that. And
Let me. Of course, you're going to agree with that, which makes sense. But let me probe there, because here we are. This is in play here now. Why should we give the dimensional versus use inquiry primacy over the de minimis inquiry? Why should we do that?
And I think that goes to Hertzberg, where the court itself said that if you are excusing a use, you're directly contravening the more important legislative determination of what uses are permitted in which zones. So, for instance, in this case, this is an R2 zone. Bed and breakfast estates are allowed for adaptive reuse, but I believe that the township's intent, when you look at the ordinance, there are measurements of how big your entertaining area is based on people, the bedrooms in the living area and the common area in the residence.
You see, I'm glad you said that, because that's why the chief's question got me going on this, because this case, when I was reading this case, it struck me as a bit of a different animal. It's almost like a quasi-dimensional case, because you're talking about, first of all, for some reason, and I'm not sure, maybe you can elaborate, the tenant house is class 2 and the Paxton house is class 1. I don't know why. And they're only 150 feet between them.
They could be connected.
They could be connected. It could be a breezeway. These people are walking from one to the other. So the dichotomy, I understand the Hertzberg formulation, this dichotomy, use and dimension, but like you can understand a use variance between like a restaurant and a dry cleaner, or a restaurant and a home. But in a dimension, on the other hand, I need my ceiling to be 15 feet instead of 13 feet. But this case is not such a clean dichotomy. And I'm wondering why we shouldn't treat this case as an opportunity to expound on our zoning law to allow for what I'm calling a quasi-dimensional case. I mean, in other words, you agree there's no statutory bar that would preclude us from doing that. We might need to do case law tinkering if we were to do that.
Well, I would say that there is a statutory bar, and I think as Justice Todd and Justice Donahue joining in metal green, the court stated that in zoning matters, that the court should act with caution and restraint, and relaxing variance standards are better addressed by the General Assembly. There are, I would say, hybrid cases. You see them in the Commonwealth Court, sometimes with steep slope, sometimes with driveway. In this case, I think directly to your question, Judge Seisler in the Commonwealth Court, in her dissent, really hits the nail on the head, which is this ordinance was designed for in the living space to allow a B&B estate to have people there with the property owners, a traditional bed and breakfast.
Which gets it much more into the use category than the dimensional category, because it makes a lot of sense that someone be living, it's not a hotel. Someone be living in the bed and breakfast who's subject to the same conditions. You're less likely to have, the water not working, or the pipes not operating efficiently if the owners aren't living in that house.
Correct.
Counsel?
And Judge Seisler said, if we allow this, she didn't see the difference between that's a motel or a hotel. Right. And we think the dissent got that piece of the lower court decision correct.
Counsel, middle again. You would agree that if the only variance at issue here was based upon the fact that this was a Class 2 historical building as opposed to a Class 1 or vice versa, would you agree that that would be de minimis and that variance could have been granted?
If that was the owner's residence, I would agree that that's a closer case, because in this case, we really have three issues. We have...
Yeah, I understand that. I'm saying let's assume that the only thing that was required under these circumstances was that it was a Class 2 historical, and this is a Class 1. You would say, I would think, de minimis.
I would say, from the township's point of view, that that's still a closer to a use question, because what the township was trying to do was allow for adaptive reuse of the most valuable, in terms of history and historic protection, the most valued assets to give an incentive for adaptive reuse. Class 2 and less, I would say, less so.
Council,
I'm
So
sorry.
you're a purist. You're a purist on this. You would say no de minimis, even if it's that distinction between Class 1 and Class 2, which I could not articulate to you sitting here what that difference actually means.
In our case, because there are really three things: Class 1, owner-occupied, and that same ordinance provision says that you cannot have the use in an accessory building. In our case, all that is clearly use. If it was just Class 1 and Class 2, hypothetically, I'd say I'm somewhat of a purist because of the township's interest in having adaptive rehabilitation of the Class 1. I'm sorry, Justice Doherty.
You answered
Okay.
the question I was going to ask.
Adaptive rehabilitation meaning an owner-occupied B&B in a historic building. Is that what you mean by adaptive rehab?
Yes, and allowing it in all zones in the township.
And the idea of people owning a property that has outbuildings and it's a complex of historic homes in close proximity with one another. You don't think that our case law ought to allow for any kind of de minimis analysis in appropriate circumstances? You think the use line in this context is drawn by if the owners are putting their heads on the pillow in that building?
Yeah, I'd say that Nettleton, in a footnote, gives the court's clear precedential view of exactly what the de minimis standard is, and that is that it's limited to the grant of dimensional variance relief.
Counsel, would you agree that with a simple, maybe it's overly simplistic and you can disagree with you one, use variances deal with what can be put on the property, dimensional deal with how?
Yes, I would say what can be put on a property and how it operates or is used, and dimensional is if all of that is okay, are we less worried about
So my view was too simplistic then, I apologize. But the point is, in some zoning ordinances where municipality will draft an ordinance to allow for a particular use, when they define the use, they might include within the definition certain dimensional characteristics. For example, they may say, we allow wedding venues, but the square footage of the venue for the wedding has to be at least 2,000 square feet at a minimum. And that's in the definition of what a wedding venue is. If I have a venue that I want to be a wedding venue and it complies in every other respect with the use ordinance, but I can't get 2,000 square feet, I can only get 1,998 square feet. Would that be a use variance or a dimensional variance?
I agree that's a closer case and maybe closer to dimensional. I think if you look at the Commonwealth Court's own precedent until this case, in Coyle, asking about that difference between what is a use. In Coyle, I believe, single-family property, it's an attorney who wants to convert 2 bedrooms into law office use for other attorneys. Coyle says that that seems factually interesting, but they cite their own precedent to say that would be a blatant disregard of our precedent and the Supreme Court's precedent, including in Podrosky, that de minimis is limited to dimensional.
Yeah, and I'm trying to get to, I was trying to just explore the difference between a use and a dimensional variance. So the other sort of question I have is in response to Justice Weck's question to you, where in the MPC does it allow the grant of dimensional or de minimis variances?
Yeah, I think if you look at Hertzberg...
Where in the MPC?
Yeah, I don't think you'll find it.
Okay.
Yeah.
Where in the MPC does it talk about a lesser standard for use, for dimensional variances than use variances?
I would say in part, again, you won't find that. I think when you look at Hertzberg, I think it's this court's attempt to coincide both the MPC with its own precedent over the years.
So we create, so Hertzberg is a judicially created exception to the MPC for a lesser standard of variance than what the General Assembly provided for dimensional variances. And it has been stated to be a very narrow exception or narrow application, correct?
Yes, but I would say that the MPC says that it incorporates prior law to the extent not inconsistent with the MPC, and I think the Supreme Court's own precedent in the 40s and 70s, Podrosky appeal of Crawford, has always said, especially as to de minimis, that there is a dimensional exception from the hard variance standards.
Aren't you granting it? I mean, in response to Justice Probson's questions, aren't you granting this is a judge-made distinction, and since it is a judge-made distinction, we could tinker with it at the margins. We could tinker with it at the margins. This quasi-dimensional term I threw out there just off the cuff. It's not beyond the. It's certainly not violative of anything in the MPC. You'd have to grant that, wouldn't you?
No, I think to excuse a use variance not having to deal with the MPC, again, I think dimensional is an interpretation of what is the purpose of the MPC, and this court has always said that the higher thing that the MPC is trying to protect is use.
And I guess let me just ask it one more time. Do you insist that every kind of variance application must be dichotomized in this way? Are you saying there is no variance application which you could imagine, be it this one or any other one, that could partake of aspects of both dimensional and use variances?
I think the Commonwealth Court's cases involving steep slopes, I think that is an area where you could see a hybrid that makes sense. But in our case, to us, it's so clearly a use that you've got to jump the shark, as we believe the Commonwealth Court did, by saying it would be a blatant disregard of their precedent in Coyle, and for this own court to ignore Nettleton and all of those cases going back decades that it cites. It really is, it's a hard rule, hard in a way that, meaning it is clear to practitioners. And you've got thousands of zoning hearing boards across the Commonwealth. And when I'm on the applicant side, we tell clients sometimes, look, here are the standards. You may want to petition to rezone. You can challenge, but if this goes up on appeal, you're going to have a problem. And my last note for the court on that is the cases are already in the pipeline. In August of 2025, Commonwealth Court in the Markey case cited its own precedent in Soland, and that involved a recreational field in an industrial zone where that was not permitted. So it is happening, and we would like to see clarity, and we think the right clarity is to keep the higher standard for use.
Thank you.
Thank you.
Thank you very much. Let's hear from Mr. Mezzanotte. Mezzanotte, sorry.
May it please the court, I'm John Mezzanotte, and I hope to be quick because I think this is well briefed, but the second question addresses the very specific issue of whether the de minimis variance that was granted in this case is truly de minimis. And it may be that you will not need to consider this part of the argument if you accept Mr. Rao's argument that de minimis should not apply to non-dimensional variances. The starting point, I think, is to remind ourselves that the whole notion of a de minimis exception to any legislation came from the notion that sometimes the exception is so trifling, which is the word in Latin, that it does not and should not take the time of a court. And so when we look at this particular case and the variances that were regarded as de minimis, we're left to look and examine whether they were truly trifling, whether they were that insignificant that they were excused from compliance with the ordinance on a de minimis basis. Again, to remind ourselves, the de minimis requirements, which I think would be imported from the dimensional cases to the use cases, would be the same, and that is that de minimis would mean that there is a minor deviation from the ordinance.
So, counsel, do me a favor then. Define minor for me, because I understand, having done these types of cases in the past, I understand the de minimis application to dimensional variances. It's required for 2,000 foot, to use the example. It's only 1998. It's a 30-foot ceiling, and we're going 32 feet. Where do we draw the line? I mean, if we extend the de minimis doctrine to use variances, which is a legislative determination of what is allowable in a particular district, where do we, the courts, draw a line for use variances? Is a drive-through Kentucky Fried Chicken in my backyard a minor deviation from a residential requirement?
I mean, I think that's precisely the issue, and the issue that was addressed by Mr. Rao. If we import the dimensional de minimis standard and we layer on the requirement that we have a minor deviation, we're putting a subjective and non-quantifiable issue into play with use variances while they're quantifiable with dimensional variances. And so you asked me to define minor, I say it's undefinable.
I just foresee the opening of the floodgates. Every applicant's going to try and use their property for a use that's not allowed in a particular zoning designation, and they're going to argue, well, this is a minor deviation, and they allowed it for, this particular property. Why not for me?
Yeah, Justice, I think you're exactly correct, and I think of myself as a practitioner who represents folks who want to get variances from a zoning body. I have to think now, if the de minimis is imported into the use variance, whether I need to present that in each and every instance, because just as you say, if I have room to call it minor, maybe I have an opportunity to get around a use restriction that wouldn't otherwise be there.
Counsel, was the prior use of this tenant house a veterinary hospital?
Yeah, way in the past, Justice, yeah. I think that's in the record.
And what was that classified as?
I'm sorry, what was?
In order to have a vet hospital on a historic property, was that classified as Class 1?
Yeah, I have to say I don't know. I think it was so long ago, well, not so long ago, it was probably in the 80s and 90s, and whether it was a vestige of a prior use or not, what I do know is that at present, it's not actively used.
So we're talking about use, so it was okay to let animals stay overnight there, but just not humans?
That's right. If you can milk it, they could stay.
Counsel, Counsel, could you explain to me the significance of the distinction between Class 1 historic resources and Class 2 historic resources?
I can't any better than you, Justice, because I looked at the ordinance, and so they had listed as Class 1. It seemed to me places that had reached actual governmental status, and that Class 2 were uses that didn't reach that elevated level.
But they looked old.
Which brings me to,
But let me just follow up on that, and let me ask you this question. If that were the only requirement for this B&B, that it be a Class 1, and this was a Class 2 historic building, would that be a de minimis variance?
No, and I think there's a real good reason why, because we look at both parts of the de minimis test. First, it's minor, but second, that it doesn't do violation to whatever considered judgment of the legislative authority. And so what we do know is that these different classifications existed at the time the B&B estate ordinance was drafted. So these supervisors were thinking, what do we want to bestow this special status on? And it's not like they didn't know or forgot that there were Class 2 historic resources. They knew it, but they decided we're going to limit this special entitlement to Class 1, and we're not going to grant it to Class 2. And so that's a legislative judgment.
Isn't the judgment, though, tied to the idea that I mean, again, what goes into these zoning ordinances is very complicated, and how they decide what they have to provide every kind of use in a municipality or suffer some sort of an exclusionary challenge. So they had to provide for the B&B use somewhere, somehow. And what they decided was these higher level historical properties, we are going to encourage those to be put into a use that wouldn't require them being torn down or redeveloped. We're going to protect those by giving them the B&B option. But we're not going to give the same B&B option to a level 2. We're not as worried about them as we are.
My response to that would be, that makes sense, but I don't know if that was their legislative thinking.
But if we adopt the de minimis standard, we're going to have to hypothesize a reason for why they would make that choice.
Isn't it a fact that a Class 2 historic resource building could become a Class 1 if it becomes certified by some national historic registry?
No, it's not national. It's just you folks. I don't mean you. I mean, it's East Bradford.
Well,
it's not somebody sitting in Washington, D.C., right?
No, because it sort of elevates the ones that have received the national status. So if they've, I can read the ordinance to you, but
isn't Class 1 national and Class 2 by the local authority? Isn't that the distinction here, the labeling distinction?
I just happen to have the ordinance here.
Handy, huh?
So Class 1 specifies that it's buildings on the National Register of Historic Places, buildings certified as historic by the Secretary of the Interior, buildings documented as contributing resources by the National Register Historic District, resources that have received a determination of eligibility from the Pennsylvania Historical and Museum Commission, and then lastly, the Chester County, the National Register criteria under the Chester County Certification Program. So Justice Weck, that's why I say it's sort of a hybrid. They decided which ones to elevate to Class 1, but it was essentially based on governmental designations that existed.
But back to my question,
back to your
Class
question,
2 could become a Class 1.
You would think so.
Yeah.
You would think so. I don't know. I guess it would vary from property to property. But again, what we're dealing with here isn't simply, are you Class 1 and is that enough? But we're also, the owner occupied and the no accessory building, that melds together to give you an indication of what the supervisors were looking for here. They wanted a conventional B&B. They wanted the guests to be in a property that was occupied by the owners. They didn't want accessory buildings used, and they wanted it to be very specifically Class 1.
A lot of security involved in that. I mean, that there's some sense to that thinking.
Sure, I think it probably operates both ways. There's monitoring that can be done by the owners, and then conversely, guests or have an owner in close proximity that they can look to. And I know somebody could quibble and say, look, owner-occupied is broad. It doesn't mean somebody's living there. It doesn't mean somebody has the bedroom there. Owner-occupied has been otherwise interpreted as being pretty broad. But it does mean at least this. It means that there is some interaction between the owner and the structure that can guarantee some confidence that guests are observed and maintained. So, again, this is to the point that we're not talking about something trifling here. When we're talking about that as a legislative requirement. And then, of course, again, to sort of hammer home that they want a principal use involved here, there's a provision of the ordinance that says there could be no accessory uses. Just anticipating what we might hear from the marshal side of things, I think what their argument essentially is let's flip it. Let's not talk immediately about the question of whether something's minor. And I understand why that is, because when you just totally eliminate standards, you're not deviating slightly, you're eliminating them. So the argument therein seems to be, aren't we getting to the same place? I call it this, if it can be someplace, it can be anywhere. So if it can be on the property and we can have a B&B operating here, isn't that just automatically de minimis, because you essentially have the same use of the property? And I think that's the wrong focus, because if you focus on the property, you're not focusing on the building, which is what the supervisors did in East Bradford Township. They were talking about what specifically could be done in a building. And so we're not talking about precisely the same effect. We're talking about a complete reversal of what was contemplated by the ordinance. Again, not de minimis. And so I'm going to wrap up here. I think looking forward, I know you take these cases because you're not just interested in what happened in this particular case, but what you're doing for the future, what standards you're setting that will apply going forward, and what it will mean to the people, to the governments that serve them, and to the courts that serve them. And what you're doing here, if you accept the minimis here, is looking back on it, you have a zoning hearing board process that was so thin that there was no discussion at all of de minimis. You got a opinion and an order that was equally thin, no analysis of what it was that made this de minimis, other than in a conclusory way saying there could be a de minimis for a use variance. And again, the poor Commonwealth Court was left without a real record for support. So what it was left to do is, number one, say, well, the de minimis was implicit because it wasn't said at any time, and then had to come up with a reason why it was okay, and they said, well, it met the spirit and intent of the ordinance. And so if you accept a de minimis variance in this particular case, what you have set out for the future, for lawyers like me, for courts, is to say, this can be granted as a de minimis variance with virtually no underlying zoning hearing board factual support, argument, or decision. And you can allow a de minimis variance that eliminates 3 sections of an ordinance, just eliminates them entirely. No class 1, no owner-occupied, no accessory restriction.
Counselor, do
yes,
the
sir.
Solands have a bed and breakfast on their property?
Excuse me?
Did the Solands have a bed and breakfast on their property?
On their property, no.
Okay, just inquiring.
They're not competitors. No.
Okay, I think we get it. Thank you very much.
Thank you very much.
Surely. Let's hear from Mr. Green.
Good afternoon. May it please the court, Edward Green on behalf of the marshals, the property owners, the appellees in this case. My clients, the marshals, were a family of 5 that purchased the remnants of a 18th century farm in 2017, and for the last 8 years have been pursuing the opportunity to operate a bed and breakfast out of their estate, out of this property. I think to some degree the prior argument just gave a little short shrift, I think, to what the Commonwealth Court did. Essentially what the Commonwealth Court did was, in essence, apply the same test that this court has applied in reviewing de minimis dimensional variances, and applied it to the facts they had before them. Essentially, the de minimis dimensional test really has two parts, which is what is the degree of deviation from the ordinance, and then secondly, is it antagonistic to the purpose of the ordinance or public policy of the ordinance? Essentially, it's a two-part test that this and all the courts in Pennsylvania have applied with respect to a de minimis variance. They took that test and applied it here. And what they found was that applying that same test of what is the degree of deviation from the ordinance to what the facts they had, they found the difference to be de minimis.
The difference between the use variance, though, and the dimensional variance in terms of that kind of an analysis is that the use variance is not objectively measurable in a way that the dimensional variance is.
Well, I would suggest that it is in some respects. It is in some times. And I think just like every case that comes before all the boards in this court, all the courts, all entails some subjective analysis. If you look at the process in terms of the grant of a variance, the five-part test, included in that analysis are the court's interpretation in terms of what is the impact of that variance on the community, what is the impact on the character of the neighborhood. That is the part of the statutory test that all the boards have to apply in determining the grant of every variance, so that it is in every case that there is an element of subjectivity applied in determining whether to grant the variance. It is not in any case purely objective. It is always subjective.
Part one of the test in a dimensional variance, part one is objective and measurable.
Oh, absolutely. Well,
Part two, there is some.
Right, I'm not suggesting it's all subjective, but I'm just saying there is an element of subjectivity in every analysis for every variance request that comes before the board. So to introduce some subjective analysis by them is nothing more than what they have been doing with respect to dimensional de minimis variance requests.
But counsel, isn't what you're articulating entirely subjective? I mean, you're correct in what you're saying. The Commonwealth Court basically said, well, the MPC doesn't allow, there's no such thing as a de minimis requirement in the MPC. It's a judicially created kind of doctrine. We've applied it in past cases to dimensional variances, so why not to a use variance? But the difference is, if there's an allowable usage that says the building can't be above 30 feet and it's 31 feet, as long as it's, I mean, the way that that doctrine's been historically applied is, what's the harm if it goes up another foot, another 6 inches? I'm just struggling because the question I asked your opposing counsel is, what's the objective criteria that we need to articulate and give to trial judges and zoning boards across the Commonwealth of Pennsylvania that says, yeah, we're going to allow variances, de minimis variances for use. What's a de minimis use variance? I mean, and I'm not talking about this particular case. I understand that this case is the exception maybe to the rule, but again, what's the objective criteria? If I live in a cul-de-sac and I've got a home office and it's all residential and no business is allowed, if I'm an accountant, am I allowed to meet with clients? And if so, how many clients, at what time? Do my clients come over and take up during tax season 20 parking spots on my street? This seems to me to be a very, very slippery slope without a bright line objective criteria that we can impose upon zoning boards.
It is unquestionably true that the grant of a de minimis use variance is more challenging than the grant of a de minimis dimensional variance. But having said that, even the grant of dimensional de minimis variance contains some level of subjectivity. There is still some element of how much is too much, how much is too far, and then also what is the impact of that deviation. So even the dimensional de minimis variances have some non-objectivity to it. It's simply the type of decision that the boards and courts are asked to make all the time. The result may be that it's more difficult, and that's essentially what this courts have held with respect to use in dimensional variances. It's more difficult to get a de minimis use variance than it is a dimensional use variance.
But if we extend it to use variances, don't you foresee literally the floodgates opening up with people saying, I want to use my property for something it's not zoned for?
Well, I think the answer to the floodgate issue is that by and large, they'll be denied. I think that...
I'm not suggesting they won't be denied, but I'm suggesting that you're going to have a flood of litigation and zoning hearing boards all across the Commonwealth of Pennsylvania where novel attorneys and novel business owners or property owners are going to suggest that a use that's prohibited by a General Assembly declared zoning district is a de minimis use variance. I should be able to have a Kentucky Fried Chicken drive-through at my house.
Well, I think the answer to that is that as the matters present themselves to the boards, it will be sorted out in terms of what will be considered to be under those specific circumstances. Again, every de minimis variance is a fact-specific grant.
That brings me to a different part of that analysis, the specific purpose part. What specific purpose justifies this relief?
Well, I think that when you say the purpose, the reality is that the MPC creates the right to have ordinances and specific regulations, and then it creates statutorily the right to have variances. When there is, under those facts and circumstances presented, there is something about the property, the intended use of the property, the dimensions of the property, such that a board or court has the discretion to make it, to essentially adjust that ordinance to fit the unique facts that case presents.
Why should that be the case here?
For this particular client? Well, I think the analysis starts with the fact that unlike most use variances, we're a permitted use. And if you look at the ordinance that was granted, the bed and breakfast estate de minimis grant that we had here was that, as the court found, it was in support of and was consistent with the intent and the spirit of the bed and breakfast estate use and the adaptive reuse. So what the board below found and what the Commonwealth Court found was that the plans of my client, where there was in their mind minimal deviation from the ordinance, and the fact that it was consistent with and satisfied the spirit and intent of the bed and breakfast estate use.
Let him finish the answer, if you would.
Oh, the fact that in the mind of the board below and the Commonwealth Court below, the deviation from the ordinance was minimal. I think they viewed it as, they said, technical, not substantive. And the fact that the use they had here as designed was consistent with both the intent and the spirit of the bed and breakfast estate use and the adaptive reuse, which is the preservation of historic buildings. This case presented a very unique opportunity to have multiple historic buildings preserved.
But, counsel, now that's my concern. You're arguing that the use is de minimis, but the ordinance has two objective measures. One, historical, class 1 historical, and 2, owner-occupied, neither of which the tenant house is. So how is that de minimis when it's not meeting the two objectives required by the ordinance?
Well, I think that
the... may be one or the other.
Well, Your Honor, I think the catch is that what the Commonwealth Court saw and what the board saw was the fact that this use is being operated out of 3 buildings, 3 recognized historic buildings. It's a property that the township has recognized as putting on its historic resources map as a Class 1 historic resource. And they have all the buildings, the zoning officer testified that all of the buildings on the property are historic buildings, but one, the garage. And then the bed and breakfast is being operated out of 3 buildings. The farmhouse, which is a Class 1 historic resource, the barn, which is a Class 1 historic resource, and the third being the tenant house. So it's not a situation where in this...
Are any of those owner-occupied?
Yes.
I would suggest certainly the farmhouse is owner-occupied. That's the house, but I would suggest that the interesting fact that was presented here is the fact that the bed and breakfast is being operated out of multiple buildings. And that's contemplated by the bed and breakfast estate ordinance because it used the term buildings, not building. So first of all, I suggest you cannot equate the owner occupancy with necessarily having to have the family live in the building in which the bed and breakfast estate is operated, or at least all the buildings, because when you contemplate multiple buildings as being used in a single use, this bed and breakfast estate use, you cannot expect the family, what are they going to split up the household and have different members of the family live in each of the buildings?
You didn't, but counsel, I'm confused. You seem to be arguing that that the ordinance allows what you're doing. You wouldn't need a variance if the ordinance allowed what you're doing.
Well, I would suggest that I'm not convinced that we needed the variance to meet the owner-occupied requirement.
Well, that's a problem then if you're not convinced of it, that we shouldn't decide the case. But I have a question for you, and I don't want to get into it, but you kind of opened up the door on this. What's your hardship?
Well,
can your client comply strictly with the ordinance and operate a B&B on the property?
The client can operate the bed and breakfast and conform with the ordinance.
Right. They want to do it a different way.
Correct.
That isn't a variance. A variance is we can't do it the way the ordinance requires. And while we might not be able to meet all of the MPC requirements for a variance, we can tweak a little bit here and comply. So I'm not aware of any de minimis, maybe you can point me to one, I didn't see it in your brief. Any case where the courts have given a de minimis dimensional variance that actually eliminated a requirement. So the setback cases, the steep slope cases, we've never said your de minimis variance is the elimination of the setback. We've altered it. You're seeking an outright elimination of qualifications to a permitted use. I don't know how that could ever be de minimis.
Well, I guess the way the court looked at this, recognizing that this is each of these variances are a case-by-case, fact-by-fact analysis. I think what the board below did and what the Commonwealth court did was view the fact that what we have is we have the operators of the bed and breakfast estate living on the same property, same address, same shared driveway as the building within which the bed and breakfast estate will be operated.
And they could live in the house.
And they will be living in the house. But I think the one thing we have to be careful about, I suggest, is that the term is used in the ordinance that it be owner-occupied. I think that as is a companion case with ours, I think one has to be careful in terms of how they're defining occupied. In other words, I suggest there's no requirement, and again, knowing the fact that it contemplates the use of multiple buildings, it doesn't necessarily contemplate that in the bed and breakfast estate use that they have to be sleeping in that particular building.
But see, now you're sliding back into you don't need the de minimis variance. But we're here to litigate whether you need the de minimis variance. Or whether you should have a de minimis variance.
Well, I guess my point is what the board below and what the court below felt was this is so close to meeting the language of the ordinance that it's a de minimis change. That the fact that they are living in the farmhouse, which is located near the tenant house, is a de minimis difference between living in the building itself versus living.
But it is a difference.
It is a difference.
I guess what could have happened is the zoning hearing board could have said, no, you don't need a variance at all because we interpret the ordinance as allowing this.
Correct.
But that's not why we're not here, because that's what happened. We're here because of this concept of a de minimis use variance.
And I think what the board found, what the Commonwealth Court found, was that essentially the fact that the owners of the bed and breakfast estate were residing in the farmhouse, same address, same property, same shared driveway, just down the driveway from where the tenant house is, that is a minimal deviation from the requirement of owner-occupied, and for that reason, we find that to be a minor deviation warranting the grant of the de minimis variance.
Okay,
Counsel, just one, and I'm confused definitionally.
Okay.
You're using a phrase, bed and breakfast estate.
Yes.
That's your phrase, right?
Yes, that's the ordinance.
It refers to the bed and breakfast estate, not a bed and breakfast?
Well, the actual use is defined in the ordinance as a bed and breakfast estate. Am I answering Your Honor's question? The use is defined, the formal use for which we submitted our application and received our approval was for a bed and breakfast estate. That's the term that it has within the...
Well, how does one occupy an estate? One can occupy a structure on the estate.
Well, the bed and breakfast...
Is that your argument? That's why you didn't need a variance?
Well, the bed and breakfast estate use has 23 conditions, and one of those, 24 conditions, and one of those conditions is that the only buildings eligible for the location of a bed and breakfast estate is that it be owner-occupied, Class 1 historic resource. So it is our position that what the Commonwealth Court found and what the board below found was that we were in the proximity of our farmhouse to the tenant house, to the barn, was such that we were meeting, in essence, close enough to the owner-occupied term that they found that to be de minimis, granting us the variance from that particular.
It could be viewed alternatively, in your judgment, as no variance needed at all.
Correct. Correct.
Okay, Mr. Green, we understand and we appreciate all of the arguments. Thank you very much.
Thank you.
As far as zoning cases go, this may be one of the more interesting we've had.
Yes.
It's a low bar.
Zoning cases.
It is a low bar.
Mr. Minner, would you call the next case?
Gregory Education versus Sarah A. Scotchlas, appeal of Brian Campbell, individually on behalf of Ms. Rothenberg Campbell, representing Ms. Campbell,
No.
Campbell, representing Ms. Brenda Campbell Esquire, Ms. Joanna Gelb, and representing Gregory Lukasik.
Okay, in this custody proceeding, the trial court, without conducting an evidentiary hearing, found that the mother of the minor child engaged in vexatious conduct by filing through counsel a 262-paragraph petition to remove the child's guardian ad litem, thereby delaying the custody proceedings. The trial court reasoned that the removal petition lacked legal merit, as the voluminous allegations of the guardian's bias against the mother had already been rejected by the trial court months earlier, when the trial court denied the mother's previous petition to remove the guardian after conducting an evidentiary hearing. Accordingly, the trial court ordered mother to pay the guardian's and the father's counsel fees relating to the filing of the second removal petition. The Superior Court, based on this court's 2023 decision in County of Fulton, reversed the trial court's order in part and concluded that the trial court abused its discretion by ordering the mother to bear full responsibility for the payment of counsel fees. To the contrary, the court held that mother's counsel engaged in dilatory, obdurate, vexatious, and bad faith conduct by filing the lengthy second petition to remove the guardian, and remanded the matter for further proceedings to determine the joint and several responsibility of counsel and counsel's law firm. We granted allowance of appeal to examine whether the Superior Court properly applied our decision in County of Fulton in concluding that counsel and his law firm were jointly and severally liable for counsel fees charged against the mother. Please proceed.
Good afternoon, Your Honors. May it please the court. I'm going to just take a moment to get a little water. My name is Attorney Ryan Campbell, and as Chief Justice eloquently described, I am here on behalf of myself as well as the law firm of Rothenberg and Campbell. Your Honors, I'm here today on the Lukasik case, which has remained an anomaly in the pool of Commonwealth child custody cases. Today, I seek vacatur of the April 16, 2024 order, which sua sponte applied County of Fulton to find that my conduct had violated Section 2503 of the Judicial Code. It also remanded the proceedings back to the trial court for further proceedings. Your Honors, today, vacatur of the April 16, 2024 order of the Superior Court is necessary, and I aim to show why on ternary grounds. Number one, the Superior Court, in using County of Fulton, improperly substituted its own judgment for that of the trial court. Specifically, Your Honors, the finding of my conduct, specifically during the underlying trial court proceedings, had not been determined by the trial court.
That was true in County of Fulton also.
That is correct, Your Honors. However, in County of Fulton, Your Honors were sitting in a fact-finding capacity. Your Honors, in that case, had asked Chief Justice Jubilier to hold a proceeding about, conduct that may be sanctionable. In her report and recommendation, Your Honors felt that most of those recommendations were valid. However, in County of Fulton, Your Honors determined that the attorney for the county's conduct was especially sanctionable. That opinion, Your Honors, is again voluminous and operates not only as an very well written, Justice Wecht. The one thing about County of Fulton that I took away, Your Honors, actually this I took away a little bit more from Justice Doherty in his concurring opinion, was that it heeds a warning to litigants and counsel to play by the rules, so to speak, and not to engage in conduct that's going to disrupt this honorable court. And so
that was a contempt case, right? This is a child custody. That was under the Judicial Code. This is under the Child Custody Code, right?
No, my understanding is that dilatory, obdurate, vexatious, and in bad faith, Your Honor, is 2503. The Child Custody Code would be arbitrary, I believe, or capricious.
Repetitive? Where's the repetitive?
Repetitive is in there, Your Honors, and I'm glad that you brought that up, because let's talk about the 56-page, 262-paragraph second motion to remove Attorney Coble as the guardian ad litem. Your Chief Justice Dodd explained earlier this morning that Your Honors are familiar with the case, and I'm certainly not going to waste time going through that entire filing. And there are plenty of words that I could use to describe that filing: crusading, annoyingly self-righteous, pedantic, flippant, too long, overkill, overtly contextual and speculative, those are all fair. But, Your Honors, it cannot be stated that that 56-page, 262-paragraph motion was filed frivolously, without due diligence, or that its arguments were wholly without merit, fraudulent, dishonest, scattered and disjointed. As for repetitive and persistent, Justice Weck, it cannot even be said that it was repetitive.
Okay,
and
we're gonna stop a minute.
Thank you.
Although you're on a roll. I mean, that's good.
I can go all afternoon, Your Honors, but
Mr. Campbell, I'm usually concerned with attorneys who speak so softly I can't hear them. You are the opposite. You certainly are. I can hear you very well.
I'll step away.
Well, no, could you just, move the mic a little bit away from you, and I think you will be heard fine. Thank you.
I appreciate that. But as for repetitive and persistent, it cannot even be said that it was, at least in my context, repetitive.
Counsel, how much time went by from the denial of the first petition to your filing of the second?
I believe, Your Honor, it was 6 to 9 months, I believe.
And what had changed during that time period? My understanding is that it was almost a cut and paste job of the first one. What had changed in between that time period such that would change the circumstance?
Your Honors, I'm glad that you brought that up. In fact, it was not a cut and paste job. There were several additional arguments that were lodged in that second motion to remove, Attorney Coble as the GAL. For instance, there was a procedural ground regarding the initial appointment of Attorney Coble as guardian ad litem. There also existed different contextual examples, and importantly, and this is what I had tried to do in both my reply brief and my initial brief, is that document, whatever my intent was, it's the only act by myself at the time representing Ms. Scotchlas that can even be used. The problem is there was no evidentiary hearing about anything during the short time period I represented Ms. Scotchlas.
I apologize. Is this on the first one or the second one?
Sorry, second one, okay? I entered my appearance, Your Honors, on January 27th or 26th, 2023. The filing, was filed a couple of days later on January 31st. The oral argument, which again initially was a hearing but was an oral argument, was on April 18th of that year, so a few months later, and the order came out on May 5th, the amended order, on May 5th, 2023. During that time period, Your Honors, nothing happened. There was nothing scheduled other than my hearing on the underlying motion.
Counsel,
yes.
I don't mean to interrupt. I used to love to try cases, and that was a trial judge, and I used to love to hear cases and fact find. But you're talking about 25 pardons, or 2503, which is vexatious, obdurate, and dilatory conduct. Isn't that a fact-finding function?
100% correct, Judge, yes.
So let me ask you this question. What witnesses did you call at a hearing to defend yourself on these fact-finding allegations?
Zero. There was no hearing.
Let me keep going. Did you present any witnesses?
No.
Did you have a hearing?
No.
Isn't your real argument here not necessarily that you didn't do anything wrong, but you didn't have due process?
That's correct, Judge, and again, I argue that. I mean, that's essentially the underlying problem, is that there are no robust procedural safeguards.
You filed a pleading. In response, the attorney asked for attorney's fees. There was a little bit of an argument, I guess, in front of the trial judge, but there was no hearing on their request for attorney's fees. You didn't call witnesses. They didn't call witnesses. You didn't get to cross-examine witnesses against you. No exhibits were entered against you, right?
That's correct. Additionally, I never received copies of the fees, so there was no reasonableness, even an attempt to talk about the reasonableness of those fees. The fees, I believe I cite them, were surreptitiously requested by the trial court judge mid-oral argument. I never received a copy of any of the proposed fees. I was not able to challenge the reasonableness of those fees or anything of that matter.
But counsel, the proceeding, I'm sorry, over here, the proceeding in front of the trial court was a motion for sanctions against a party, right? Was it against both of you jointly?
No, Your Honor, respectfully, the underlying proceeding was an oral argument on the motion to dismiss,
right,
the second motion to remove the GAL. So initially,
what was the sanctions request that was made to the trial court?
the sanctions request was a request for attorney's fees.
Attorney's fees against whom?
Scotchlas.
Right.
And myself.
Oh, and you.
I believe that there was a request to hold me jointly and severally.
And that was oral at the trial court?
Are you sure of that, counsel? Are you sure of that?
I'm not.
It was, well, how could you not be sure of that standing before us today? I mean, part of the issue here is whether or not you had notice that there was a claim for attorney's fees against you. Either there was or there wasn't.
Your Honors, there was absolutely a claim for attorney's fees against me made during the oral argument as well as in the filings. I understand what is being demanded. The issue was that there was never a hearing on any of that.
Let me go back. The trial court imposed attorney's fees against your client.
That's correct.
Okay. Every single argument that you've made here today to defend yourself, you could have made on behalf of your client.
Your Honor, there was no opportunity.
Yes, there was. I mean, I'm sorry. I mean, I have a problem without there being a hearing here, but the trial court asked for briefs. They asked for a brief by the party claiming fees, and then the father said he had the same petition for attorney's fees and he would be filing something. You said nothing and filed nothing. You were not defending the attorney's fees that were going to be imposed against your client.
Respectfully, Your Honor, that's not right. That's incorrect. Actually, what was requested was a little bit of a brief on the oral motion to hold me in contempt. Okay, that was never filed. That was made during the oral argument. And yes, I did submit a filing regarding that. I did actually submit a 3-page single-spaced filing on that in response. Specifically, that was to hold me in contempt. Again, oral, not written, nothing filed, was to hold me in contempt for retaining an expert, okay, to examine...
Different motion. At the end of the proceedings, at the end of the oral argument on the day that you're referring to, counsel raised the issue of her pending motion for attorney's fees. There was an outstanding motion for attorney's fees that had to be decided. The court said, everybody file, just nothing long, don't take a lot of time, file something setting forth the law and the facts, and father jumped in and said, I have the same fee petition pending. He filed something. You filed nothing.
Your Honor, I don't know what you're talking about, and maybe that's just because the transcript of that proceeding itself was ambiguous. I do remember being there. I also remember having submitted, a long response that was submitted to the trial court. But as for fees, I mean, that wasn't the subject of the oral argument. That wasn't filed anywhere at that time. So again, at that point, still, no opportunity to have been heard on that issue.
Well, counsel, the trial court at the end of the argument, at the end of the oral argument, I agree with you, it was an oral argument, it wasn't a hearing, right? It was an oral argument.
Yes, that's correct.
Not a hearing. It wasn't scheduled for a hearing. Okay, but it was transcribed.
That's correct.
That at the end of the proceeding, Attorney Coble said to the court, reminded the court that she has an outstanding petition for fees, right?
Yes.
Okay. At that point in time, the trial court instructed her to, quote, give it a little bit of a paragraph as to why she should be entitled to attorney's fees, a little legal research on it, and submit it to the trial court, and it would be taken into consideration. Do you remember that?
Sounds familiar. I mean, Your Honor, if you're reading directly from the transcript, I have no reason
as opposed to my relating it to you.
I have no reason to disbelieve what
But
you're
did she invite parties to submit post-argument letters, or did she simply ask for a letter from one side?
I remember from one side, or some information about the fees. That's
And you heard that, and I'm not going to judge why you did or didn't do it, but you didn't think it prudent to get your shot in at that point in time and say, you know, Your Honor, I'd like to respond to this fee request. I'd like to oppose it. I'd like to have a hearing on it. You didn't do anything like that?
Your Honor, if you go forward in the transcript, what I believe was that the judge started out by saying, I don't want to hear anything from anyone. And that particular proceeding, if you've read the entire transcript, I had very little opportunity to say anything at that point. Again, if Your Honor is reading directly from that transcript, I'm no reason to disbelieve what you're stating isn't true, but if Your Honor is inferring that I did something wrong by not doing something at that proceeding...
Well, I'm just trying to understand, because I'm not sure you were answering Justice Donahue's questions directly, but I also want to correct what I think you said, which the order that the trial court entered, again, without a hearing, no question, there was no hearing, entered a fee award against the party, meaning your client.
Correct.
Right? Not against you.
Correct.
We're here because when it went up to the Superior Court decided to amend that order somehow, some way, and I guess the trial court could have sanctioned you at the time if it wanted to, but it chose not to. But the Superior Court's like, oh yeah, we're not just going to decide whether the trial court was correct or not correct in sanctioning your client. We're going to also look at the issue of whether you should be sanctioned as well.
That's correct.
And that's why we're here.
That is the reason why we're here.
Okay.
Yes. And again, it is confusing, but what I believe...
I'm not sure it's that confusing.
The issue isn't confusing, but it was confusing as to how they did it. I thought maybe they were applying County of Fulton as a way to do that, but Your Honors, I'm confident that that's not what County of Fulton stands for. It doesn't stand for the fact that if an appellate court sitting in an appellate capacity can do just that. I don't believe that's what County of Fulton stands for. It does stand for the fact that as an exposition of sanctions and contemptible conduct, absolutely.
You would agree that the Superior Court could have sanctioned you if you engaged in dilatory, obdurate, vexatious conduct in front of them?
Correct.
Without a question.
That is true, yes.
Now, what are you asking us for? Do you want a remand for an evidentiary hearing? What do you want?
Your Honors, I've asked for a vacatur of the Superior Court's order and a remand to have an actual hearing on whether my conduct or my client's conduct is sanctionable.
Can I stop you there?
Yes.
You appealed the fee award against your client and then didn't file a brief. The appeal was dismissed, so the attorney's fees award against your client stands.
Judge,
correct? So the only thing we're arguing about here, you're arguing about here, is whether or not you share in that fee award.
That is my understanding of the particular issue here, Your Honor.
Okay, so your client is still on the hook.
You want a remand for an evidentiary hearing as to whether you are required to pay attorney's fees.
Well, again, it would be a remand to determine the scienter, whatever would be the subject of sanction.
I thought you just want us to reverse, which would reinstate Judge Corbett's order imposing fees on your client.
That's not
only on you, only on her, rather than what the Superior Court did, which is change it around to share it with you.
The issue with and then again, I mean, that could happen, and a reversal would equally, correct the problem with the Superior Court's ruling. However, that will also affirm what didn't happen in the lower court, meaning there was no hearing.
Yeah, but to Justice Donahue's point, you missed that boat, because it was all the trial court did was impose sanctions on your client. So it was your client that was damaged by the lack of a hearing in front of the trial court. It went up, you didn't file a brief, your client's appeal was quashed. So whatever rights your client had to contest the procedural due process or lack thereof at the trial court is gone. The only thing we're dealing with, as I understand it, is the Superior Court just decided, even though the trial court didn't decide to do it, the Superior Court decided that you're going to have to share in the liability of your client. And that's the only thing we're looking at. So I think it's great that you're open to a remand to the trial court for a hearing to determine whether you should share, but you might be conceding too much.
Your Honors, I have nothing to hide in this case. I admit what we did and what we didn't.
By the same token, you need to be clear with us as to what you are requesting, what relief you are requesting.
I understand, Judge.
Okay?
I understand.
And what is that relief?
Reversal of the Superior Court's decision.
And what?
That's it.
That's it?
There's nothing, I mean, at that point, there's nothing at that point that needs to be done in addition.
Okay. All right. Do you have anything further to argue, sir?
I do not. I thank you all for your time. Appreciate it.
Thank you. All right. Let's hear from Attorney Gelb.
Good afternoon, everyone, and may it please the court. My name is Johanna Gelb. I actually wrote it down, so I didn't forget to say that.
And would you pull the mic closer? Thank you.
Okay. Honestly, nobody's ever accused me of being,
That's true.
Nobody's ever accused, you're right. Not one person's ever accused me of being bashful. Okay, so I am here on behalf of Brenda Coble, who was the court-appointed guardian ad litem, actually by agreement of the parties. Attorney Lynott is here, and he represents the father, Greg Lukasik. And along the lines of what the court just said about the Superior Court's decision against Ms. Scotchlas stands because Mr. Campbell abandoned his appeal, and his appeal was based on the fact that there was no evidentiary hearing. The record is clear on that in his docketing statement, in his statement of matters complained of on appeal. He specifically said there was no evidentiary hearing.
No, but you're conflating something here. The issue isn't that the hearing in front of the trial court. The issue, at least in this context, is that the Superior Court just switched it over to joint and several without giving Mr. Campbell a hearing. It just converted this into a Fulton County-like contempt proceeding in the appellate court, which is a very odd procedural thing.
Your Honor, but I can get to that, but the thing I wanted to point out when I was saying that the Superior Court dismissed the appeal that was filed by Mother, which was 811 MDA 2023, Father had an appeal that was filed at 884 MDA 2023, and the guardian's appeal was at 885 MDA 2023. And when asked, which case are you filing this petition for allocator on, Mr. Campbell submitted a letter to the Prothonotary on April 30th of 2020, I think 2025. 2025, because he filed April 15th of 2025. And he specifically said, I am not filing this petition for allocator in the father's action. So technically, as we stand here, the father could ask the trial court to go back and hold a hearing on apportioning liability between Mr. Campbell and his client, because that petition, or that petition for allocator, was not filed in the father's case. So petitioner is saying to this court, what the Superior Court did in the guardian's case was wrong and should be reversed, but what the Superior Court did in the father's case, which was the exact same decision, should not be. So technically, Sarah Scotchlas isn't present. Sarah Scotchlas isn't present, but she also could go with father and ask the trial court right now, as you're being asked to reverse on 885 MDA 2023, and can go back and say to the trial court, when the record comes back down, you need to hold a hearing to apportion liability, because that was not appealed.
Well, I'm sure like acrimonious custody cases, this thing will go on and on and on in the trial court, but that's not what we're here to decide. What's up here on Aplts is the Superior Court's impression somehow that it wasn't bound by an abusive discretion standard in looking what the trial court had done, but that it could somehow sua sponte convert this into Fulton County, which was a totally different matter, where we were sitting as a fact finder in effect, because we had a special master and we made contempt findings, and that was a contempt case with robust procedural protections. Let me ask you this. How is this case a proper application of Fulton County?
Because the trial court found that there were or that mother's conduct was vexatious, repetitive, obdurate, dilatory, and the Superior Court looked at the same record and said, we find, just like this court did in County of Fulton, that that conduct that was attributed to mother could also be attributed to the council.
You know, this is an abuse of discretion standard, I think we can agree, in the Superior Court, looking at Judge Corbett's disposition. So, on what legal basis, without fact-finding as to Mr. Campbell, without a fact-finding hearing in front of the Superior Court as to Mr. Campbell vis-a-vis his client, was the Superior Court entitled to impose this on Mr. Campbell when Judge Corbett had made a discretionary ruling?
We think that it can, because first of all, Mr. Campbell didn't even oppose either the guardian's appeal or the father's appeal. So it's our position, first of all, that it's been waived. And he was asked in this court, Mr. Campbell, to identify where, in fact, he preserved any of these issues in the record. And his answer was, in an answer to a motion to dismiss, in an answer to an amended motion to dismiss, and in my notice of appeal. Well, I filed the petition for fees March 8th of 23, and there was no request for fees in there. We filed a brief. There's no question, and Justice Donahue pointed out, that the issue of fees came up during the April 18, 2023 matter. It came up as against Mr. Campbell. Mr. Campbell was present. He heard me say, Your Honor, we also have a petition for fees. I also have my bill. Mr. Campbell said nothing. In fact, Mr. Campbell said—
Did your petition for fees seek fees against Mr. Campbell?
No, but the petition for fees did not.
Right.
But the brief in support of the petition for fees did.
Well, the briefs—
What court are you talking about?
I'm talking about the trial court. So it was—
Briefs follow the motion.
Well,
briefs are simply argument and elaboration of the motion, and your motion sought fees against a party, not against counsel for a party.
You're correct, Your Honor. But there was also no objection to that.
But the trial court— see, this doesn't help you, though, because you file a motion for fees against a party, right?
Yep.
Then you filed a brief asking for fees against the party and counsel.
Correct.
But the trial court denied your request for fees against counsel. The
Correct.
trial court made a judgment, a discretionary judgment, to only grant your fee request against the party.
I understand that. That is what the court did, and I think that the court was wrong, and that's why I filed a motion for reconsideration, which was also not—
Is that the basis of one of your appeals? Did one of these notices of appeals get filed and say, we think the trial court abused its discretion in only giving a fee award against the party, they should have also given it against the attorney?
Yeah, that was exactly the appeal that I filed in 885 MDA 2023.
Go back a moment, Ms. Gelb. Did you file an amended motion in support of your theory that counsel was also entitled, or fees were also to be assessed against counsel?
I did not.
So just the brief.
Just the brief, the motion for reconsideration, the argument, and again, it is not as though Attorney Campbell did not have the opportunity to speak. He tries to represent it that he wasn't permitted to say anything. That's not true. The argument was on whether or not the second motion for removal of the guardian was prohibited by res judicata from the first motion that had been fully adjudicated. And Mr. Campbell was interested in arguing that there had been no full adjudication of the motion in June 13th of 2022. And he persisted in that in his motion that he filed January 30th of 2023 in his paragraph 178, where he said...
But Ms. Gelb, you're arguing things that Mr. Campbell did, and all of this presumably was in front of Judge Corbett, and she made a discretionary decision to impose fees against Ms. Scotchlas. And then on appeal, without any additional fact-finding, the Superior Court, and no discussion of any law except citing Fulton, which was a completely different case, the Superior Court simply just shifted it to a joint and several thing, saying, we find Attorney Campbell engaged. What is the basis for the Superior Court to make a fact-finding that displaces a discretionary judgment on fees by the trial court?
I don't think it was, I don't think he transmuted it. The Superior Court transmuted it. I think the Superior Court looked at it and found that she abused her discretion in making the finding that she did. To go back to I understand that that's your concern because you've sort of asked me that question like...
But was that question before the Superior Court?
Yes. The appeal to the Superior Court in the guardian's case and the father's case was whether or not the trial court erred by failing to apportion the fees between counsel and the client, and that there was no response. So originally when the mother's appeal was filed, the Superior Court consolidated all three cases, and then 811 MDA 2023 was dismissed upon motion of the guardian filed December 4th of 2023 because there was no brief filed. And the Superior Court then issued a decision December 5th, 2023, unconsolidating the cases and saying, okay, father's case is alive, guardian's case is alive, and Mr. Campbell is directed to notify his client that her appeal was dismissed by December 18th of 2023, or 2023, which did not happen. So the issue of it...
If I may, I'm still considering, you stated to us that you raised the waiver issue. I was just looking in your brief, your summary of your argument. Can you share with me where you raised the waiver issue to this court? Because I believe you just said you and your defense counsel made the waiver issue.
We made the waiver issue in front of the Superior Court, yes. And we made it in this court as well.
And where I'm making it in this court, I read it, just as a perusal of your summary of your argument. It's not in there, so I was wondering where you wrote discuss in your brief.
It's just, well, it would be this, I do actually have my brief with me, but it's in my brief case. It would be, it's definitely in there, and it's in with the table of contents which I put in. Again, it's our position that the Superior Court did nothing wrong, the Superior Court should not be overturned, but again, since there's avocado that really only granted at 885 by Mr. Campbell's request, if this court grants his request, then the other case stands.
Okay, that's fine, and I'm sure that proceedings will continue in Lebanon County.
That should be an issue. I'm sorry, but
if we have a legal issue before us, and now I'm questioning whether or not the Superior Court actually sua sponte raised this issue of assessing fees against the father. What you are telling us is that you raised to the Superior Court the trial court's error in not also assessing fees against the attorney.
That's exactly what we did. We filed a motion for reconsideration on that basis, which the trial court denied, and then we filed an appeal that was the entire basis of the appeal, because it's, I'm sorry?
885?
885 MDA 2023.
Really?
The Superior Court may be erroneously granted relief.
Well, but they did do it so strong.
No, I understand. I'm just trying to understand. 885, the Superior Court, perhaps erroneously, granted you relief.
Correct.
Okay, but that appeal, that order is not being appealed here.
That order is being appealed because that's the Guardian's case. The order that is not being appealed is the father's case. So
Is it the same thing? Was there an order issued in the father's case doing the same thing?
yes, that's what I was trying probably.
And the father in his case appealed the same issue that the trial court appealed.
Because there was an account fee award and Guardians have $10,418.40 assessed against mom. I believe the amount against father was somewhere around $85,000.
So this is more of a technical error. The Superior, hold on, sorry. I'm trying to unwrap this. This is more of a technical error. The Superior Court maybe ruled on an appeal since the trial court abused its discretion, not making joint and several liability in two of the appeals where it was actually presented as the issue on appeal. And for some reason, just because they thought they should be consistent, did the same thing in the third case where it wasn't proper before the court.
That's not correct, Your Honor.
No.
There were three appeals. The mother's appeal was dismissed by the Superior Court, abandoned. That's A11 MDA 2025. Guardian father appeal was 884 MDA 2025.
Issue is,
I'm sorry, 2023.
and the issue is,
Saying that the trial court failed to assess the fees between counsel and the client. Exact same issue.
So what's before us is before us. So I don't even understand why you're engaging us in this procedural quicksand, which I guess you want to obscure the issue, which is was the Superior Court in good standing to reverse a discretionary call by Judge Corbett on the basis of Fulton County, which was a fact-finding contempt proceeding.
That's not that's not a question being accepted for review.
I'm not trying to obscure anything, Your Honor, but I'm trying to...
Didn't he accept the issue of the Superior Court's decision to impose...
Here's the issue we accept. Whether the Superior Court erred in applying County of Fulton to sua sponte find Attorney Campbell's conduct dilatory or vexatious and bad faith and remand, blah, 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 blah. He did not find it sua sponte. He found it in response to your appeal.
Correct, in which it was crystal clear that was the basis of the appeal. It was in my background statement.
So the problem seems to be the statement of the question accepted for appeal, and I don't have in front of me if that is the exact text proffered by Mr. Campbell, or whether this was rephrased in some way. But we'll figure that out.
Okay. So then I can just follow up on this. The thing you're focusing on here is Mr. Campbell's apparently incorrect use of the term sua sponte. That the issue was teed up. It wasn't sua sponte. The Superior Court decided it pursuant to that being one of the issues you had raised. And we remain in question about whether the Superior Court correctly reversed the trial court's discretionary decision. Is that correct? Okay.
Yes. And how do you account for the fact that there was no hearing?
Well, that was unfortunate. That's how I account for it. But there is a plethora of cases which talks about there is no need for a hearing. The facts of the matter are evident. I cited all of those in my brief. In my brief to the trial court and in my brief to this court. And also said there was no objection. So in other words, I don't think there had to be a hearing. There's plenty of cases where they say you do not need a hearing, but should this court find otherwise, then it's my position that Mr. Campbell waived his right to that because he didn't ask for one. He never objected on the record.
Counsel, what was the abuse of discretion by the trial court in denying your request for an abortion of attorney's fees?
That was the abuse of discretion.
How was her decision to deny your request an abuse?
Because the facts were flagrant, and it fell right in line, in my opinion, with County of Commonwealth, Pennsylvania. That this was a conduct that was committed, and that the court used its discretion by failing to hold trial counsel of the
So based on that, I think the judicial provision is a little problematic because it's very different, unless it's signed pro se, everything that party does in litigation that's dilatory on government taxation arguably is by the lawyer. So I guess the question is, if we sort of uphold this and say it's an abuse of discretion not to hold the attorney jointly responsible, that's got to be the rule going forward. When would you not hold an attorney jointly responsible in terms of a filing in court as opposed to something else?
Depends on the facts of the case. I mean, this case really cries out for finding that Mr. Campbell was vexatious, repetitive, obdurate, and dilatory, and I think the trial court abused her discretion. And back to two other things. On this issue of whether or not there had to be, quote, notice and an opportunity to be heard, it's my position at both levels, and I put this in my brief, that Mr. Campbell had notice and an opportunity to be heard, and he waived it. And again, to go back to the Superior Court, that was the issue, and Mr. Campbell chose not to file an opposing brief.
Question.
Sure.
You indicated that the question that we accepted that there was a sua sponte response by our Superior Court, that your comment was, in essence, Mr. Campbell created that that's not what happened. It was as a result of your appeal, correct?
Correct.
So when you saw, or counsel for father saw that there was a material misrepresentation made to this court, why did you not respond? Did you not see the element or the phrase in question was that there was a sua sponte response of Superior Court, which is which you told us did not happen?
I'm sorry.
That question came apparently from the appellant in his petition for permission to appeal. That was his Allocott question. The justice wants to know, when you saw that, did you not say, no, that's not the case, and have some response to the phrasing of the Allocott question?
I'm sorry, but I wasn't aware I had the ability to pose the request. I probably filed it.
That's because our rules do not require a response.
I don't know where I was supposed to do that. But can I just go back to something that Justice Lex said? Because I have never done anything to obscure the truth of anything, quite the opposite. My point in bringing up the May 30th, 2025 letter that was submitted by Mr. Campbell to the pathonetary was that he made it clear that the same decision, because the Superior Court issued the same decision in both cases, the exact same decision, that his appeal was only to the guardian's case, not to the father's case. So he put that in a letter, that's in writing, that's what's before this court. Only the allocator to the guardian's case. So we're the court to...
Both orders are the same.
Exactly the same. So we're this court to entertain and grant the relief that Mr. Campbell is requesting in the guardian's case. It would still stand, and this case will still go back to Judge Corbett to hold a hearing on whether or not how fees should be apportioned between Mr. Campbell and his client.
I do want to, before we wrap up, Chief, I apologize. I do want to maybe defend Mr. Campbell for a second.
Go ahead.
When he referred to sua sponte in his questions, he was talking about the sua sponte finding by the Superior Court that he engaged in dilatory, obdurate, and vexatious conduct versus the Superior Court raising the issue sua sponte. I think there is a little bit of a distinction. It may be inartfully drafted.
Justice Mundy, this was, could you read that question? This is the question that he submitted. Please.
Reverentially, whether the Superior Court's finding that Attorney Campbell engaged in dilatory, obdurate, vexatious, and bad faith conduct, a finding adopted from the trial court, unconstitutionally infringes on Attorney Campbell's constitutional rights and lacks any evidentiary basis whatsoever where the trial court, sua sponte, and without notice or hearing, awarded counsel fees and found petitioner in contempt during oral argument and without prior notice or evidentiary hearing warranting the exercise of supervisory powers of the Pennsylvania Supreme Court.
Okay, so the sua sponte allegation was really against the trial court?
Yes.
And it was somehow transposed in the official question to reflect it was before the Superior Court? I think that's what happened. All right.
All I'm
okay.
saying is that...
We're going to figure it out.
To wrap up, however the court looks at it, there was notice and an opportunity to be heard by Mr. Campbell at both the trial level and the Superior Court level. He chose to abandon his client's appeal. He chose not to respond to the guardian's brief. He chose not to respond to the father's brief. And then he chose to make a representation to this court, by the way, that he had actually settled the case with the father, which was completely not factually true, but is in his brief, and then says, I don't even appeal the father's case. I'm only appealing the guardian's case. So we would ask that the court uphold and affirm the Superior Court, along with the order that was issued by the Superior Court awarding Attorney Coble counsel fees pursuant to Section 5744.
All right, thank you, Ms. Gelb. Yes, let's hear from counsel for father. Mr. Lynott.
Thank you. Justices, good afternoon. If you told me that navigating the Schuylkill was going to be easier than this argument today, I would have thought you were all crazy, but I'm going to try and untangle that knot that we've gotten ourselves into and go back to the basics.
No matter what, it's going to be easier than whatever you folks are going to do someday back in Lackawanna County on all this.
Judge, on that point, I'm the only one left. He's out, she's out, 2 judges are out. I just finished the custody trial in this case in the spring of 2025 with Mother's 5th attorney. The judge made the appropriate ruling. Mother appealed that and never followed through on the appeal. Last week we got an order from the Superior Court dismissing Mother's appeal. But I think that we're getting lost in the sauce, which is what's gone on throughout this case. And to answer some of your questions, why didn't we do things, or why did we do things? Because this is what we've dealt with. The question that was presented to this court is confusing. That's the game here. And my brief, if you look at my brief, I specifically argued that it wasn't sua sponte, that the Superior Court appropriately applied County of Fulton, but that what Attorney Gelb said. Both lawyers, and I wasn't there, I guess that's my pain for being stuck in it at this point, but I wasn't there back in April of 2023. Both lawyers on the record for father and the guardian made oral motions regarding attorney's fees being assessed upon Mr. Campbell, as well as his law firm, because members of his law firm entered their appearance in the case. That was then appealed to the Superior Court by both father and the guardian. I came into the case after the appeals were filed, but when the briefs were going through. But I think it's important, if I can go backwards to forwards for a second. And I got to tell you, I know more about vexatious, obdurate, and dilatory than I've ever learned in my life. It's scorched into my brain, unfortunately. But one of the questions the court asked, in Attorney Gelb's response to the petition for allowance of appeal, she did raise the waiver issue. I think it was paragraph 2.
I found it.
And then again, I went back, and here's what I submit to this court. This isn't just about a second page, 200-page, 57-count motion to remove the guardian ad litem. It's about the overall conduct. And when we go back to the definition of those 3 words, what happened? Mr. Campbell gets in the case. If you read that transcript, what does Judge Corbett say? I have a 2-year-old girl who hasn't seen her mother in 7 months. We don't move forward to move the case along to assist the mother or the child. We file a motion to get rid of the guardian. And then when that doesn't look like it's going, 2 days before the oral argument, we file a precipice for writ of summons on behalf of the minor child that the...
I just can interrupt for a moment, because this is not a trial court. All of this stuff you're talking about, was this not in front of Judge Corbett? Because I assume it was.
Yes.
And she made a discretionary decision, and she made Ms. Scotchlas liable for, then that went up on appeal, and the sua sponte thing aside, the issue is, basically, The issue in the Superior Court was reviewing that discretionary call by the judge. And in reviewing that discretion, the Superior Court somehow decided this was like County of Fulton and could be shared jointly and severally. And the question I think before us is that a lawful thing for the Superior Court to do without some independent fact-finding like we had in County of Fulton about Attorney Carroll?
And that's where I was going, Your Honor. I believe that the record reflects that fact-finding, that this, as you've all said, this is a simple custody case. This is not a difficult matter. The court had 4 days of testimony last year and resolved that. But it's what happened leading up. It's not just the second motion. It's the 2 days after entering his appearance, filing the second motion. It's filing the precipice for writ of summons on the doorstep of the argument. Additionally, in that transcript, you will see Mr. Campbell, and I want to clear this up for the court, and if I'm overstepping my bounds, I apologize. The contempt wasn't for filing the motion. The contempt was that he released a report to a so-called expert that there is a sealing order from the court, from Judge Munley, that was in effect, and he acknowledged that on the record.
Yeah, but counsel, this wasn't a contempt hearing. This was a remand for the imposition of attorney's fees against Mr. Campbell and his clients pursuant to Section 2503, vexatious, obdurate, dilatory behavior. It's a completely new paradigm. Shouldn't he and his employer have the right to defend or call witnesses or at least have some type of evidentiary hearing on those issues?
I'm sorry, Your Honor. I believe, Your Honor, again, I wasn't in the case at that point, but my record...
I understand that, and I understand where you're going, and I understand the emotions that are attendant to this particular case. But if it was you and one of your associates did something, wouldn't you want the opportunity to present evidence or a hearing in front of a judge or some kind of due process requirements?
And that's what I'm saying, judges. I believe that there was multiple motions that were scheduled for that argument on that day in April of 2023, including the contempt.
You're talking about something different than Justice Wecht mentioned. You're talking about the original flurry of motions that resulted in the April 18, 2023 hearing. Justice Wecht referring to what the Superior Court did, imposing liability against Attorney Campbell and his law firm. At that point, aren't they entitled to an evidentiary hearing?
Again, Judge, what I believe the record reflected from that April hearing is, first of all, that motion was part of the April hearing. Second of all, there was argument on the issue, and there was some acquiescence and acknowledgement by Attorney Campbell of what he did, and then the court asked counsel, as Attorney Gelb said, unfortunately there wasn't a hearing. However, they were asked to brief the issue, and again, I think we both cited that.
We're getting lost again. The original contempt citation that imposed the attorney's fees, the request for attorney's fees, that was imposed by the trial judge against who? Against what entity?
Scotchlas.
Correct. Then it goes up on appeal, right?
Yes, sir.
Now, we can agree that Scotchlas is different than Campbell, and Campbell's different from his employer, the Rothenberg firm, right?
Yes, sir.
That case goes up to the Superior Court. Judge Stevens writes an opinion saying it's going back down to the trial court for a determination of or for attorney's fees against Campbell and his employer. But there was no hearing at that point, right?
There was not, but I believe in front of the trial court, the issue was raised, it was argued on the briefs, and the record showed the conduct that gave the Superior Court.
Yeah, but counsel, that's where you're going down the path of making this case a little bit more confusing. When the trial court made the decision to deny the request for an attorney's fees apportionment and to just assess attorney's fees against the party, and it goes up on appeal, when the Superior Court's reviewing something for an abuse of discretion, they don't look for reasons in the record to rule the other way. They look for reasons in the record to support what the trial court did. The trial court didn't issue an opinion with fact-finding, right? She just issued an order.
No, there was an opinion.
And the opinion found certain facts as to misconduct by?
Again, I don't recall it off the top of my head, but I believe it did.
But not by the attorney. See, that's the problem is when there's an abuse of discretion is in a very deferential standard of review, right?
Yes, sir.
So you look for any reason in the record that would support what the trial court did. It just seems to me that you're asking us to look for reasons in the record to support what the Superior Court did.
Well, And again, I believe, I'm not going to recall it all, I apologize, but I believe that the opinion does address it, as well as the record in the trial court regarding the reasoning why the request was made for Attorney Campbell and his law firm.
Counsel, right here,
Sorry.
if I could summarize what I think the argument is on the abuse of discretion as you're stating it is, it was an abuse of discretion in light of the overwhelming evidence of record as reflected in the, whatever the argument session was, the date of the arguments, all of the facts asserted therein. It was an abuse of discretion to not award attorney's fees against both the mother and attorney.
That's exactly how I was going to say it, Your Honor.
Okay.
And with respect to the proceedings before the trial court, did Judge Corbett give counsel for appellant the opportunity to request an evidentiary hearing?
I don't believe so, and I believe that's what I was looking at when Attorney Gelb was arguing. Attorney Campbell actually asked to argue, and that's in that transcript from that day.
He asked for oral argument.
Asked for oral argument,
Did
yeah.
not ask for a hearing.
Never said I wanted a hearing, said I have several arguments to make. And so, but to go back to your point, Justice, is when we define the conduct, there was nothing related to the custody case being done on his watch. And
There's also nothing based upon everything that you asserted to us that the client could have done without the participation of the attorney.
Yes, and that's why I said the dilatory, the obdurate, the vexatious, everything, and even as we come here today, I thought it was interesting that Mr. Campbell noted the well-written opinion of Justice Wecht, which I also noted, but
I didn't think so, but
he in his brief said that your opinion sounded like a one-sided sentencing colloquy. So, I mean, and he referred to, I believe it was Justice Doherty's concurring opinion as somewhat indignant. So my point in all of this is when you go from Judge Corbett to the Superior Court to this court, like Attorney Gelb said, he puts in a court-filed document that he's amicably resolved the case. Listen, if I had my 8950 for my client, I wouldn't have sat here all day and gone through this. And
this case certainly is not about Mr. Campbell's eligibility for, paragon of the law of the year. The case is about whether the Superior Court committed reversible error by reversing a discretionary call of the trial court, and whether Fulton County is anything like this case in terms of its posture.
other than the fact-finding, as we call it, that was conducted in Fulton County by this court, if you look at Attorney Carroll and you look at Attorney Campbell, I believe that their conduct and their actions are completely similar. And as you both stated in your opinion, in your concurring opinion, to paraphrase, if we don't have rules, it's chaos.
That may be very well true, but one thing that was missing here was all the work that Judge Cohn-Jubileer did in the Fulton County case.
Correct. And it made it very difficult to read that opinion when it was stuck in before the concurrences. But yes, I believe and I submit to this court that the record is replete from Judge Corbett to this court as to why it is not reversible error and that they made the correct decision. Because again,
whether or not it was lined up correctly with the Fulton case, your position is the Superior Court did the right thing.
yes, it is, Judge.
Okay. Anything else?
Thankfully, no.
Thank you very much. Thank you all.
Thank you.
Mr. Minner, would you call the final case?
PASSHE, Kutztown University, PASSHE Officers Association, representing the Officers Association.
What's that?
Yeah.
Oh, yeah.
In this case, a police officer employed by Kutztown University was terminated for posting various objectionable matters on Facebook, including those alleged to be racist, Islamophobic, and seemingly justifying excessive police force. Pursuant to a collective bargaining agreement, the officers' union grieved the termination. An arbitrator resolved the dispute by sustaining the grievance and ordering that the officer be reinstated with full back pay, benefits, and seniority. The university appealed the arbitrator's award to the Commonwealth Court, which upheld the award under its deferential standard of review known as the essence test. However, in considering the public policy exception to the essence test, the court determined that the award, in imposing no sanction for the officer's misconduct, violated a dominant public policy prohibiting discrimination, and thus the court vacated the arbitrator's award. We granted Allocott to consider the proper remedy after an arbitration award has been vacated under the public policy exception to the essence test, whether to vacate the award and allow the university's termination to stand, or whether the reviewing court should remand the matter to the arbitrator for a new award conforming to the court's order. Good afternoon.
Good afternoon, Chief Justice and other justices of this court, and may it please the court. My name is Vlad Kochka. I'm with the law firm of Spear Wilderman, and I represent the appellant, the PASSHE Officers Association in this case.
And we're going to end with a calm argument with crystal clear issues, right?
No, I thought I was going to yell and be confusing. Okay. Before I address the issue of this case, let me just help the court narrow down the issue of this case. Let me just quickly discuss what it's not about. It's not about whether the Facebook posts in this case were offensive. They were. And it's not about whether the court correctly decided that the arbitrator's decision should be unenforceable under the public policy exception. The sole issue in this case is, after the Commonwealth Court decides that an arbitrator's award should not be enforceable, what should happen next? In this case, after vacating the award, the Commonwealth Court went beyond its jurisdiction and declined to remand the case back to the arbitrator. Instead, it held that the employer's decision should, quote, stand. However, that is clearly the arbitrator's role. Really quick, let's discuss the arbitrator's role and the Commonwealth Court's role. They have played two distinct roles. The arbitrator's role, the issue before him, was to decide whether the employer violated the parties' collective bargaining agreement. The issue before him was whether the employer's termination of the officer violated the just cause provision, and if so, what should a remedy be? The issue before the Commonwealth Court on a petition for review is whether the arbitrator's decision should stand. And the Commonwealth Court reviews the arbitrator's decision, not the employer's decision. And it's the Commonwealth Court's decision to decide whether the arbitrator's award should stand. This court has stressed over and over again that the Commonwealth Court should not step into the arbitrator's shoes and decide the underlying issue about whether the employer's decision to terminate or issue some other discipline should stand. That is clearly for the arbitrator's role.
Can I stop you there?
Yes.
The arbitrator's role is to decide, as you stated in this case, whether or not the decision to terminate violated the CBA.
That is correct.
Okay. And the arbitrator therefore interpreted the CBA within the four corners of that document, which is what the arbitrator can do, correct?
That is correct.
Okay, so on appeal, the Commonwealth Court says it's against public policy.
Yes.
For that arbitration, that CBA to allow the it's against the public policy of this Commonwealth to not allow the employer to terminate in this matter. Isn't that the end of the case? What are you suggesting? We send it back to the arbitrator so they could reinterpret the contract with information outside of the four corners of it?
Let me just specify. I think what the Commonwealth Court specifically, the two issues before the arbitrator was, one, does the employer's decision violate the just cause provision, and if so, what should be the remedy? And the remedy was give him his job back with full back pay. I think what the Commonwealth Court was deciding was the remedy is what violates public policy.
No. The question was, does the arbitration, does the CBA allow the termination for just cause under these circumstances? Arbitrator says no. The question at issue before the arbitrator was whether or not the employee could be terminated.
That is correct. That whether the arbitrator found a just cause was lacking, so to the employer's decision could not stand.
Under the CBA.
Under the CBA, yes.
Correct.
That is correct.
Arbitrator says CBA does not allow for termination under these circumstances. Commonwealth Court says it's against public policy for CBA to thus hold. Therefore, the employer could terminate under these circumstances. Isn't that the end of the case?
No, because I don't think, just to clarify, I respectfully disagree. I think that the Commonwealth Court, for the Commonwealth Court's jurisdiction ended upon finding that the arbitrator's decision violated public policy. And the Commonwealth Court, I don't interpret the Commonwealth.
See, it's what the arbitrator decided is that the CBA did not permit termination.
That is correct, under these particular circumstances.
And what was at issue here was whether or not the employer here could terminate under these circumstances. The Commonwealth Court said the CBA cannot preclude termination under these circumstances based upon public policy. Therefore, the action that the employer took was just cause.
I think I respectfully interpret the Commonwealth Court's decision a little bit differently, if I may. I think what the Commonwealth Court held was the grievance reinstatement with full back pay, the grievance reinstatement with no punishment is what violated public policy. The arbitrator's decision to give him no discipline.
See, but that actually wasn't what was before the arbitrator. What was before the arbitrator was whether or not the employer could terminate the employee under these circumstances. The arbitrator said it doesn't support just cause. No. He can't be terminated.
That is correct.
I mean, the only thing that was issue in this case was whether or not this employee could be terminated under the collective bargaining agreement. That's all the arbitrator could decide.
Yes, that was the issue before the arbitrator. And the distinctive issue before the Commonwealth Court was whether the arbitrator's decision to bring this guy back with no punishment violated public policy. And the Commonwealth Court decided no punishment in this case. Not specifically, the court was citing this court's decision in Philadelphia Housing Authority, where the Commonwealth Court said the employer can't be not allowed to issue decisive action when it comes to these type of conduct, regardless of whether it was just cause.
See, but what you're suggesting that we need to do is send it back to the arbitrator, who would have to essentially disavow the previous interpretation of the CBA, which he cannot do. I mean, the arbitrator can't take into account public policy. The arbitrator can only look at the four corners of the agreement. The arbitrator did that. The arbitrator said within the four corners of this agreement, this employee can't be terminated.
I have to specifically disagree with that, Your Honor.
Okay.
I think what the appellant is in fact arguing is that the arbitrator should and must consider public policy when issuing his decisions. And I believe the appellee in this case is saying that the arbitrator incorrectly did not apply the public policy when issuing his decision. And are you asking what is left for the arbitrator to do in this case?
Yeah, after the Commonwealth Court has said termination is allowable.
The Commonwealth Court said...
And that's all, I mean, that's what was at issue.
Okay.
I mean, could this employee be terminated?
So I don't think the Commonwealth Court did not hold that termination was required in this case. I don't read the Commonwealth Court's decision like that. And if this court interprets it like that, then it should find that the Commonwealth Court went beyond its jurisdiction to decide that termination is the only outcome in this case. I think what the arbitrator, if this court if the court orders the Commonwealth to order remand, 2 steps, what the arbitrator would have to do is, one, he would have to issue a new decision in conformity with the Commonwealth Court's opinion that would comply with public policy. What could that decision be? For example, the arbitrator could decide a very long suspension is decisive action. A long suspension punishes the grievant enough and allows the employer to uphold Title VII and other anti-discrimination laws. That is an issue that's not been decided. The Commonwealth Court only had the arbitrator's decision granting the grievant reinstatement and full back pay. That's all it had.
Could you cite to any case in which there was a remand to an arbitrator for reasons other than further development of the facts of the underlying dispute?
So I am asking the court to recognize that under 903 para, that is a procedure that Commonwealth courts should adopt. Just like when this court decided to adopt the essence test and the public policy test, I'm asking the court to recognize that under Section 903 of para, Section 903 of para mandates arbitration.
And that was the position of Justice Seamus McCaffrey and Justice Max Baer in Philadelphia Housing and Concurrence.
Correct.
Yes, that is correct.
Justice McCaffrey wrote, the remedy would be to remand to the arbitrator to reconsider the award in light of the articulated violation. Anything more intrudes upon the other public policy against judicial interference in arbitration awards made pursuant to para.
That is correct.
See, and this may be a disagreement among the justices, and we'll have to hash that out, but the public policy exception looks at the award. The award, not specific findings, but the actual result, the award that's issued. I'm not aware of any case where we've said, I think we've said fairly clearly that if a court does not have the authority to alter or change an arbitrator's interpretation of contract. That's not part of the scope of review that a court can look at. But the public policy may say that the actual award, for example, reinstatement or even termination, maybe, I guess under the theory, a termination could be a violation of public policy. I can't imagine that would ever be, but it's possible. But you look at the award result. Since this court adopted the public policy exception, has it ever been used to vitiate, in the name of public policy, an arbitrator's interpretation of the CBA?
I'm sorry, Your Honor, I'm not sure if I understand.
Since the court adopted the public policy exception, has any court used it to override or vitiate the arbitrator's construction of the CBA?
None come to mind at current.
The only time it was ever used was to undo the award.
Just to vacate. The Commonwealth Court has the authority to review and vacate the award. It's not then supposed to step into the arbitrator's shoes and decide what was the proper outcome. And let's
Counsel, then I'm kind of lost. You just got done saying that the arbitrator, part of the arbitrator's responsibility is to consider public policy.
That is correct.
Theoretically, in this case, they considered public policy and found that there was no public policy violation. That was appealed to the Commonwealth Court. Commonwealth Court said, no, there was a public policy violation. So what are you asking us to do? Send it back to the arbitrator to do what?
The arbitrator...
To find that the Commonwealth Court was right and he was wrong and refashion a remedy?
Okay. Well, of course, on remand, anytime a court remands, the lower tribunal has to find that the reviewing court was right, and it has to issue a new award.
Not according to what Justice Brobson just said.
What?
We can't vitiate the findings of the arbitrator.
No. What I said was on what the CBA means. But these arbitrations are not that disjunctive. The issue was not just his termination that was grieved. It was whether he could, under the CBA, be punished at all, whether it was sanctionable conduct, not just the result, but whether they had just cause to punish him, one, and then, if they did, whether the termination was appropriate or whether something else should have happened.
Yes, well, I think you switched around the question. The question is whether there was just cause, and if no just cause, what should be the remedy for that contract violation?
Well, you're making my point.
Yeah.
Is these things are grieved in a way that you leave to the arbitrator not only the question of whether there was just cause to punish, but also to the arbitrator whether there was just cause to punish by way of termination.
That is correct.
And here, the arbitrator said you had just cause to that the arbitrator here said there was no just cause to punish at all.
That's correct.
And reinstated him. And what the Commonwealth Court, as I understand, said, oh no, you, arbitrator, in your award found he engaged in all of this conduct. That finding in that award to reinstate him with back pay without any kind of punishment is a violation of public policy. That's what the Commonwealth Court said.
That is correct.
Okay.
Yeah, and now before us, we know that is how that there could be no enforceable award where the employer has to bring him back with no discipline. We know that now, but what we don't know is whether there could be some other discipline short of termination that could meet the Commonwealth Court's common policy concerns.
Could the Commonwealth Court, under the public policy exception, have looked at this case, and can we look at this case and say, based on the findings of the arbitrator, based on the conduct, based on the dominant public policy that would address this conduct, no punishment short of termination could satisfy public policy?
I don't think you could, because that would be literally you stepping into the arbitrator's shoes. That would be literally you deciding whether the employer's decision to terminate him should stand.
We can play whack-a-mole and keep sending it down for resentencing, basically, as if it were a criminal case, as if there was an illegal sentence. We can keep playing whack-a-mole and sending it down for a new sentence until public policy is satisfied.
That is correct, Your Honor. And you might ask, well, why would you do that? Well, one, because 903 para mandates that disputes between parties is resolved by arbitration. Let's realize that there is no binding arbitration decision today resolving the parties' dispute. Right. And that is against para 903. We can't allow that to stand. Second of all, it's not unusual for reviewing courts to send things back to the lower courts. I mean, in Westmoreland, this court remanded twice to the Commonwealth Court. So remand and sometimes reappeal, it happens, but that doesn't mean that Section 903 of para doesn't need to be respected. And finally, this court has stated over and over again that speculation that an arbitrator might issue an award that violates public policy is not a reason to not respect the arbitrator's jurisdiction.
Thank you.
You're welcome. And again, the employer.
That was a hopeful thank you that you were done. But
oh, I'm sorry. I got a little. If you want me to end, I can end. But I can. Can I just
Why don't you sum up?
Okay. Section 903 of para mandates that disputes between parties to a collective bargaining agreement is resolved by arbitration. There's no exception for any cases where there's a lot of controversy or where agreement engages in a lot of misconduct. Every single case where if it's a matter of contract interpretation must be decided by an arbitrator. And this court has over and over and over again told the Commonwealth Court that issues involving disputes between parties to a collective bargaining agreement need to be resolved by an arbitrator, not the court. And again, and this court has repeatedly said it doesn't want litigants to use the public policy exception to get two bites of the apple. First, you decide before the arbitrator, and then you're going to decide before the court. No. Therefore, what this court needs to do is remand this matter back to the arbitrator to tell litigants that arbitrators are the ones that are going to be resolving disputes between parties to a collective bargaining agreement, not the courts. Thank you.
All right, thank you. Let's hear from Mr. Patchen.
Thank you. Good afternoon, Chief Justice, and may it please the Court. My name is Ben Patchen. I represent the appellee of the Pennsylvania State System of Higher Education, Kutztown University. The appellant's position in this case is asking this court to adopt a rule that does not exist in para, does not exist in this court's precedent, and would weaken, if not eliminate, the public policy exception that was adopted in this court 20 years ago.
Would you pull the microphone up, please?
Sorry, I was striving to be the last case. I was not that loud.
No, you know what? You're taller, so keep it coming. Thank you.
Thank you. The Commonwealth Court in this case correctly vacated the award after concluding that reinstating this police officer after he made these outrageous Facebook posts that denigrated and attacked the same community that he swore an oath to protect violated the public policy prohibiting discrimination.
Is that what they said? Or did they say reinstating without any punishment?
Well, that was referenced explicitly,
Yeah,
but they also...
They didn't just say reinstating. They said reinstating without any punishment.
Correct. And they also cited this court's decision in PHA, which was just brought up, about the termination decision was not required, but the employer was permitted to terminate under these facts. And that's where we are in this case. There are no facts. There's nothing to go back to the arbitrator. I think you used the word whack-a-mole for what would happen here. I was thinking more of ping-pong.
But Philadelphia Housing did not say that the public policy required termination in every case. So why isn't the view of Justices McCaffrey and Baer correct that there has to be an arbitration under the correct rubric? So the correct rubric now articulated by the Commonwealth Court is that this falls under the public policy, and therefore there has to be an opportunity for the parties to have the arbitration hearing in front of the arbitrator under that rubric so that sanctions can be considered, ranging from X to Z or whatever.
Well,
under that new proper paradigm rather than having no proper arbitration at all.
Well, there was an arbitration. I understand there was no arbitration decision because any arbitration decision based off these facts, and quite frankly, taking a step back, when we're looking at this public policy exception, this was put into place 20 years ago. I was able to find only 6 cases where courts actually vacated an award. And my position is that once the court does vacate an award under this public policy exception, the only possible answer is termination.
But I'm not sure that that's correct, because you're asking an appellate court to step into the arbitrator's shoes. What the arbitrator and the court do are different things. The arbitrator does the grievance thing, and the court does this public policy thing. And the court, that's the only way that, that displays the essence test. So now it goes back under the proper rubric, and properly governed by the law, the arbitrator conducts a proper proceeding. Isn't that the more restrained approach?
Well, no, I don't think it is under this exception. And para obviously favors arbitration, and we want arbitrators to resolve disputes. There's no argument about that for me. But that doesn't mean they have the absolute authority and that they're prohibited from any appeals. And this was why we came up with this, why this court came up with this in Westmoreland, was that there is a policy favoring arbitration and favoring disputes. And that's how they came up with this public policy exception that has been so rarely been used in practice because of the policy favoring arbitration.
How is PURA advanced by the absence of a final arbitration award that complies with public policy?
Well, I would say there is no award that would comply with public policy other than termination. So maybe my argument...
But that's not what the Commonwealth said, and I agree there's probably room, in our public policy jurisprudence for us to, and for any court to say for that matter, that given the arbitrator's findings of misconduct, any discipline short of termination for this conduct would violate public policy. I mean, we created the public policy exception. I think we could do that. That, in and of itself, though, presumes that there could be no other remedy here. And I think the Commonwealth Court didn't presume that. I think the Commonwealth Court, in its judgment, said, yeah, putting this guy back as if he didn't engage in the conduct that you found he engaged in with back pay is a violation of public policy. But the Commonwealth Court didn't say anything short of termination is a violation of public policy. I mean, if he had been suspended for 6 months without pay and ordered to go through counseling and ordered to buy the offended people savings bonds for their children, I don't know, you're saying that would still violate public policy?
That would still, and that's what Westmoreland itself, the employee was reinstated with no back pay, and I think it was counseling or some other type of training, and that they found that that still violated public policy. And that's my position in this case, that there is no penalty other than termination for these egregious facts. And I don't know how much we want to dive into them, but that's my position, certainly in this case, and in all of the public policy.
So that makes, that virtually assures that every arbitration decision that provides some form of penalty short of termination gets appealed, and there will be a de novo consideration by the Commonwealth Court or the Common Pleas Court of what that public policy is that's offended and whether anything short of termination can vindicate it.
Well, I don't think I'm asking to change anything from what's happening right now. Is that once we have found that it violated public policy, which again, 6 times in 20 years, it doesn't happen very often. So I don't think anything's changing other than in these, I mean, literally less than 0.1% of cases where we have an award that's so egregious that violates public policy. And in those type of cases, yes, the answer is there is no penalty other than termination. And there is nothing else, and if this did go back to the arbitrator, and he did, whether, I don't know what he would do, whether it's a 1-day suspension, whether he said...
terminate.
He could terminate him, or whether he could say reinstate with no back pay, and it's been so long, I agree that would be a substantial penalty, but I would still be here saying the same thing I'm saying right now, is that under these facts, it violates public policy to prohibit an employer, just like we talked about PHA, to prohibit an employer from terminating somebody under these facts.
Doesn't there demand that the parties have an opportunity to have that grievance hearing under the proper legal rubric on a remand?
No.
Because you're imposing, you want to impose a blanket rule in every case where the public policy exception has been held.
Well, just to be clear, I want to follow what we've done. For the 6 times that has happened, the award is vacated. I'm not asking to change anything. But PARA does not prohibit appellate review, which I think would happen. I mean, it would be, they would all go back, and I guess I can't predict what would happen at the arbitration, but we'd be in this ping pong back and forth, whereas one day...
And we would, or probably would, because if it goes back, and let's say that the award is go to counseling for a month.
I would be right back. I mean, I would go even further that even if the award said no back pay and we're 4 years later, that would still violate public policy to force the university to employ this person as a police officer. That would violate public policy.
Which is why, if the CBA does not prohibit the termination of the employee based upon public policy reasons and the employee was terminated, that's the end of the case.
Correct.
Or if it was any other, there could be a less egregious action taken by the employer, but if it violates if it is found to violate public policy, case is over.
I would agree with that. I would just note that, I kicked this around too. I don't know that you could make a legitimate public policy argument if you've determined the appropriate penalty for that conduct is, let's just say, a 5-day suspension.
Well, and that may well be true. I guess part of the issue in this case is whether that's an appropriate judgment for you or, frankly, for us to make up here rather than in a proper arbitration hearing under the new adjudication.
But I guess I don't understand what the new adjudication hearing is.
It's the determination that the public policy exception applies and the arbitration proceeding has to go on under that paradigm.
And when you say, I would interpret I don't think there's any need for any, quote, hearing. If it were to get remanded under what we're discussing, I think it would only be remanded for a penalty or.
You've already, yeah, right, and you've already decided that has to be termination. You've decided that.
Well, the university has decided that.
Right, but there should be an opportunity. There should be an opportunity, at least if McCaffrey and Bear were correct in their concurrence, for a hearing. I'm just repeating myself now, so I'm going to stop.
But wasn't the finding below essentially by the arbitrator that this conduct did not support just cause for termination under the CBA? That's
yes.
He said there's no just cause. I mean, we're sending it back not only to make a new award, but to essentially reinterpret the CBA.
Right, and I don't. That's my point. I think that's the point. That's the point I'm making.
Is that consistent with 903? It says in the beginning, arbitration of disputes or grievances arising out of the interpretation of the provision of the collective bargaining agreement is mandatory. The procedure to be adopted is a proper subject of bargaining with the proviso that the final step shall provide for a binding decision by an arbitrator.
Right, and that language has always been interpreted to provide for some type of judicial rule, just like with the other statutes for arbitration that even go further with language about no appeals, that they've all been interpreted.
But if you're letting the Commonwealth Court be the final word on what happens to that employee, then the arbitrator and the CAB isn't the final step in the process.
Well, it's the final step in the arbitration process, but it's a review standard that in only 6 times in 20 years we've met this standard. We being an employer that has gone this far, and there hasn't been a quote a final and binding. And then I think maybe what my stronger argument in response to these questions is that in this case it's futile to send to remand it under these facts because there is no other award that would not violate public policy.
That's the question. What is the dominant public policy that demands termination in this situation? What is the dominant public policy that demands termination is the only thing that can happen when the conduct that the arbitrator found here occurs?
I have a two-part answer to your question. I don't think there's any statutes that say for any type of conduct, if you do this, you're fired.
No, you have to be fired.
You have to be fired. I don't think there's any statutes that say that for any conduct. I'm not aware of any.
That's significant, isn't it?
I agree, but my second point in response to that is there are discrimination statutes that do require an investigation.
No question.
That do require appropriate action based off the investigation. And my response to you would be that the only appropriate action here, as we're required to investigate an issue, would be termination. And that's the public policy. The public policy prohibits discrimination. It doesn't say you have to fire someone for any type of conduct. I'm not aware of any.
But so every kind of conduct that rises to the level of workplace discrimination demands termination.
Well, no, because that's too fact specific. I mean, that's why we've only had 6 cases. I think that's too broad of a scope here. You know,
that's the public policy test. The public policy test is the award, meaning his reinstatement with back pay. It violates a public policy, that there is a public policy that prevents him under these circumstances as found from the arbitrator from being reinstated without any penalty.
Correct.
I think the Commonwealth Court said, yeah, there's a public policy that says he can't be reinstated with back pay without any penalty.
But isn't that because of the egregiousness of the offenses? I mean, it wouldn't be because any evidence of discrimination would rise to that level.
And that was my response, is that these are so fact-specific that there's a difference between one offhand comment, not to say that that's okay, but one offhand comment versus physical inappropriate touching.
But we would have to say that as a court. We would have to say there's no legislative dominant public policy that, as you acknowledge. We would have to decide in our judgment, or the Commonwealth Court would have to decide in its judgment, contra to the arbitrator, that we believe the public policy of the Commonwealth, based on the conduct here, demands termination. We'd have to say that.
Well, I think we have done that for 20 years. And when we say demands termination, I think it's more along the line of that the PHA case. And the quote that was referenced here is that an employer cannot be precluded under these circumstances. I think that's the response there. Because there is no, these cases are so fact specific and everyone's different, it would be impossible to just come up with a statute that said if you do this, you have to be fired from your job.
Exactly.
That's not realistic from any, I couldn't write a statute that could properly evaluate, especially sexual harassment or discrimination, that could come up with that.
Okay, are there any other questions for Mr. Patchett? No. Thank you very much.
Thank you.
Both. Mr. Minner, would you adjourn court for the day? Thank you.